Good morning, good morning, good morning. It is Tuesday. Ooh, it is a huge day in the trial world, okay? First of all, we have Sarah, I excel at everything, no malicious, not intentional Boone taking the stand in a trial that we have been waiting to start for 47 years. Let's just take a moment to take that in. She's finally going to testify. Okay. Then, as if that wasn't enough, previous texts that were not going to be allowed in the Leilani Simon trial, not only are they going to be let in, but the person who she was texting will be testifying. Red Craig, who is Leilani's connect, and her side piece is going to testify today at some point. This is crazy. That's right. Red Craig, he's going to testify. Whew. Then, last night, me and Alex Erickson, we went live together. We went over the calls from the El Paso County Jail that Letitia Stalk made during her time at the El Paso County Jail awaiting trial. So they were from March 2022, which is 1 month after Letitia changed her plea from not guilty to not guilty by reason of insanity. Okay, we played those calls. We had a hoot. If you missed it, please go over there and check it out. If one of the mods could drop Allie's link, it's in the Nightbot. Excuse me. Okay. Well, we had such a hoot that your girl overslept by like a lot. I normally set my alarm for 6:30 in the morning. I do not even recall the alarm going off, number one, or me turning it off, number two. So this morning has started out like a big number two. I've been rushing around. I'm all scattered. I'm all confused. It's a big, huge, yeah, that's how the day started. But let's talk about how after lunch started yesterday for Sarah Boone. Okay. So hang on, I got to share it. Oh, wait, I have to fix it. Un momentito. All right. So after lunch yesterday, the judge, let me just say this, Judge Kranick is incredibly patient, okay? But he suffers no nonsense at all, at any time, for any reason. And apparently, yesterday, during the morning session, there was some chitter chatter in the gallery. There was some cell phoning in the gallery, and there was some sort of outburst in the gallery. Now, I streamed the entire morning. I don't recall there being an outburst. I think that it might have taken place after they adjourned, because I didn't see what started this. Okay. So we're going to watch. I have the closed captions on. I have the audio boosted. Just watch.
All right. Thank you all for your patience. Ma'am in the back left, last row. Good afternoon. After conversing with the state and the defense, they've agreed and asked me to excuse you from this room. I understand that there may have been an outburst by you with courtroom personnel before the judge arrived on the bench this afternoon. If you would like to watch the trial, it is being streamed live. You can head to the 12th floor, get off the elevator, and head to the south side of the building. See the sign where it says Judge Michael Kranek, and it'll tell you which direction to go. You can pick up the phone, call my judicial assistant, Anita Barrios, and she can give you instructions on how to watch this trial virtually. Okay?
Okay, thank you so much.
Thank you, ma'am.
Well, I ain't probably doing it anyway. Okay, I bless you guys. I'm still the boss of the city, so we gotta work together and try to figure it out.
Thank you, ma'am.
And y'all heard what I said. Ms. Jones, you're fired. Have a good one.
Thank you. To restate the court's prior positions, if there's anyone going to have any outbursts or cannot control themselves, again, I'm going to ask you to remove yourselves at this time. State, are we ready to bring it?
Now, I have literally zero idea what she said. I caught a few of it, but overall, I didn't really understand because she's so far from the microphone for the court stream that I really can't understand what she said. I don't know if she was there because she was a supporter of Sarah Boone's or if she was not a supporter. I'm not exactly sure, but that happened. And then the day or the rest of the trial day proceeded. Okay, so yesterday, Detective Chelsea Kepsel was on the stand. At the end of court, after the jury had left, this happened. All right, so let me fast forward.
About the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face to face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, we'll be in recess for this evening. We will see you tomorrow at 9 a.m. And again, I thank you for your attention and your sacrifice in this matter.
Jury exit.
Y'all may be seated. State, anything else we need to discuss this evening?
I've received a motion from the defense that I guess they filed at 5:08 p.m. regarding the witness Pearl Walker to appear by Zoom. It is not something I can agree to, and I'm not sure if they're meeting for deposition or trial or both. It doesn't specify.
No, I talked to Ms. Walker's daughter, who is her caregiver, and they're going to have her down here at 6 o'clock at the state attorney's office for the deposition, and then they'll go from there. Kevin Beck's going to be handling the deposition. But she's outside the courtroom, Judge.
Okay. Specifically referring to a motion for witness to appear via Zoom filed October 21st, 2024 at 5:08 p.m. The court has reviewed it. We can address this tomorrow after you've had the opportunity to take the deposition.
I would just submit based on what we've just heard, she can appear in person because she has.
Is that your final position?
Yes, sir.
Okay.
I think it would be wise to ask her those kind of questions from the lawyer so they would be able to give a more detailed response about why she doesn't want to appear in court. But I understand their position.
Here's the problem that I have. The rule 3.116D requires or allows the court to have virtual testimony or remote testimony if all parties consent. And I'm not hearing consent on behalf of the state attorney's office. And in reviewing the other portions of that specific rule, it all follows if there's consent. So I can't allow your request based on the lack of consent between the parties. So for the record, the motion for witness to appear via Zoom filed today, October 21, 2024 is denied in accordance with Rule of Criminal Procedure 3.116, Section D, Paragraph 1.
Judge, and the only other thing is we're trying to logistically get our witnesses here. We got to fly one in, and of course, Ms. Walker and the experts. I'm just asking for what their plan is for their case for tomorrow.
Judge, we covered it up at the bench. I thought, this is our last witness. It's up to them on how long they cross her. I thought we anticipated Ms. Boone taking the stand at 10 a.m.
He mentioned 10:30.
And my understanding was that Mr. that Mr. Cacciatore had no further questions for Detective Kepsel, and that we would tender her for cross tomorrow morning at 9 a.m. Mr. Henderson had advised it would be 30 to 45 minutes. Taking the worst case scenario, that would be 9:45, built in 15 minutes for redirect. I don't know if it's going to take that long. We will then remove the jury. Once the state rests, we will address any motions. I will colloquy your client on a couple of different matters, and then I will turn it over to you. So I would say that a start time, a good range would be between 10 and 10:30. I hope we don't have the same delays we had this morning with access. It's Tuesday, not Monday. There may be less jurors, so it may allow better efficiency in moving our panel in. But as soon as the state rests, I intend on moving to motion, colloquying your client, and turning the ball over to you, sir, for you to call your first witness.
Prior to Sarah Boone testifying, I am going to want to view with her the suitcase in the back.
Understood? Okay. Anything else, state?
No, Your Honor.
Defense?
No, sir.
All right, we'll see you tomorrow morning at 9 a.m.
So there you have it. Okay. First of all, I don't really know who this witness is. Now, you think I would, as many times as I've been over this trial, I have, or all the, stuff in this case, but I don't know who this witness is that they're intending to bring. The defense is. I don't know who that is. Maybe at some point after the coffee and 5-hour energy have had time to merge and all the synapses start firing, perhaps then it'll come to me. I don't know, and I don't want to promise anything because I just don't know. Okay. Moving on to the second part of that. Mr. Owens, I watched you guys after lunch, at break, many times over the course of yesterday's testimony, and then, in between, up at the bench, having long discussions on what I can only imagine are various topics. However, one of those topics, it appears to me, is the schedule. Why is it that every single time there is some type of arrangement or agreement made, here you come way after the fact, way after the agreement has been made, asking questions? You know who you are, Mr. Owens, Esquire? You're that kid in the class who, after the teacher has given the instructions for homework and is about to dismiss the class, here you come with the question. And not one question, multiple questions, and a sermon. Not a sermon, a soliloquy. Here you come. You're that kid. Does Mr. J and Mr. Cacciatore, should they stop making oral arguments or having oral discussions with you? Do you need pictures? Do they need to draw you something? Do we need to get a sketch artist in there so that they can draw you what the plans and the schedules are so that you understand? Is that what needs to happen this morning? I'm over it. It's ridiculous. Every single time. It's a big fat waste of time. All right, let's get over here because they're starting. So now you guys know that Detective Kepsel is going to return to the stand. She's going to be on cross. Okay. Mr. Henderson, excuse me. will be doing the cross-examination. I'm going to say that it is going to be worst case scenario and will be 45 minutes of recross. And here's why. Even though we're at the start of the day and the defense has been apprised of what the schedule is and what's happening, when Detective Kepsler was called to the stand, Mr. Henderson over here, it's going to take him at least 2 to 3 minutes to realize it's his turn. So there's some delay there. Then there will be probably 1 to 2 questions, a pause for a while, followed by 4 or 5 more questions, and it'll go like that until we start to reach a point where it seems like the question portion is coming to an end. And when that happens, Mr. Henderson is going to say to the judge, Your Honor, may I briefly confer? I can't even talk, confer. Maybe I shouldn't be roasting anybody since my words are getting all tangled in my mouth. And then he'll go over there and he'll briefly confer with Mr. Owens for what I don't know. Because I feel like this is sort of a big deal. Detective Kepsel is one of the more important, substantial witnesses to take the stand. You'd think that they would be prepared. But maybe he just wants to double check. Okay. Maybe he's showing his work, like in math, when your teacher would have you show your work. They want you to show every step that you took to arrive at the answer, especially in algebra. Maybe that's what he's doing. I don't know. And then after conferring with Mr. Owens and probably Miss Boone, because it appears she's running the show, he'll say, No further questions, Your Honor. Now, I know a lot of people are concerned that that the state resting their case in chief. It's too soon. What are they doing? Okay. And you guys have questions. There is the national treasure, maybe natural disaster, both. Who knows? You like him. I love him. MK Lynn brushed her hair with a balloon this morning. Amen, MK Lynn. All right. Okay. I would not have selected that color outfit for her to wear if she's going to be the one taking the stand. But whatevs, what do I know? I'm just some chick on YouTube. Who knows? What do I know? Okay, so the concern you guys have. What we have to keep in mind is that the defense intends to use the battered spouse syndrome defense, right? But they haven't been allowed to use it as yet. So Sarah's got to testify, all right? Which means that moving forward, if Sarah testifies and there's no overt act testified to, the battered spouse syndrome defense is out the window. She must testify to an overt act. Okay. That's the first point. So let's entertain the 2 scenarios before we start. Let's say Sarah does testify to that overt act and the judge rules that they are now allowed to use the battered spouse syndrome defense. Okay. So the defense is going to put on Sarah, then they'll likely put on their expert witness, and then that'll go on like that, right? So what will the state do? The state will then put people on the stand after the defense rests, okay, their case in chief. Then the state will get an opportunity for a rebuttal case. And at that point, that is when they will put witnesses on the stand, like their expert witness who evaluated Sarah, other witnesses, etc., to rebut the battered spouse syndrome defense. Now, this is scenario number 2. After Sarah has taken the stand, should the judge decide that no overt act was testified to, and they don't allow the battered spouse syndrome defense to be used. Hold on a minute. Okay. Then the state has lost nothing, because a second-degree murder case without the complication of battered spouse syndrome defense, their case is very, very straightforward, and they've proven it. She's on video, all the things. So that is why they did it that way. All right, let's get into the testimony immediately.
Ma'am, good morning. Can you state your full name and date of birth for the record for us?
Sarah Boone, 10-10-7-7.
All right, Ms. Boone is seated at counsel's table wearing a black blazer and a dark blue blouse. She is in custody. However, she is not in any restraints, so we will continue to stand while the jury panel enters and exits. My understanding is that our panel is here this morning. State, do we have any housekeeping matters we need to address before we bring back in our panel?
Yes, sir. 3 discovery issues, and then I filed a motion late last night requesting an in-camera inquiry into a potential conflict of interest. I copied your JA.
I did review the motion.
Okay. The 3 discovery issues, please. One, on October 5th or October 4th, I believe the defense was provided with the body-worn camera 911 calls from the prior incidents, and there was a request made to tell us what, if anything, should be redacted from their point of view, so that we could either reach an agreement or use the court's resources to decide any conflicts in those issues. Yesterday morning was the first actual response I got from the defense team, and it was incomplete. It was about 3 of the 5 incidents. I do agree with 2 of the redactions, and we're getting those taken care of. But obviously, just like connecting to the court screen, it takes time, and I'm not the person that's going to be doing it. Somebody else in the office has to do it. The 3rd incident, I think we're still not on the same page as to what the state's planning on introduce. So I resent the email with the screenshots of what files the state plans on introducing to the defense team again this morning. I have not heard anything yet from the defense team about the 4th and 5th incident. I was told that Attorney Beck was going to handle it. It is now Tuesday, day 7 of trial, and he has not handled it. The second discovery issue is Friday, I was given a hard copy of the 119 pages of the second copy of the Winter Park Advent Health records.
10/18, October 18th. That would have been the preceding Friday.
I was given the hard copy after court at about 5:30, 5:45. I emailed the PDF of those records back to the defense as they requested. I put Bates numbers on them. I understand from court what pages they indicated that they want to use and what pages the court indicated should be included at the state's request, which is pages 26 and 48 out of the 111. I would just appreciate if I could get a copy of the intended exhibit as it shall be introduced to the court, so I can confirm those things ahead of time and not in court. And then the third thing is, I believe we had a discussion about the plethora of pages regarding the victims' hospital records, and that there was some sort of discussion we had that they were to narrow it down. And I have not been given any narrowed down version of that so that we can confirm we're on the same page or use the court's time if there's a conflict. Thank you.
Okay. Responses to the first discovery issue regarding body-worn camera and 911 calls is to the, my understanding, 5 prior incidents. Defense.
Judge, I can speak to 3 of them. There were 3 of them that I reviewed, and I believe I reviewed them on Sunday. I had made the decision for what I thought needed to be redacted. I think the first 2, if I remember correctly, I said that was fine. We didn't even have any redactions to it. I think it's 1 that I said redactions to, and I think the state agrees with that. The specific one that I didn't quite know, and I think that has to do with a body cam where it comes to, and I believe it's Ms. Mr. Torres's mother. I can't quite be for sure, but she's been asking questions.
I can't quite be sure. Isn't it your motion that you drafted? This was your department. Okay. So we have Mr. James Owens over here, Esquire, who is the kid who, after the teacher's given your homework assignment, decides they're going to raise and about to dismiss you, is going to raise their hand, ask questions, followed up with the soliloquy and more questions. And Mr. Henderson is the partner you get when when you have to do partner work, who doesn't do his homework, who doesn't do their part, and then shows up to class and is like, I don't know, I think, maybe. So now you start the presentation off with a 50 because your buddy over here didn't do his homework. How do you say you don't know?
And I think it's about, if I can recall correctly, about Mr. Torres's whereabouts at that time. I didn't know the relevance of that at that time, but that was the only part of that to let the state know. I just don't really know the relevance. It could come in.
No, Lisa, just me running my mouth.
But as to the other two, I think we were on page with. I had been out to the jail that day. It was late. Then I asked Mr. Beck to do the other two redactions, but I hadn't had the opportunity to talk to him about that since. So that's where we are there.
So is the third incident that the state has identified for which there's seemingly no responses to redaction, is that the body worn camera purportedly between law enforcement and Mr. Torres's mother?
That's
Yes, babe, Melissa Jade, this is today. And by the way, I want to thank you, Melissa, for sharing out the live. I appreciate that, babe.
Which I believe was June 15th of 2019. The state only indicated to them that we were intending to introduce one video file. It is not of the victim's mother. It is of them at Sarah Boone's house. And the objection to the files that they were objecting to, which we don't seek to introduce, just said ID. And I don't know that as a legally recognized objection. So
It's not. I'm not even a
I'm not
lawyer.
sure. I'm just trying to make sure we're all on the same page. We understand.
No, they're not on the same page as you, Mr. J. They're not even reading the same book as you. You're reading a book with no pictures. These bozos are over here reading Fun with Dick and Jane. Okay. The argument is from Mr. Henderson. Remember in the body worn camera footage with Kayla Rodriguez at the scene when Sarah starts her cry, not even crying, just sort of like whining and I'm scared of his family, right? That's what they're talking about outside of the house when she's talking to detectives and it's caught on Kayla Rodriguez's body worn cam. That's what they're talking about.
Which file the state wants to use regarding that third incident, because he's describing files the state does not intend to use. The first couple of incidents, we agree, there's a 911 call that seemingly cuts off into an OPD call at 3 minutes and 51 seconds. We're cutting that to the end. The second one, Ms. Boone at like 3 minutes and 43 seconds indicates that she had been arrested prior. So we cut that out at we're going to cut that out at that cat's out of the bag. So what we're looking for now is just making sure we're all on the same page about the third incident. I sent screenshots. There's a tool called Snipping Tool in Windows. I literally create a rectangle around the files that I'm intending to use, their file size, and the folder that includes the OCSO agency case number incident, so we can be as crystal clear as possible. And I'm still getting objections about things we don't want to introduce on that incident, and I've gotten no response with the fourth and fifth incidents.
Bless Mr.
Addressing
J.
The third incident is the specific portions of the June 15, 2019 incident, seemingly the body-worn camera that you're making reference to, Mr. Henderson, the state has no intention of utilizing.
Yes, sir. And Judge, it's a lot, so if I could have one more.
Sure.
To isolate which incident it is. That's not the one. I understand. My understanding is the state is talking about the third incident. That would be June 18th.
Here's the problem. I sent these pictures over with the OCSO case number, and then I get a response based on incident dates. So we have to kind of cross-reference. So you can just make the record entirely clear. OCSO incident 18-067501. There was no 911 calls and apparently no objection. So they have no redactions requested for that 2018 case. Then the next response was 6/15/2019 case. And that, for the record, is OCSO 19-054917. Their request on that one was the 911 call that we just discussed, indicating that at 3:51, well, I had to find it, 3:51, it turns into another case, and to redact that to the end. We agreed. Video 3 in that file, again, no file name, indicates at 9:40 to 9:43, there's a redact request with previous arrest. The state agrees to that. We heard her quickly say that at 9:43, and we will get that taken care of. Then their next response was 6/18/2019 case, which I had to cross-reference back to show that it is OCSO 19-055572. And in that particular case, what I sent them was a screenshot that includes the OCSO case number 19-055572, and it indicates there is an intent by the state to introduce 2 911 calls and 1 video file labeled axon_flex_2_video _2019-06-18_1330. My response that I received from them was video 3 in file, 2 minutes 7 seconds to 2 minutes 18 seconds paren ID, and then video 4 in file, 2 minutes and 4 seconds to 2 minutes and 16 seconds paren ID. So my confusion lies in I did not indicate 3 or 4 files. It was just 1 file. And then again, with the other 2.
I don't want to address 4 and 5 yet.
Okay.
It's my understanding there's no response. We'll address that momentarily. Responses to the clarification as to what it is the state seeks for incident 3.
No redaction.
Okay, all right. With regard to incidents 4 and 5, Mr. J, could you place on the record what it is specifically as to those incidents the state may be seeking to introduce?
Yes, sir. So what we're calling incident number 4 should be OCSO 19-078009, August 28th, 2019. We indicated the desire to use axon_flex_2_video _2019-08-28_2024. And then at their request, they had desired to get photos of Ms. Boone's injuries from that case. There is a 19-page PDF file, which has pictures taken by law enforcement of her injuries. I don't see anything else in there. 1 picture of Mr. Torres, a couple pictures of Mr. Torres, but nothing that the state was objecting to. So that was at their request that they wanted photographs in. So that is incident 4, which is labeled OCSO 19-078009.
With regard to seemingly the body-worn camera that the state seeks to enter into evidence from August 28th, 2019, what say the defense?
John, I don't know about the state's position on this. There's a portion of this video at the very end that's very personal to the investigating officer that they may want to redact. We're not asking anything to redact.
Is the state seeking any redactions?
I'm just clarifying what their redaction requests are in that particular file.
Okay.
If they don't have any, then
So are there any redaction requests with regard to that particular file? Okay. I'm just keeping notes. Give me a moment, y'all. As to the 5th incident, Mr. J.
No redaction request, Your Honor. I do want to point out that we were apparently advised yesterday that the state was only going to use the 3rd video possibly. And so we haven't really spent a whole lot of time worrying about it since then.
Let me clarify as to what the 5th incident is, just so that we're all on the same playing field.
Judge, the 5th incident is OCSO 19-079759, and that was on September 4th of 2019. Within that screenshot that I sent to them, Friday and then resent it this morning. Was photographs of the defendant taken at that time at their request. Shows a cut in her ear. It's 3 photographs. Then there is also one body-worn camera labeled 1924755. Strike that. 192473549_GEN_INV, and then the 911 call from that incident.
Any redactions sought by the defense with regard to that specific body-worn camera or 911 call?
We're not necessarily seeking redaction, Your Honor. However, there are 2 separate videos. One seems to focus on Jorge Torres. One seems to focus on Ms. Boone. And there is clearly some redundancy. They're both body cams. One went upstairs where Mr. Torres was found hiding in the shower for bathroom. And so some of that's redundant, but there are actually 2 separate videos pursuant to the 5th.
Mr. J, are there 1 or 2 videos that the state's seeking?
There's one, the one that I listed, filing for non-court order.
Okay. Do you know if that's a... Bruce, can you find out what counsel's here for? Is that the video from the perspective of, as identified by Mr. Beck, one more geared towards Ms. Boone or one more geared towards Mr. Torres?
My interpretation of both of them is there's interactions with Ms. Boone, and then there's interactions with Mr. Torres upstairs after he's located.
Mr. Beck, the specific file number was identified. So just to confirm, no redactions? Okay, all right. So just as a recap, with regard to the first incident, the 911 call, the parties have agreed to redactions at the timestamp of 351 towards the end. With regard to the second incident, body-worn camera, a redaction from timestamp 940 to 943 has been agreed to. With regard to the June 15, 2019 incident, there are 2 911 calls and 1 body-worn camera sought by the state, to which the defense has no redactions. the August 28th, 2019 incident for which there is no redactions to the body-worn camera, but there is a 19-page PDF with photos that the defense intends to be included with that submittal, to which the state has no objection. As to the 5th event, 3 photos of the defendant, body-worn camera, and a 911 call for which there are no redactions. Does that clarify everything for the state?
Thank you.
Is there anything that I stated incorrectly, Mr. Beck, Mr. Henderson, or Mr. Owens?
No, you were.
Okay, thank you very much. Moving to the next issue with regard to the 119 pages from Winter Park. Defense, are you in a position to provide, I believe we discussed it either Friday or I think it was last week, we discussed it as to how it was culled down. Yes, because we had the Richardson hearing on Friday, how that list was culled down and the additional pages that the state was seeking. And then if they were able to find, I believe it was page 68, we would readdress that. Have you provided that finalized exhibit to the defense as to those specific Winter Park health records from the 119 pages that the defense may be seeking to enter into evidence?
I believe they've received everything from us, Your Honor. We identified those documents that were not specifically addressed by the defense. That the state wanted extension out of rule of completeness. I believe we're.
But my understanding from Mr. J was that they were looking for the tangible copy of what it is that you were actually looking to move in, those 12, 14, 15 pages. Okay, if you could provide that to them by noon, I would appreciate it.
I'm not sure if it's, that's what we're saying.
But if it's going to be moved into evidence, we have is it going to be moved in paper form, or is it going to be moved in digital by virtue of a CD?
We can get it, Judge. We'll work on it.
Okay, perfect. Just get it to the state. It doesn't have to be intangible. Just get them what it is that if it's an electronic format, that's fine. Just the state should be entitled to know what it is that y'all are intending to move out of those pages, just to confirm it. Lastly, with
The state has been looking for page 68
hospital records of
since
victims.
before the trial started.
I know there were conversations, discussions about that list being narrowed down. The state has advised that details as to those narrowed down records has not yet been provided. What say the defense?
The hospital records for the victim, Jorge Torres.
It's my understanding.
Oh my gosh. Will you guys please get your poop in a group? This is ridiculous.
We've yet to do that.
Okay.
We've yet to do that. Yet to
My
do that.
understanding is that the experts are potentially teed up to testify tomorrow. I don't recall if those records are a basis of the experts' opinions.
The second expert is not likely to testify until Thursday. She's testifying in Bay County tomorrow. I will be here Thursday. And I spoke with Dr. Brandon last night. He will be present tomorrow morning as soon as he gets here from Coral Gables.
Did either doctors Brannon or Harper rely on those medical records?
Dr. Harper did. It's in her deposition that was taken a couple of weeks ago. I think it was a question.
Ms. Perez, good morning. If you're here for pretrial, 19 Alpha, Judge Myers is covering. Okay, thank you. You may continue.
Dr. Julie Harper, I know she considered the records of Jorge Torres, and we took Dr. Harper's deposition, I believe, a couple of weeks ago. She was asked by the state.
Oh my gosh.
She relied upon, and she did indicate that. Are we going to use or attempt to introduce those records? We'll pare it down if you want.
Okay, you've got till
Okay, I'll
5
explain what's
p.m.
happening.
today to advise the state as to what.
Okay. So there was a discussion, a motions hearing that took place Monday, I believe it was. And essentially what happened is the defense wants to introduce these medical records of Jorge Torres. And the state, the totality of pages that they intended initially to introduce is 550 pages of medical records. It's the entire medical file from 2 incidents, one in 2017 and one in 2018. Okay. The one in 2017 is the one that was on Christmas. Jorge Torres put his fist through a plate glass window. And the second one is from 2018 when he got into a fight with one of his brothers and required facial reconstruction surgery. And the judge had already ruled that, the nurse's rounds notes and just, there's a lot of material in there that really isn't germane, that the nurses reports, the jury is just going to get lost in paperwork, and it's not really necessary for them to have all 550 pages, right? So the judge said, you're going to have to pare it down, okay? And so they've been talking about this since. That's not true. I believe the motions hearing that this was discussed was last week. Okay. So they've had over the weekend, all the things. All right. And they still haven't done it. And that's what they're discussing right now, is there's no reason for that. Now, the problem is they, initially, this could have all been first of all, it should have all been handled already. That's number one. However, Mr. Beckman said, oh, well, we're not going to, none of the experts relied on it. And then here comes Mr. Owens, Dr. Harper did. Okay. So now if Dr. Harper relied on George's medical records in any way, shape, or form to form her conclusion in the report, which she's going to testify to, they have to be admitted into evidence, which means the jury has to see them, but they must be pared down. That's the problem. 550 pages of extemporaneous material that will mean nothing to the jury. It's a lot of nurses' notes. It's a lot of medical terminology that really the jury's not going to understand. It's not really going to be, that part of it won't be testified to. What's important is the narrative, according to the defense. So it's, again, you have a whole team over there. Why didn't you give Sarah Boone the assignment? She doesn't have anything to do. And we watch her during the trial. She loves taking notes, writing notes, all the things. So, maybe give her the assignment.
Are you still satisfied with your lawyer's representation of you in this matter?
Absolutely.
Are you still on board with the strategy that they have employed in the use of your defense?
Yes.
All right, let's go ahead and stand and bring in our panel.
Good morning to everybody who's just coming in. What's going to happen is they're going to recall, they're bringing the jury in right now. They're going to recall Detective Kepsel to the stand. She is the lead homicide detective on this case. There will be cross-examination to start, potentially maybe some redirect. Then the state is expected to rest their case in chief. The jury will be dismissed. The judge will colloquy, colloquy Sarah Boone, which is essentially she's going to have to testify. So before she testifies, the judge needs to ask her some questions, like if she's on any medication, if she understands all the things, right? Then they will recall the jury back in. Okay. And the defense will begin, and Sarah Boone will be their first witness. That's the plan for this morning. So if you have anybody that has been following this case that wants to hear Sarah Boone testifying, let them know. She's testifying today, and the
State, do you
Ward
recognize
case
our
studies
jury?
is a place to watch.
Defense, do you recognize our jury?
Yes.
All right, everyone will be seated. Thank you. Members of our jury, good morning. Welcome back to 12 Alpha of the Orange County Courthouse. Thank you again for your time, your attention, and your sacrifice in this matter. Just by a show of hands, if you could confer that you complied with the court's instructions last night. The record will reflect all juror members have raised their hands. All right, State, if you could please recall Detective Kepsel.
State would call Detective Kepsel.
it amazes me how Sarah Boone is so capable of compartmentalizing all the things, because I got to be honest, Sarah Boone right about now, which she should be nervous as heck, but she's not. She's cooler than a cucumber in a bowl of hot sauce. And if you get that reference, you belong here.
PSEL.
Mr. Cacciatore, you may proceed.
Your Honor, we had tendered the witness to the defense.
Okay, thank you. Mr. Henderson, you may proceed with any cross-examination.
Literally, this might be the fastest that Mr. Henderson has ever in the history of this whole trial, all 3 days, approached the podium this quickly to cross-examine. Snuggie asks Jen Liu, is state allowed to call their own expert as rebuttal witnesses after the defense rests in Florida? Yes, there will be a rebuttal case. All of this hinges on Sarah Boone being allowed to use the battered spouse syndrome defense. And in order to do that, this Sarah Boone must testify. Okay. And not only must she testify, but she must testify specifically to the overt acts committed by Jorge Torres Jr. that caused her to have to trigger a PTSD response, which is the battered spouse syndrome. Okay. She must testify to that. So that is why the state is going to rest what seems like early, because that defense hasn't been allowed yet. So there's no reason for them to put their experts on at this time. They will in their rebuttal case. All right, here we go.
Good morning, ma'am.
Good morning.
Now, it's my understanding that on February 24th of 2020, you responded to this crime scene. Is that correct?
Yes.
Were you the first officer to respond to the crime scene?
No.
So there were other officers who were there prior to you arriving?
Well, if she was not the first, then yes.
Were you the first
Oh my God.
detective to respond to the crime scene?
Myself and my partner, we all arrived at the same time because we left from the same location at the same time.
Okay, and who is your partner now?
Detective Scott Lowen.
And throughout the whole time, you and Detective Lowen worked on this case together, is that correct?
Yes, he assisted me with this case.
Now, when you arrived on the 24th, approximately how many other officers were there?
Including like deputy sheriffs, like in uniform?
Yes, ma'am.
Yes. Oh, approximately 4, maybe, I would assume.
Had it been designated a crime scene at that time, and had tape or security measures been taken to protect the scene?
Yes, they had.
So that had already been done by the time that you arrived, is that correct?
Yes, that's correct.
Okay. Now, in the investigation, one of your, or what you're trying to accomplish in the investigation is basically get a basics of what took place. Would you agree with me there?
Yes, I would.
All right. And you can do that one or two ways, or a combination of ways. One is to take testimony of potential witnesses. Is that correct?
Yes, it is.
All right. On this day, did you in fact do that?
Yes, I did.
And one of those potential witnesses was Sarah Boone. Is that correct?
Yes, it was.
And you took a statement from Sarah Boone because we've all seen it. Is that correct?
Yes, we had.
And at that point in time, Ms. Boone did not have to talk to you if she didn't want to, did she?
No, she did not.
So she agreed to talk to you at that point in time?
Yes, she did.
Okay. Were there any other witnesses besides Ms. Boone that you talked to on this initial date of the 24th?
Just Brian Boone.
And Mr. Boone told you what? You had a chance to talk to him. He told you his involvement. Is that correct?
That's correct.
And in fact, wasn't Mr. Boone's testimony, was that recorded too?
I conducted an audio recording, yes.
Okay. Is that standard procedure when you do your interviews to try to record the interviews?
Yes.
What's the benefit of that?
So I know what was said.
Okay. So, and if something goes on for a long time, you can refer back to it. Is that correct?
Yes.
Okay. All right. So, and out there, that's part of talking to witnesses or potential witnesses. Okay. Also, it's your job too to identify potential physical evidence in a case.
Yes, it is.
All right. And in fact, on the 24th, did you do that?
Yes, I did.
Okay. Did you have anyone assisting you in doing that aspect of it?
Yes, crime scene investigators and digital forensics investigator.
All right. And was Miss Melissa Rothengarten, that's how it's pronounced? Pronounce it for me.
Rough Garden.
Rothgarten. Okay, thank you. Did she help you in that area?
She was the lead crime scene investigator, yes.
Okay. So were y'all walking around together? Give the jury an idea of how that process takes place, please.
So yes, when I initially arrived on scene, I introduced myself to Sarah Boone and explained that I wished to go inside her residence, which she gave me consent to go in and look around. I went in, looked around, and then when my CSIs arrived, they would go in, take pictures, and then I kind of leave them to do what they need to do as far as taking pictures and documenting things and measurements. And then that's when I conducted my interviews. And then I would meet back up with my crime scene investigator after interviews were conducted, to kind of follow up with like things that I was told that would help us like identify things from the scene. And so, I mean, there's like multiple occasions where I would have met with my crime scene investigator inside the residence.
So this is an ongoing process doing that thing. You get information, you consult with them, they have information, they consult with you, and you're making a determination of what potential physical evidence that y'all at least like to document by camera, correct? Pictures, or actually collect and take away. Is that correct?
Yes, so it's accurate.
In that case, the suitcase was some evidence that y'all agreed on that we need to take this suitcase from the scene. Is that correct?
Yes, it was.
Okay. How about the baseball bat? Was that done that day?
The baseball bat was collected, yes.
All right. In your viewing of the suitcase, did you see the suitcase while it was unseen?
Yes, I did.
All right. Did you notice that if there was any items, other independent loose items in the suitcase?
There were, yes.
Were those items collected?
Some of them were, yes.
Who made the determination what items of that suitcase would be taken or collected and what would not be collected?
I would say that I have the final say on what is to be collected or not collected, but we do discuss it together to make that determination for me to give the final yes or no.
Do you recall which items you decided to collect from the suitcase?
Do you have the property form that I can refer to?
No, I'll try to find it.
I know some of them, but
Ma'am, I don't have it, but to the best of your memory, can you tell? And I would understand there would be some stuff that if you had the property report to refresh your memory, you can give me more detail.
yes, to my understanding and to my recollection, we collected things that had blood left over on it.
I have to pause for fair use and commentary, but let me just say this. You knew last night at the end of the trial, at the end of the day yesterday, you knew that this witness was going to be on the stand and it was your job to cross-examine her. And you were going to ask a question about the evidence collection, which is notated in the property report, and you didn't bring the property report. Fantastic. Mr. Henderson, I can see in your future a letter from Miss Boone. Please continue.
I want to say there was like a necktie potentially. I do recall there being a small amount of clothing and miscellaneous paperwork, but I do not think that we collected the paperwork. There was also a cell phone in there. It was not, it was dead, the cell phone. And then, like I said, there might be one, I think we collected 5 to 6 items from the suitcase itself, but obviously the property form would tell you specifically, but that is what I recall.
Correct, and I understand, and that's fair. Okay, so potentially you collect these items because you believe they're evidence for the case potentially, is that correct?
Yes,
And some of these items you actually collect with the potential that you might need to have them examined in greater detail, is that correct?
yes.
An example of something like that would be in this case, if you found blood on something, you might want to potentially examine that. Is that correct?
Yes.
And also the stuff that you're learning outside of these items also helps you in making that determination. Isn't that correct?
I'm sorry, one more time.
The stuff that you learn, the information that you're getting or you're receiving about what happened at that time will lead you to determine what items might need to be collected and what items might need to be tested.
Correct.
Is that correct?
Yes.
That's correct. We don't take everything that's inside of somebody's home at a crime scene to be investigated. We don't,
So
Lord.
out of the items that were collected at the house or the apartment, at those items, was anything to your knowledge sent off for further examination?
I believe so, but if it was, there would be, they would be sent to the Florida Department of Law Enforcement for further testing.
And do you have an independent memory of what items that were collected from the house that were sent to FDLE for further examination?
I don't recall specifically without looking.
Okay.
That report has been entered into evidence,
Now-
by the way. The FDLE, what was sent,
you
what was
aware-
tested, was submitted. Why don't you produce that document? You've already,
At one point in
Ugh.
time,
bruh.
there were some fingernail clippings or fingernail swabs taken from Miss Sarah Boone. Is that correct?
Yes.
And in fact, that was done on her interview date on would it have been the 25th?
Yes, sir.
Is that correct?
Yes.
Okay, and that's what we witnessed in the video.
Yes.
That's what they were doing at that time, correct? And I'm sure at the autopsy, which you were present at, is that correct?
Yes.
And those, there would have been some fingertip swabs of Jorge Torres. Were you familiar with that?
They do swabbing of the hands, to my understanding, and clippings of his nails.
Okay. Do you have an independent memory of the fact that Sarah Boone's fingernail swabs were sent to FDLE for comparison?
I would believe so.
Okay. How about the ones from Mr. Torres? Do you have knowledge that those were sent to FDLE for comparison or identification?
Well, they would have come from him, so I'm not sure what we would have compared him to.
Okay. Were they there to see, or at least they're sent there to see if they can extract DNA?
Oh, okay. Yes. I mean, I'm not sure if they did that testing for his nails clipping specifically, but it would be in the report if so.
Okay. Who would make the decision about sending his finger swabs to FDLE for comparison or evaluation?
I would request it I would request it to the crime scene investigator, and she would author the, I guess, procedure for them to do so.
Okay. And then as to Sarah Boone's swabbings, who requested that those be sent to FDLE for evaluation?
Again, I would assume that I would have done that. I would have requested the CSI to do that.
We did, Nicholas, and there wasn't any foreign alleles or anything underneath Sarah Boone's fingernail swabs, which is
Are you
interesting.
aware of the results from those evaluations?
Oh, here we go. She's about to testify to it if she's aware.
I'm not asking you for the results, just if you're aware of the results.
I believe I'm aware, but would love to see a report before I specifically answer.
Yes, I'm not going to ask you a specific question about it, okay? All right. But basically, you're aware that it was done, the procedure was done.
Yes.
The analysis was done. Okay. Now, ma'am, so you're through the first day. Then we get to the second day, which would have been, I believe, the 25th of February. Is that correct?
Yes.
And on the 25th of February, was Mr. Torres' autopsy done at that time?
Yes, it was.
Were you present during the autopsy?
Yes, I was.
And did you communicate with the medical examiner at that time?
Yes, I did.
During the course of things, is that where you found out through the medical examiner at the autopsy that there was blunt force trauma injuries?
Yes, that is where I learned more about his injuries.
Oh, that's how you
Now,
learn about it?
initially, when
Hold
you
on a
were
minute.
and when you were
That's how you learn about the injuries, Detective Kepsel? I consult the Magic 8 Ball when I want to know, but good for you for following protocol and procedure. These are ridiculous questions. I don't get the point, but let's keep going.
following the scene on the 24th, did you view Mr. Torres's body?
Yes, I did.
Did you notice in and of yourself on your own something that caused you concern that there might be blunt force trauma injuries?
Yes, I noticed injuries to him. Yes.
Okay, so after the autopsy, you had additional information, is that correct?
Yes, I did.
Now, there was an interview, well, I don't know if it was an interview. There was a meeting set up for Sarah Boone, is that correct?
Yes.
On the 25th? Is
Yeah.
that correct?
Yes.
Can you tell me how that meeting was arranged or how that meeting was set up, please?
So either before I left the scene, the night of the incident, I obviously met with Sarah and told her that we were leaving. We had to go make next of kin notification. And I would have either at that time said I would like to meet tomorrow and arranged it then, at least to like let her know that I would like to meet after the autopsy. And then obviously from watching the video towards the end, she said something about like recalling a conversation that we had, like calling me. So there may have been a phone conversation that occurred later that evening where I either would have confirmed the time or told her the time then. I just don't have that like on an audio. But I know it either took place before I left the scene because I obviously would have, said my goodbyes and told her, hey, we're leaving. We're going to make next of kin notification. She was very concerned about that. So I would want her to know that we were doing that. So it either took place then or it took place on that phone conversation that we had.
All right, the day prior to that, on the 24th, ma'am, you received Sarah Boone's phone, is that correct?
Yes, her phone was on the scene, yes.
And when you received that phone, Sarah Boone had given you that phone, is that correct?
No, she was not allowed in the apartment to give me the phone.
I'm sorry, did she give you permission to take the phone?
Yes.
Okay, is that correct?
Yes, I was given permission to go through her phone, yes.
Because at that time, you hadn't applied for any type of search warrant to get or search the phone, is that correct?
No, it was based off of consent.
Okay, so she had consented to you for you to have her phone,
Yes.
is that correct? She also provided you the code to get in the phone. Is that correct?
Yes.
So at this point in time, Ms. Boone is cooperating with you. Isn't that correct?
Yes.
Now, ma'am, do you recall telling her, Ms. Boone, that she could get her phone back the next day?
I don't recall specifically telling her when she would be able to get her phone back, but I did say something along the lines of we were now going to be taking the phone. I obviously had digital come out for consent to go through her phone. There was evidence on her phone that I needed to be downloaded. And at the time, I was willing to give back her phone before going through it. And then once we had gone through it, and those videos were found, I felt like this was very different, and it changed my perspective on consent. And I decided at that time that it was best to write a search warrant. So consent couldn't be basically like I knew I was going to take her phone. So consent has to be basically given to me throughout the entire period. So she would have had no way to contact me to tell me she no longer consented. So therefore, because there was evidence on the phone, I took the phone. Basically, I potentially told her, maybe we didn't get a full download. I may have said something along the lines of that. As far as me taking the phone, and then I wrote a search warrant. I either started writing the search warrant the night of, but it wasn't signed until I didn't submit it until the next day. And then it was signed the next day on the 25th.
So basically what you're telling us is that she could have withdrawn her consent at any time prior to that search warrant being received. Is that correct?
Well, while I was on scene, but at the end of the day, there was evidence on the phone. So I knew I could go through I knew I could get a search warrant to go through the phone based off there being evidence, like the 911 calls, and her explaining to me that they had spoken to family members.
Please silence your cell phones.
Since they had explained to me that they spoke with family members the night prior. So I wanted to obviously corroborate her statement. So I knew that I would be able to get into the phone through a search warrant. But yes, she could have not consented, and she could have not signed the paper consenting while we were on scene.
But before you left scene, you knew that Sarah Boone was not going to get that phone back. Is that correct?
Yes, that is correct.
Okay. So when Sarah Boone called you the next day, asking you about bringing her phone back, did you just tell her, Ms. Boone, you're not getting your phone back?
There was not a conversation about her not getting her phone back. She may have inquired about her phone, and I would have explained that we will talk about it when we meet that afternoon.
So did you reach out to Ms. Boone that next day, or did Ms. Boone reach out to you?
I don't recall a specific if she reached out to me the night of the 24th or before the interview on the 25th. I don't have my call records for that. I'm just basing it off of the interview where she had basically said that, yeah, I have your business card and I can contact you like I did. So my assumption would be that we did have some sort of conversation either the night of the 24th or before the interview on the 25th.
On the 25th, did you make arrangements with Sarah Boone to meet with her on the 25th?
So I either made arrangements on the 24th with her before leaving the scene, and I would have told her I would like to meet with you the next day. Or I said, and I may have given her a specific time at that moment, or when we spoke later that evening on the phone, I may have confirmed the time or given her a time then. But she definitely knew that we were meeting at 3 p.m. on the 25th at Orange County Sheriff's Office Central Operations.
And ma'am, you just don't remember at what point in time you informed her to set up this meeting with her. Is that correct?
It's one or the other that
One
I'm,
or the other?
yes.
Okay. As it to it being one or the other, you did you prepared the investigative report in this case, is that correct?
Yes, I did.
And the investigative report, you basically summarized everything that took place on this case, up to a certain point.
Yes,
Is that correct?
it was a summary. Yes.
Yes, that is
As
what an
far as
investigative
evidence,
report is, a summary.
As far as witnesses who were talked to and synopsis of what they said to you at that time, is that correct?
Yes, things that I did specifically. It was a summary of that.
I found your investigative report to be in great detail because it helped me track this case from basically beginning to not to the end, but to the point where the report stops. And it seems like in your investigative report, you are very thorough about details. Is that correct?
I would say I'm a detailed person. Yes, thank you.
Okay. So being the detailed person you are and absolutely doing your law enforcement training, they tell you, they train you that your report should be very much in detail. Is that correct?
Yes.
Okay?
He
Because you might
complimented
have to
her.
refer back to them at a later time. Is that one of the reasons? Is that correct?
Yes, I'm to prepare myself for depositions and trials.
Okay.
He complimented her. Mr. Henderson, you're definitely getting a letter.
And just to give an accurate picture of what you did and what took place and what people told you. Is that correct?
Yes.
Okay. Being as thorough as you are with these contacts with people, I didn't see in the investigative report when the arrangement was made with Sarah Boone to meet you down and where did y'all meet?
The Orange County Sheriff's Office Central Operations.
All right. To meet you at the Orange County Sheriff's Office. I did not see that in the report. Do you have an explanation why?
It's not typically something I would put in my report.
Okay.
It's not part of the investigation. It
You
wouldn't.
remember
Hold on a
in,
minute. Just hold
having-
on. Mr. Henderson, it wouldn't become part of the investigation until after she spoke with Sarah down at the police station, at the cop shop. I mean, come on, bruh. Like, this is ridiculous. You passed her a compliment, but it was a backhanded compliment. You're saying that she's incredibly detailed. Then you go ahead but you left this detail out. Stop it. The jury's going to see through this.
The conversation with Miss Boone about this meeting that was supposed to take place, that you said that you could not return the phone to her that day because you were not feeling very good. Remember telling her that?
That never happened.
Okay. Ma'am. Judge, if I could have a moment.
Yes, sir, of course.
Ma'am, during this time frame, were you pregnant at this time, at that time?
Yes, I was.
Okay. All right. Well, anyway, Miss Boone, there was a meeting arranged. Is that correct?
For the 25th at 3 p.m., yes.
Yes, and Miss Boone showed up for that meeting.
She
the
did.
25th.
Yes.
That we saw. Okay. Now, ma'am, I'd like to talk to you about some other investigation on witnesses, other witnesses that you took their testimony or statements, recorded statements at different times. Okay. Do you remember Abraham Marino?
Yes.
Okay. Did you take his recorded statement?
Yes, I did.
All right. At the time that you took Mr. Moreno's recorded statement, was there anyone else with you?
My partner should have been with me, Detective Scott Lowen.
Excuse me?
My partner should have been with me, Detective Scott Lowen.
Okay. Ma'am, as to who was with you, would it help refresh your memory if you were to see your investigative report as to that interview?
Your Honor, I would object. She hasn't said that she needs any aid in refreshing her memory.
Objection sustained.
Ma'am, was Detective Scott Lowen with you during that interview?
Yes, I believe so.
May we approach?
Yes.
Ma'am, do you have an independent memory of Detective Scott Lowen being with you at that interview?
I believe my partner was with me on the interview. Yes, I typically wouldn't go and do some follow-up without my partner being with me.
Thank you very much. Now, ma'am, did that interview, what date did that interview take place on?
I believe the 26th, February 26th of 2020.
Okay, thank you. Ma'am, was that interview recorded?
It was audio recorded.
Was the entire interview audio recorded?
Yes, the entire interview was audio recorded.
Ma'am, are you familiar with a witness by the name of Brandon Moats?
Yes, I am.
On February the 27th of 2020, did you interview Brandon Moats?
I believe so. It was either the 26th or 27th, yes.
If you were to see your investigative report, would that help refresh your memory?
Your Honor, I would again object. She hasn't indicated that she needs assistance with her memory.
Approach. Objection sustained.
Ma'am, if it was the 27th, you would not disagree with that, would you?
Well, I just stated that it was either the 26th or 27th.
Okay, thank you.
Okay, so not that this makes sense. I'm not saying this is a good way this, but the point of this, which is incorrect in my opinion, is he's trying to impeach the apartment maintenance manager's testimony about what the apartment, about what he told the detectives on February 26th or 27th. She's not the right person to impeach this testimony, especially, Lord, never mind. That's what he's trying to do. It's weird. I don't get it. Whatever. Here we go.
Ma'am, Mr. Moats, he was the neighbor living in the apartment, or the connecting apartment, wall apartment with Ms. Boone and Mr. Torres. Is that correct?
Adjoining
Yes.
apartment is the correct
He's
word.
the one who told you about the loud noise. Is that correct?
Yes.
Okay. Did you interview anyone else in reference to that loud noise?
So I was interviewing Brandon, and then my partner was interviewing Vincent, the other witness, and I came in at the end of the interview with Detective Lowen.
Okay, so that's Vincent. Do you know his last name?
I would butcher it.
Me too, but Taglione, something like that. We're talking about the same person?
Yes, sir.
Okay. And did that interview take place on February the 27th of 2020?
I believe so. I interviewed witnesses after I interviewed Sarah. The 26th or 27th would be my memory.
Okay, thank you. And then did he also talk to you about a loud noise?
I believe that I was refreshed on the conversation. And yes, he expressed hearing a loud noise as well.
Okay, thank you. Now, and those interviews were actually audio recorded too, is that correct?
Yes, they were.
Now let's go to Ms. Boone's interview. And that would have took place on the 25th, is that correct?
Yes.
Okay. And Ms. Boone came down. And ma'am, prior to Ms. Boone coming down for the interview, had y'all made the decision that Ms. Boone was going to be arrested?
Yes, I plan to arrest Sarah Boone.
Okay. Did you tell Ms. Boone in arranging the meeting that when she came down there, she was going to be arrested?
Your Honor, I'm going to object this to relevance.
Approach.
I'm going to object as to relevance as well. Look here. They're not required to tell a person that they plan to arrest them. Okay. Sarah agreed to come down and answer more questions. She didn't have to agree. Okay. There was a lot of talk that, and this is something the defense is not talking about. We could hear it in the interrogation video. Sarah was very, very worried. She claimed to be very, very worried about anything pertaining to what happened to George being discussed in front of her son. That's what she said. It's in the interrogation video. It's also at the end of Kayla Rodriguez's body cam footage. And they agreed on Kayla's, on Officer Rodriguez's body cam footage that nothing would be done in front of Sarah's son. okay, which is why they called her down there to the sheriff's office. Okay. This isn't all that deep. This isn't all that complicated. It wasn't some, huge subterfuge. Sarah didn't want anything, any questioning, any talking, anything taking place in front of her son. And they requested,
Objection's overruled.
or they not requested, they acquiesced. They agreed. That was the deal.
So ma'am, at that time, you did not tell Miss Boone prior to coming down there that she was going to be arrested. Is that correct?
No, I did not.
Okay. Why did you not tell Miss Boone that she was going to be arrested?
We planned to meet at 3 p.m. and go over the autopsy and have another interview. So, I mean, I'm not sure why I would tell her that she's going to be arrested. That would potentially cause her to flee, not come, and then we have to go find her and make it more difficult for everyone.
Or potentially get an attorney to come with her?
She was read her rights that said that she has a right to an attorney, and if one cannot be provided for her, she will be appointed one.
I understand that. You read her those rights when she got there. Is that correct?
Yes, I did.
You didn't read those rights to her before she got there, though, did she?
I wasn't in contact with her, physical contact with her.
That's not required.
So, but you said potentially for fleeing. My question was, potentially she could have got an attorney too to come with her. Is that not correct?
I misunderstood your question. I didn't hear potentially bring an attorney with her, but yes, I guess she potentially brought an attorney with her.
So Miss Boone shows up and you tell her there's some things that we need to talk about. Is that correct?
Specific verbiage. I know I said something along the lines of, obviously the autopsy had been conducted, and there were things that we needed to talk about in regards to that.
And prior to discussing it with her and asking her questions, you did read her Miranda warnings. Is that correct?
Prior to, I'm sorry, one more time?
Before you started asking her questions, though, in this interview, before you started asking Ms. Boone's questions, you read her Miranda warnings. Is that correct?
Yes, before I started asking any sort of potentially incriminating questions, she was read her Miranda warnings, yes.
Okay. Ma'am, do you remember as part of the Miranda warning?
All right, for those just joining us, this is the cross-examination of Detective Chelsea Kelso by Mr. Henderson, Sarah Boone's attorney, after Detective Kelso is done testifying. So after cross and potentially any redirect, which I'm sure there will be, the state will rest its case in chief, and then the jury will be dismissed. The judge will ask questions of Sarah pertaining to her testifying. Excuse me. She'll answer them. The judge will bring the jury back in, and then Sarah will be called to the stand.
And said you read to Ms. Boone. Did you read her the one that states that if you decide to answer questions but want to stop answering and consult with an attorney, you may do so? Do you independently remember reading Ms. Boone that instruction?
I don't recall that specific, but I do have my Miranda card on me, but I don't recall that that's what that says. But it is on audio and video recording.
Okay, thank you.
You're welcome.
Now, ma'am, at that point in time, Ms. Boone wasn't under arrest. Is that correct?
Ms. Boone was not going to be free to leave once she was in my custody.
At that point in time, had you told Ms. Boone that she was not free to leave?
No, I did not.
At that point in time, had you told Ms. Boone that she was under arrest?
I told her at the end of the interview.
Okay, before the interview.
No, I did not tell her before the interview.
Ma'am, why didn't you tell her before the interview?
Your Honor, I'm going to object as to asked and answered.
Overruled.
So I have to read her her Miranda warnings, and that's what I did. I do not have to tell her that she is under arrest at that time.
Was there a reason, could you have told her that she was under arrest before reading her Miranda warning?
Your Honor, I'm going to object as it calls for speculation.
Sustained.
Ma'am, was it a strategic decision not to tell Ms. Boone that she was under arrest prior to reading her those Miranda warnings?
Your Honor, I'm going to object as to relevance.
Approach.
This is a question, this is an argument that's been made 11 billion times, okay? Sarah Boone, who by her own admission excels at everything, was read her Miranda rights. That is all that law enforcement is required to do prior to questioning, which is exactly what Detective Kepsel did. She did not ask question number 9, which reads, having read you these rights, do you understand and wish to still speak with us today? That is question number 9. For the 11 billionth time, question number 9 was not asked. Question number 9, under the Florida Supreme Court, State Supreme Court, and the U.S. Supreme Court, question 9 is not a requirement. If it's not asked, it does not violate their suspects and constitutional right. Okay, they only have to be told that they have the right to remain silent. Sarah chose not to exercise that right. Sarah also chose not to request an attorney at any point in time, even when the questions became uncomfortable, even when the question became difficult. She did not say, I need to speak to an attorney. Point blank, period, the end. They can ask all the questions they want, which they're allowed to do, pertaining this question number 9 situation. Okay. However, it does no good. It's not going to work. It's ridiculous, and it's a big waste of time. When the main question, which is something that Sarah has alleged, is that she was under the impression, or the accusation, excuse me. Sarah had the accusation against Detective Kepsel is that Sarah was lured to the sheriff's office under false pretenses, and the false pretense being getting her phone back. Okay, Detective Ketzel's
Objection sustained.
Ansel took all the wind out of the defense's sails on that. Period. The end.
Ma'am, and we were able to see the video of the interview. As a process of interviewing people such as Ms. Boone, or let me specifically, in the process of interviewing Ms. Boone, is law enforcement free to give information that might not be accurate or true during the interview process?
Are you asking if we're allowed to lie to her?
Yes.
Yes, to an extent.
Was that done at any time in this interview?
Did I lie to her? I don't recall lying to her, no.
I confer, Judge.
Yes, sir.
Oh, for Pete's sake, this should have been prepared. This is, look, I'm not even an attorney, but this isn't all that difficult. If I think somebody is lying, what do? I produce a receipt. Okay. You ask this
Thank you,
detective
ma'am. I have
if,
no further
yeah, that's what I thought.
A redirect examination.
Hold on just a second before we redirect. This is why this was a weak cross, in my opinion. There are allegations that are being made. Now, the conversation as to how Sarah got down to what she was under the impression of why she was coming down to the cop shop, that is kind of a he said, she said sort of situation because there's no evidence to prove it one way or the other. However, there is evidence supporting Miss Kepsel's version of events because Sarah, at the beginning of the interrogation, talks about a list of questions that she has. The interrogation takes place. Sarah gets to the list of questions. Let me just explain this. The phone is not the first thing that she asks about. What she first asks about is does she need to call George's probation officer? Okay, that was important to her. It might have even actually been questions about the family, what they're going to tell the family. That might have been the first question, and it was followed by the probation officer. So clearly the phone was not a big deal. And when she did ask about her things, it was not actually her phone. What she asked about specifically was her son's laptop. That's what she asked about. I think the phone was like the third or fourth thing that she asked about, fourth thing that she asked about. Okay. So there's that. If you want to prove that Detective Kepsel is allowed to lie, and in fact she did lie, why would you ask that question if you didn't know the answer to it, right? You know she's going to say no, she didn't lie. And if you want to call her out on it, then you have the interrogation video. It's been admitted into evidence without objection by the state. The defense didn't object. Why don't you why don't you pull up the clip from the interrogation where you think that she was lying to your client? I mean, this is preposterous. What are you doing, bruh? This is what happens when I oversleep and I'm crabby. Here we go.
No, Your Honor.
Can this witness be released? State.
We have her subject to recall.
Okay.
Subject to recall.
All right, ma'am, you're released subject to recall. Thank you.
Great, thank you.
All right, here we
State,
go,
any
you
other
guys.
Witnesses, evidence, or testimony to be produced.
All right, this time the state would rest.
Okay. Members of the jury, it is 10:22 a.m. I have some matters with counsel that I need to address. So we're going to excuse you for a short while. It's a great opportunity for us to take our morning break as well. Similar instruction that I've given to you over the last couple of days. Please do not discuss this case amongst yourselves or anyone else. Do not conduct any independent research or investigation as to the person, places, things, or charge involved in this case. We'll bring you back in as promptly as possible. Thank you.
Jury exiting.
I mean, that was in all my trial coverage, like not even trial coverage, just the amount of time that I have been watching trials. That is probably one of the weakest cross-examinations I've ever seen. And again,
Defense, any motions?
Judge, we do have some motions, but my client needs a comfort break.
Okay.
If we could do that, because it may be fairly.
Agreed. Let's go ahead and.
Oh, for
take
Pete's
that.
sake.
It's going to be in recess for 10 minutes, and then we'll pick up any motion practice at that point in time. Court's going to be off the record. Thank you.
fantastic. And of course, in the middle of all of this, the jury is exiting. And what is Mr. Owens doing? Just meandering around the courtroom for no reason. Look at her. Unfazed. Unfazed. At all. She seriously thinks that she's going to be able to get on that stand. Now, I will give it to her in this way, okay? On direct examination, that's the easy part. That is the easiest testimony for a defendant, okay? It's the cross-examination. And she chose to wear a black suit with a blue shirt. according to the judge. It's hard to see because it's under, I can't see from behind. But you came what? Dressed as a bruise? I know she's, come on, they could maybe take the blazer off and just wear blue. That probably would have been better. And for the love of Pete, Sarah, you get up at 2:30 in the morning or 3 or what, and then you're brought over to the jailhouse. You have plenty of time to do something with the back of your head. You out here looking like you just rolled out off the cot. Come on. Like, don't you? And now she needs a comfort break. Give me a break. All right, let's scooch forward. Let's see where we're at. All right. For those of you who are interested in the happenings in the Leilani Simon trial. Whoa. Hold on. I didn't mean to. I'm looking on my phone. Sorry. I put it live. I believe, yes. The witness on the stand currently is what is his title? He's the supervisor of the landfill for the company that handles trash collection in Savannah, Georgia. So, yeah, that's what's happening currently. OMG, Country Joe, what you doing? I haven't seen you in a long time, babe. Good to see you. So, yeah, I agree. A lighter shirt would have been better. I expect, given the discussion that took place earlier, the defense's expert witness isn't even going to be able to testify. One of them isn't going to be able to testify till Thursday. Today, for the record, in case anybody needs to know, doesn't remember, is confused. Sarah was very confused about what day it was that day in the interrogation room. So, what day of the week? So today's Tuesday, which means Wednesday. We still have another day of testimony, okay, and then Thursday, right? So, where it's going to fall apart for Sarah is in the cross-examination, okay? At the end of the day, it is even the most unflappable people, most well-prepared, prepped defendant very rarely is able to withstand the scrutiny under cross-examination. Everybody gives just a little bit. Oh, thank you very much, Country Joe. Oh, Country Joe. I don't know if you've seen it, babe, but I put out a trailer on the channel that I think that you would be very interested in. So when you get a minute, check it out. I could play it for you guys now, but it is it's the trailer for the documentary that I'm going to do for Halloween, where I go through all of the Conjuring movies and tell you guys about the true story. And I used clips from the movies. They're obviously horror movies. I used clips, and it's kind of scary, and it might, it's not for everybody. So I don't want to play it now because I feel like it might, that might be too much. It's not for everybody. So yeah, that's what I'm going to do. And yes, one does not simply outsmart on cross. So it is kind of cool, Jesse from Jesse, California. I worked really hard on it. I'm worried that if I can show it if you guys want me to show it. I'll show it to you guys, but I need to get like an overwhelming number in the chat that want to see it before I show it, just because it's, it's not for everybody. So yeah, it's on my channel. I don't really need to show it. Mel already. So yeah, that's what's going on over in the Leilani Simon trial. I believe that at some point today, Red Craig is supposed to be testifying. So yeah. You know what? I know you guys want to see it. I'll tell you what, instead of showing it here, what I'll do is while we're on break, let me give you guys the link because I feel like I want to show it because I'm actually really proud of it. And it's not scary to me. It takes a lot for me to be scared. Like something's very wrong with me. I'm not even going to lie. I've been watching horror movies since a very, very long time. And it's, it takes an awful lot to scare me. True crime scares me sometimes, but here, I'll give you, here, I'll put it in the chat and then you guys can watch it in the chat. There you go. That way, if you want to go and you want to watch it, you can. And then if you want to, if you don't, then you don't have to, but there it is. There's the link. So I just think this is what I predict is going to happen. Okay. Owens is probably going to be the one who questions Sarah on direct. Okay. And then I think Mr. J is going to be the one who handles cross-examination. I'll know better by when they start the direct examination. If there's any objections, whoever makes the objections is the person who's going to handle cross. Okay. So, but I think it'll be Mr. J. And Mr. J is a very, very effective prosecutor. I'm very impressed with him. And for those of you that are following, as I am, the Madeline Soto case, Mr. J will be the one prosecuting Stephen Stearns. So I feel really good about that. I feel like he is going to give Maddie the dignity and the reverence that her case deserves. And I think that he is going to make sure every single I is dotted, and not just like one of those dots where you can't tell if it's dotted, but there's a dot there, but it's not a big, you know what I mean? No, I think it's going to be a very clear dot. And I think it's going to be a very clear crossing of the T's. I think that I think he is going to do a phenomenal job. And I feel a lot better about the case moving forward and Madeline Soto getting justice, because those of you that follow know that this case, what happened to Maddie, didn't just happen that Sunday into Monday. It had been going on for 4 years. And so, Neat Noodle, I'm not actually sure about the other case. That's not the murder. I know he's handling the murder case, but I'm not sure about the other case. I'll have to go and check, and I will go and check on that. Maybe at lunch or something like that. I do expect that Sarah's testimony is going to be quite lengthy, because remember what they're trying to get in here. The defense has to get in this overt act committed by George, okay, before they can even start putting on any evidence of the battered spouse syndrome defense, okay? So I would expect that her direct testimony is going to be quite lengthy, and might likely take all day. So this is what we will do. I will stream all morning long. Likely there will be a lunch break. Usually Judge Cranick gives everybody an hour and a half, putting the time to come back at 2. So I'll schedule another stream starting at 1:45. All right. And then we'll listen to the afternoons. I'll stream all day today. So to answer Tracy L., why did he say state rest, meaning no more witnesses for the state side? Okay, so the reason why the state rested at this time is because they know that the defense intends to use the battered spouse syndrome defense. But the judge has ruled that no evidence of the battered spouse syndrome defense can come in until Sarah Boone herself takes the stand and testifies to the overt act she says Jorge Torres Jr. committed that caused her to go into sort of a PTSD type scenario. Okay. So if the judge doesn't allow that,
We're back on the record.
hang on, let me
2020
pause
260.
this. If the judge does not allow the after stairs testimony, if he doesn't allow the battered spouse syndrome defense to be used, the state has rested, and it then becomes a straight, very simple second-degree murder case, which, in my opinion, even if they put no other witnesses on, they've proven because of the interrogation video, but more important, and Sarah's own statements, but most importantly are the suitcase videos. Okay. So they rested now. The defense is going to take over. They will present their case. And then the state, after the defense rests, the state has an opportunity for a rebuttal case. So should that be allowed, the battered spouse syndrome defense be allowed, then the state will use their rebuttal case to put on their expert witnesses to essentially refute the battered spouse syndrome defense. Okay. Oh, thank you, Jennifer Mikesell. Thank you very much. I didn't know this. And thank you for the super chat. You didn't have to do this, babe. The state decided to combine the 2 cases. So, bruh. All right, here we go.
3, State of Florida versus Sarah Boone. Appearances for the state.
Yes, sure, on behalf of the state. William J. for the state.
Defense.
James Owens for Ms. Boone. Tony Henderson.
Tony Henderson for Sarah Boone.
Do we have any motions? You may proceed. Yes, sir.
At this time, the defense would move for a judgment acquittal. I'm going to start with just a real quick couple of comments, Your Honor. We know that JOA motions have become essentially pro forma, which may be why I've been assigned this responsibility today. But in this instance, I want to make an argument that I think has some merit. I've been paying close attention to.
Let me tell you what's going on right now. I forgot about this part because I got so wrapped up in Sarah Boone potentially testifying. So now that the state has rested their case in chief, this is totally normal procedure. The defense will always begin by motioning for a dismissal. Basically, they're going to, this gentleman, Mr. Beckman, is going to argue that the state has not proven their case. Okay. The judge is not, the state has proven their case, blah, blah, blah. It is what it is. Let's go.
The testimony in this case. And I want to point a couple things out. First of all, we know that the court has essentially assumed the role and is assigned the role of becoming a gatekeeper in this matter. We know from the testimony that's been presented in this matter that not only did law enforcement, but also the Office of the State Attorney had knowledge of these parties prior to the event having occurred. And despite that, the state has proceeded with this prosecution based upon a criminal information as opposed to having taken it to the grand jury. That kind of places the court in a special position to evaluate the nature of the evidence that's been presented. I want to focus on the second-degree murder allegation. And one thing that occurred to me while watching the evidence as it was presented, watching the videos, particularly the interrogation, was part of the dialogue between Ms. Boone as well as Detective Scott Lowen at the end of the interrogation. And I'm going to paraphrase. I apologize. I should have written this down verbatim. I did not. But she's advised that she is being placed under arrest. Something to that effect. And her response is, "Why are you doing this?" The detective's response to Ms. Boone is, "Because George is dead."
I'm sorry.
Because George is dead. That's not enough. It's not enough to support a second-degree murder, prosecution, conviction, or should it even be enough to allow this matter to go to the jury? Now, there are three elements of the second-degree murder information. The first is that the victim is dead, that Mr. Torres is dead. We stipulated to his identity. There has been no argument to the fact or the idea that he died in this incident. However, the state also has to show that it was caused by a criminal act and that the act was imminently dangerous and demonstrated a depraved mind. Now, the fact that it was imminently dangerous, I think, is belied by the fact that Jorge Torres voluntarily entered the suitcase, albeit under the influence of alcohol. But the perception of dangerousness that's attributable to the victim, apparently he did not perceive it to be a dangerous or imminently dangerous situation in having entered the suitcase, possibly because of the influence of alcohol on his capacity to make decisions, should necessarily be attributed to the defendant as well. But I also want to focus on the depravity issue, which the state must prove, and pursuant to the jury instruction in this matter, depravity is is made the equivalent of ill will, hatred, spite, or evil intent. And that's not enough. Not only does the state have to show depravity, but it has to show, because it's in the conjunctive, that the act demonstrates an indifference to human life. The state has presented testimony and argument in this matter, not argument, but testimony that in fact George Torres was suffering. Suffering does not equal hatred. It does not equal ill will.
Okay, just briefly, let me explain what's happening here. Okay. The state has rested. All right. Is now incumbent upon the defense, which is what they're doing currently, to file, to motion for a dismissal. So they're going, the defense attorney is currently arguing right now why the charges should be dismissed, and based on the charge and that basically the state has failed to prove through the evidence that they've put on in their case in chief, the state has failed to meet their burden of proof for second-degree murder. Okay, that's what we're hearing right now. This happens in every single trial. This is totally normal protocol. The judge is listening intently, but at the end of the day, the suitcase videos, in my opinion, whether George got in that suitcase voluntarily matters not, because in those videos, he is clearly scared, telling her he can't breathe, which is dangerous, and asking her to let him out. That's it. That's all. Second degree, right then and there. Boom. And that depraved mind would be for everything you've done to me, that's on you. Fuck you. Shh.
And even if they were to establish negligence, that's not homicidal. We know that suffering is something that the courts have been very, very cognizant of and very sensitive to. We know it from the field of capital punishment and incarceration. The idea that somebody suffers is not in and of itself homicidal, nor should it support the idea that there was indifference to the life of George Torres by Sarah Boone. Was she angry? I think there's clear evidence that she was angry. But that's not hatred. And that's the element that has to be proven here. And I don't think that there is prima facie case that in fact she demonstrated hatred so much as she demonstrated anger. Doesn't establish a prima facie case of second-degree murder. It's for those reasons, Your Honor, that I think that this matter should be, the motion for JOA as to second-degree murder should be granted, and this matter should be allowed to proceed solely on a manslaughter charge because, in fact, they have not established prima facie elements as required by law. Thank you, Your Honor.
Thank you. Response.
Yes, thank you. Standard at this time is just a prima facie case. Whether any trier of fact in taking all the facts in the light most favorable to the state and the inferences drawn from them establish the elements of the crime. There are 3 elements to this crime. George Torres is dead has been established by a prima facie case. The death was caused by the criminal act of Sarah Boone that has been established. There was an unlawful killing of George Torres by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. It's not Miss Boone's subjective statements on February 25th. I had no idea you could die from being zipped into a suitcase for 13, 15 minutes before she goes to bed. 2, is done from ill will, hatred, spite, or an evil intent. We heard what she said. The 2-minute video starting at 11:12 p.m. 45 seconds should be linked in Merriam-Webster's digital dictionary for the definition of depraved mind. Fuck you, I don't care, laughing is of such a nature that the act itself indicates an indifference to human life. Sarah, that's my name, don't wear it out. Judge, there's no question that a prima facie case has been laid. In addition to the 2-minute video and then the 22-second video 11 minutes later, we also have the defendant's inconsistent statements that she has made in regards to these events. And therefore, we have that factual issue for the jury to decide. She made statements on the 911 call and to law enforcement, both on the 24th and 25th, that I have no idea what happened. I just went to sleep. Everything was good. And then when confronted with her video on the 25th, we see that there are 2 distinctly different sets of statements that were made. So this is sufficient at this stage in time for a jury question. Thank you.
Thank you. Any other additional argument, Mr. Beck?
No, Your Honor.
Right,
Oh,
thank
I'm
you.
sorry,
Thank
Mr.
you
Beck.
both for your arguments. The court, in viewing the light most favorable to the state, the court finds that the state has presented competent but rebuttal evidence to establish each of the elements of the charge contained in the information to the required level of a prima facie showing. As such, the defense's motion for a judgment of acquittal is denied. Defense, do you intend on putting on a case?
Yes.
Ms. Boone, I have a couple of questions to go over with you.
Judge, if I may.
Yes, sir.
In a normal criminal trial, my position has always been to put on the defendant last. Call whatever witnesses, put on exhibits, photographs, and then the client would be the last person to testify. Because of the nature of discharge and our defense, self-defense, and battered spouse, we understand that we have to put on her first, Sarah first, as a court to then consider whether or not we've established enough evidence for self-defense instruction. So she's going to have to be going first as the witness. I'm going to need a few moments with her based on everything that's going on and based on that denial of that motion for judgment of acquittal. To just go through it again, because I know you're going to ask to colloquy about all that. So I'm I'm gonna need a few moments with her. I don't know if it's 10 minutes maybe for the 3 lawyers, 4 lawyers to meet with her. I don't know if we can do it here or maybe back there, but just a short meeting.
Sure, I'll give you that opportunity, but before you do that, ma'am, I don't want to go into any specifics of any conversations that you've had with any of your attorneys in this case. Mr. Owens has identified for the court his normal practice of calling a defendant last in a criminal case. In this case, he has advised that he wants to call you first. Without going into any discussions of any strategy that you've had with your attorneys, do you understand the strategy that Mr. Owens and your team will be utilizing in your defense?
Yes.
And are you in agreement with that strategy?
Yes.
All right. Counselor, you can have that opportunity to speak to her. The court will remain here. I don't know if they can, Officer Jones, can we let them back to have that conversation? Okay. All right. You can go back and have that conversation. The court will remain here. We'll be in a short recess for approximately 10 minutes. Thank you.
Okay. Let me just say this. This is why Mr. Owens gets on my nerves. Okay. But let me answer this question first from Dead Eye Danny. What was the plea she turned down again? The plea was manslaughter, 15 years, if I remember correctly. This is why I'm irritated with Mr. Owens. It's not really for us so much, but it's really for the jury. Okay. We've been on break since 10:22 a.m. local time. It is currently 10:58 local time. You do the math. Okay. It's 30 minutes, a little more than 30 minutes by my math, which ain't good. Anywho, they're sitting back there, they're waiting and waiting and waiting. This could have and should have been done last night. At the end of the day, Mr. Owens, with your 35 years of experience in criminal trials, right? I know not all of your cases you've taken to trial, but you have taken a great number of cases to trial. And you know, and I know, and I'm not even an attorney, that when you make a motion for a judgment of acquittal, 9 times out of 10, they are not granted because the court is required to view the evidence in the light that is the most favorable to the state. It's very difficult. It's a high burden for the defense to be able to overcome that. So they're typically not, and that is because so much has gone on pre-trial before it even gets to trial. Okay, so you knew that the likelihood of there being a judgment of acquittal granted for your client was slim. What did you do last night? I know it wasn't preparing documents and answering the emails with respect to some evidence that you intended to submit that the state requested. I know you weren't doing that. I know Mr. Henderson wasn't preparing for his cross-examination of Detective Kepsel. That was abundantly clear. So what were y'all doing last night? Why didn't you go over to the jail and visit your client to prepare her for this? I certainly was aware that you putting the defendant on first as your first witness is typically not how the defense normally does it. Usually the defendant is last when they testify, if they testify at all. I mean, I don't understand this. And now in my estimation, you're not wasting my time. I'm just kicking it. Okay. But you are wasting the jury's time. And they don't like to, there's nothing to do in the jury room. They're not allowed to talk to each other. They're not allowed to discuss the case. They're not allowed to really, it's not like they're not allowed to talk to each other, but how much small talk can you really make with somebody? You know? This is just ridiculous. There was, they used a charging document rather than taking this to a grand jury. So that the state met, it stood up under scrutiny from 2 different judges, at least pre-trial. The charging document has. So, like, I don't understand why he expected this to happen. I really don't. Thank you, Brian. I appreciate this. Seems to me like they're trying to give the ineffective counsel defense. Look, that is a incredibly, incredibly difficult appeal to mount. Ineffective assistance of counsel is an incredibly difficult appeal to be successful. It's very, very difficult because all along the way during the trial process, and I'll just speak specifically to Sarah Boone's trial, all along the way during this process, Judge Cranick has colloquied Sarah Boone specifically about her attorneys. And every single time that he has asked her about whether or not she is satisfied with her attorneys, whether she understands and agrees with their defense strategy, each and every time she has answered in the affirmative. That makes it very, very difficult. I've seen situations where, and I'm going to give you a brief example. It has nothing to do with guilt or innocence. It's simply an ineffective assistance of counsel appeal. Brendan Dassey, when his attorney allowed Brendan to be questioned without him being present by the prosecutor, that's ineffective assistance of counsel. It matters. I'm not going to argue in the chat. Please don't, because I know that's a highly contested case, but I'm only using it as a reference because it is an absolute ineffective assistance of counsel. An attorney wouldn't almost never, except for this situation, allow their client to be prosecuted, allow their client to be questioned without them being present. That's a problem. So that's an example that I use. And his appellate attorneys filed an ineffective assistance of counsel appeal, and it was denied. It's an incredibly difficult appeal to mount. It's very rarely successful. So, yeah. Well, okay, so now Sarah Boone's back in the courtroom. James Owens is back in the courtroom. Yes, Mr. J, you and me both, looking at the time. Current local time is 11:05 a.m. Eastern Standard Time. That's what I'm talking about, the investigator. My bad, a little Irish girl. Listen, I overslept this morning, and I don't really feel like the coffee and the 5-hour have quite combined and hit all my sins. Like, I'm still a little like, not all the way awake. So I feel like, it was the interview. It was the investigator that he allowed to interview, interrogate. At the end of the day, a defense attorney would never want their client interviewed, interrogated, questioned, evaluated in any way, shape, or form without them being present. And that's what happened. So, oh, thank you, Ivelisse. I appreciate that. Thank you so much. Ivelisse says, I learn a lot from you about lawyers and law. I didn't really much until you. You're the best. Love your advice, attitude, and you're funny. Thank you very much. Now, I want to be clear. Okay. This is just stuff that I've learned over the years covering true crime, but mainly my focus has always been really covering trials, because I think that is where all the facts of the case come out. Not every single fact will come out during a trial, but the facts. And so that's why I like to cover the trials. And this is based on my experience. I have never in my life, in any capacity, worked in any facet of the legal field or anything legally adjacent. Okay. I cannot give you legal advice. Please don't interpret any of this as legal advice. If you should contact an attorney for legal advice. Also, please, as much as I love you guys, and I hope none of you ever have the need for that one phone call, but should you, please don't make it be to me, because I'll tell you right now and save you the trouble. My advice is going to be remain silent and call an attorney always. Whew. Yeah. And let's be considerate to our trial watchers from Australia, from the land down. Let me do it right. From the land down under. Okay. They're like, it's like 11 o'clock in the evening time for them. It's late. They need mimes. Be considerate, Mr. Owens. Hey, Sam. Good to see you, babe. Love you. Miss you. Glad you guys are all here. And also, I'm probably a little salty and a little crabby because, like, I've been following this case for a very, very long time. Shout out to True Psych Ward, Dr. B. I started this question because I wanted to answer it and I forgot. So this human place asked if I still work with Dr. B or am I solo? I've always been solo. This has always been my channel. But Dr. B and I, True Psych Ward, frequently did things together, the roasts of true crime, discussing cases together. She's still my very best friend. We talk frequently, but she's working and she's busy, and it makes me sad because I wish that she could be up here on panel with me right now, because she's the person who introduced this case to me. And ever since then, I have been waiting for this day. Oh, what about you, Mel? Whatever. I said that James Owen is rude and taking too much time, and our friends in Australia from the land down under, it's late for them and they're trying to go to bed, and they should have some, consideration for other people. That's why I see it. So yeah, I wish she could be up here with me, but she's got to work. Initially, Nicholas asks if Dr. B from True Psych Ward is who I roasted Sarah Boone with. Initially, yes. I've roasted Sarah Boone a number of times. I think that one of those times was with Christine G. That's me. I think Allie has been up there one time or another when I've roasted Sarah Boone. So, Mel is interviewing for the position of bestie stat. I like our little spoon, big spoon better than bestie? Means a little something different, you know? But yes, Dr. B is working. And so I can assure you that Dr. B is around. She may not always be speaking in chat, but she is around. Let me go over here to the channel. I'll find it for you. Give me a second. The initial roast of true crime that I did with Sarah. Let's see. Let me view the full playlist. Oh, I need to scroll. Where is it? Huh. There's Melanie Gibb. There's Stephen McDaniel. Why, Stephen? Why? All right, hold on. Oops, that's not what I wanted. I might have it just with all the Sarah Boone stuff. Let me view the full playlist. Let's see. Hold on. Let's see. I guess this is part of the problem is that my channel is as unorganized as my brain sometimes is. So hang on. Let me see. Let me look for Sarah. I know what the thumbnail looks like. So at least I'm on the right track in that capacity. Holy guacamole. I've done a lot of I've done a lot on this channel. Give me a second. Let me see what you guys are doing in chat while we wait. Okay, good. All right. I'm still scrolling. So, I'm over this. Like, come on. Defense, let's go. Let's get this show on the road. We're ready to hear Sarah's, from her own words written in letter form. We're ready. She wanted to tell her story. She is convinced that if people heard and understood her story, that there's no way they would find her guilty. They would totes understand what Sarah did and why she did it and all of the things. And so come on, let's get this show on the road. Oh my gosh, I really have to scroll. There's been a lot. Here it is. Found it. All right, let me put it in the chat for you guys. All right, here we go.
We're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State appearances for the record.
Dave Castro on behalf of the state, William J. for the state.
Defense?
James Owens from Miss Boone.
Tony Henderson for Sarah Boone.
Kevin Beck on behalf of Sarah Boone.
Ms. Boone is seated at counsel's table wearing the same black blazer and dark blue blouse from this morning. She is in custody, however, not wearing any restraints, so she'll be able to stand when our jury enters. And if she is called to testify in this matter, she will be able to walk to the witness stand. Ms. Boone, I have a couple of questions to go over with you. Similarly to our conversations earlier today, I don't want to know about any of the substance of any conversations you've had with your attorneys, just whether or not you've had certain conversations. So far, you've been present throughout the entire trial process. You've been seated at counsel's table. You've had the opportunity to observe the evidence presented by the state, as well as the direct and cross-examination of the state's witnesses. Are you satisfied with your attorney up and until this point?
Yes.
Now, I'm going to ask you some questions again about specific conferences and conversations you have with your attorneys. I don't want to know those specifics, just whether or not those things have been had. Have you had the opportunity to discuss with your attorneys whether or not you would like to testify as a witness in this case? Do you need any additional time to discuss that matter with your attorneys?
No.
Have your attorneys discussed with you the potential benefits and potential harms of testifying as a witness in this case?
Yes.
Are you satisfied with the advice from your counsels?
Yes.
Do you understand that attorneys can make most of the decisions about trial strategy? They cannot determine whether or not a defendant testifies or not. Do you understand that?
Yes.
Not even the court can interfere with the defendant's right to make that decision. Do you understand that?
Yes.
Do you understand that it is your decision and your decision alone?
Yes.
While counsel can give you advice on whether or not it would be wise for you to testify in this case, do you understand that you can ignore counsel's advice because the final decision is yours?
Yes.
Do you understand that you have the right to remain silent?
Yes.
Did you hear me explain to the jury at the beginning of the trial how the right to remain silent is absolute, and the fact that a defendant did not testify cannot be considered as evidence of guilt or influence their verdict in any way?
Yes.
Before a jury begins its deliberations, the court will read another jury instruction if you decide not to testify. This instruction orders the jury not to consider your silence as evidence of guilt or to consider your decision at all. Would you like me to read that instruction for you at this time?
Yes.
It is instruction 3.9a, entitled Defendant Not Testifying. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that a defendant did or did not take the witness stand to give testimony in the case. Do you have any questions about this instruction?
No, Your Honor.
Do you understand that if you choose to testify, you are waiving your right to remain silent?
Yes.
That means once you begin to answer questions, you have to answer all questions unless I instruct you not to answer a question. Do you understand that?
Yes.
You cannot pick and choose which questions you want to answer and not answer. Do you understand that?
Yes.
Do you understand that if you refuse to answer any questions, the court can impose sanctions, such as holding you in contempt, striking your entire testimony, and instructing the jury not to consider any of your testimony? Do you understand that?
Yes.
If you choose to testify, you will also be subject to cross-examination and impeachment. That means the state could ask you about any prior felony convictions or convictions for crimes of dishonesty if you have any such convictions. If you have any such convictions, the questions will be limited to whether you have such convictions and the number of same. Do you understand that?
Yes.
Are you aware if you have any such convictions?
Yes.
State? Are you aware of any felony convictions or convictions for crimes of dishonesty?
No, I believe she's answering an affirmative. She's aware that she doesn't.
Okay, so you have no such convictions. Okay, thank you for that clarifications, ma'am. As there are no convictions, and that number is not in dispute, the state will not be permitted to inquire into those matters. Have you had enough time to discuss your decision to testify or not testify with your attorneys?
Yes.
Again, do you need any additional time?
No.
Has anyone forced you, threatened you to get you to testify or not testify in this case?
No.
Has anyone made any promises to you to get you to testify or not testify in this case?
No.
Are you satisfied with your counsel's advice so far in this case?
Yes.
Are you making this decision freely and voluntarily?
I am.
Did anyone force you, threaten you, or coerce you to testify in this case?
No.
Would you like to testify or not testify as a witness in this case?
Testify.
Okay. And ma'am, similarly, after you've had the opportunity to converse with your lawyers again, I want to confirm that you're on board with the strategy that they've utilized in your defense in this case,
Yes, I understand.
including calling you first.
Yes.
Okay. All right. I want to remind you, ma'am, that you can change your mind. You just have to let your lawyers know before the jury comes back in. Do you understand?
Yes.
State, anything else we need to address?
Just that the law of the case is that there should be testimony from the defendant of an overt act that particular day before there is testimony about reputation evidence, prior instances of violence, or any of the ancillary things that come with self-defense.
Holland case speaks for itself. Anything further?
I do want to talk about that, but as it relates to her right to remain silent or testify, I have nothing about it.
Okay, then what do we need to address with regard to Holland?
Well, I've got three issues. One is Holland. The other is I've got these gloves. My client and I would like to take a few moments to look at the suitcase and to look at that. And then the third thing is that the state had filed that motion for the in-camera hearing. I don't know. Maybe we need to hear that before she testifies.
Court's not going to address that at this time.
Okay.
We'll address that later in the proceedings.
So the two things, number one, of course, I've got a lot of photographs about the prior violence that Jorge Torres committed on Sarah Boone, and there is a dispute about whether or not I have.
Mr. Owens, for the love of Pete, how many times did Judge Cranick ask Mr. Owens if he had any issues that he needed to discuss with him? I'm over it, bro. I can't with you, Mr. Owens, Esquire. I'm done.
Have to establish an overt act that she responded to, that she considered an imminent threat, and that she took evidence or she took action to either block or physically restrain Jorge Torres from committing an act of violence on her. But Judge, if you'll remember, during the 2-hour interrogation, the officers make mention that they are aware of the prior incidences of violence. So I believe the door has been open, that I can go into that based on those statements by the two detectives. If you remember, they introduced this 2-hour video. She says, he comes at me all the time. I think eventually Sarah Boone realized that they had her phone and they were going to see pictures. They were going to see videotapes of evidence that Jorge Torres committed acts of violence on Sarah Boone. I think at that point she changed her tone about George. She was trying to protect George.
Hi, you
But then
guys
she
coming
realized She
in.
would have to disclose some of the acts that had been committed on her by Jorge Torres. And so she did talk about him coming at me, and we've had issues before. And the officers I can't remember exactly what they said, but yeah, we're well aware of, I don't know if they said the prior acts or we're aware of the domestic violence, whatever the case may be. I submit that opens the door. That was during their case in chief. They chose to play that entire video. And so I think I can talk about the prior bad acts before the event in question chronologically. And I've got a bunch of photographs that go into physical evidence of her injuries as a result of George's violence.
Okay. Response, if any.
Judge, we're asking for the court to maintain its ruling. We already read an instruction that the police are allowed to tell her things to try and get reactions from her. She affirmatively denied there was an overt act that night to the police. The court, in its ruling pre-trial, I've been trying to get some guidance on this. We've reviewed Ms. Boone's most recent statements on the matter, and there is no overt act thus testified to. So we are hopeful that we will maintain that ruling, and I don't know how it prejudices her or her team in any way to establish an overt act on February 23rd, 2020, before we go into reputation evidence, prior instances of violence, or battered spousal evidence.
Any other further argument, Mr. Owens? All right. I don't find that the officer's statements are character evidence, and you're looking for specific instances of conduct, which are going to be utilized for those specific purposes for reputation or violence to establish the fear component that the case law speaks about. Florida Supreme Court decision in Holland is clear that that overt act needs to be established before any of that evidence is submitted. I don't find that it's an opening of the door, and I'm going to rely on what the Florida Supreme Court has told us to do.
Judge, I've got to get the clerk to mark some photographs, and then my client and I need to take that suitcase out of that box and inspect it, play with the zipper a little bit, and then also take that bat out of that paper bag and inspect it. before she testifies.
Any response?
I'm just confused why we haven't utilized the nearly half an hour or more that the court has been off the bench to get these photographs marked. The defense team has been on board for quite some time. They did not request a second evidence view of the physical evidence that Ms. Boone already had an opportunity to do while she was pro se. It's 11:25. We need to try the case.
Judge, I think that she had that evidence view, I think with Billy Lane. I believe that was the day after I filed my notice of appearance, or maybe it was the day I filed my notice of appearance. I don't remember exactly, but it had already been previously scheduled. I was in Milton, so they went ahead and did it that morning I believe at the jail. I believe the evidence.
Any particular reason why this hasn't been done in the last 45 minutes?
Because
When I sent my jury out?
I've been meeting with my client about
Okay.
her rights to testify or not, and other related matters. So in terms of not giving her this evidence,
In terms of anything that the state just discussed?
I've just been busy with my client.
Okay. How much time do you need in order to pre-mark these exhibits and look at the baseball bat and the suitcase, which have been entered into evidence?
I would think 15 minutes.
I'm very concerned because it is 11:25 and I discharged our jury some time ago, and I don't want to be in a position where we have to break in the middle of testimony.
May I suggest that we just take an early lunch? It's 11:30. Let's take an early lunch. We've got witnesses coming this afternoon anyway. If her testimony ends before 5, we've got 1 or 2 witnesses that are here. And then I believe tomorrow is Wednesday. We've got Dr. Brannon. It's going to be here first thing Wednesday morning. And then I believe Dr. Harper's not going to be here till Thursday morning. So we're going to have a little gap in time unless we've got to put on several officers about prior acts and all that. But I think for purposes of this, Judge, in the abundance of caution, I feel like I need to go over this evidence with my client before she testifies. And I have not had a chance to view that evidence other than seeing it here today. But I think I need to do that with her before she testifies.
Okay, can the parties approach for a moment?
Okay. Much like August 30th 30th, 2024, when James Owens Esquire filed with the court his notice of appearance announcing that he is Sarah Boone's attorney. This is now and was then and continues to be an absolute dumpster fire of utter, complete, and total poppycock. This is ridiculous. The jury has been back in the deliberation room since 10:22. It is now 11:30. It has been more than an hour. It's been an hour and 8 minutes for those of you who are doing the math, that they've been sitting back there waiting. In that hour and 8 minutes, how is it that he still hasn't reviewed the baseball bat and the dadgum suitcase? And now he wants to take an early lunch. This is ridiculous. Absolutely ridiculous. We know you don't want to put your client on the stand. We all can see this for exactly what it is, which is a stall tactic. Period. Sarah's going to be a terrible witness. She is going to Boone out on the stand. I know it, you know it, Everybody in the gallery knows it. All the people watching on my stream, on various other streams that are going on right now, that we all know it. You don't want her to testify. However, she has to testify. Even if they were, all of this was not in question, whether she would be allowed to present the battered spouse syndrome defense. Even if the judge had already allowed it, and this was something we knew at the beginning of the trial, that at the beginning of testimony, that this was going to be their defense. Okay. She's going to have to, she would have had to testify, because it's essentially a self-defense case, and the jury needs and expects to hear from the person who used the self-defense. Okay. You know that you have an insurmountable amount of evidence to overcome with your client. And I don't think she's capable of doing it, because the truth is just the truth. The truth of the matter, the truth of that evening is right in those, and they're not videotapes. They're just videos from her phone. Okay? Videos from her phone. That's where the truth is. Period. And I know that it's going to be very difficult for you to get her on that stand and get her to say words in some magic combination. They're going to make the jury forget about what they saw and heard on that video from her phone that she took, where you can hear her voice in the background taunting the victim as he pleads to be let out of the suitcase, as he pleads and tells her he cannot breathe. She's continuing to taunt him, and he tells her he's being serious. He's not playing. We all heard it. I'm over it, man. I'm over it. We're all waiting. And the next thing, let me tell you what's going to happen. Let's say the judge agrees to this early lunch situation. Okay. Early lunch is going to happen. They're going to come back whenever they come back from the lunch. It's usually an hour and a half that the judge gives for lunch. So an hour and a half would be 1 o'clock. All right. And Owens is going to have another excuse. Well, Your Honor, we didn't get to do it because the bailiffs, or the officers of the court, the sheriffs, they decided that Sarah needed to have lunch. And Sarah wanted to eat because she didn't want her lunch to get cold, or her milk to get hot, or her juice box to get hot, whatever it is that she has for lunch. I don't know, and I don't really care. Doesn't matter. There'll be another excuse. There'll be another delay. We already know that they don't have anybody that is going to be their own expert witness that's crucial to this specific defense. She's the one who evaluated Sarah Boone and determined that she had battered spouse syndrome. Can't even testify till Thursday. We're on Tuesday. For those of you that like to wear days of the week chones, undies, make sure that you're wearing the correct day. Your chones should say Tuesday. Yes, Violet. Violet asks, has the jury seen the suitcase video yet? Yes, they saw it yesterday. Now we're up here at the bench on approach. Waiting while Mr. Owens stalls. It's ridiculous. It's ridiculous, man. Mr. J, I would like to personally thank you for your patience and your professionalism throughout this entire dumpster fire of utter and complete poppycock. Thank you, sir. Judge Cranick, I would also like to thank you for your patience, your diligence, your professionalism during this whole shit show that we're all waiting on to start. I appreciate you. And a side note, I don't know what kind of socks you're wearing today, Mr. J, because the camera person didn't show us that view. I speak now directly to you, person operating the camera. I'd like to see what socks Mr. J is wearing today, but other days you've worn Halloween socks, which I personally appreciate. I'd like to thank you for that. I'd like to offer to send the prosecution team a charcuterie tray with Pop-Tarts for dessert.
It is 11:35. Councils have matters that they need to address with Madam Clerk for the pre-marking of exhibits, and along with the review of the suitcase and bat, which were previously entered into evidence. I'm going to bring based on the agreement of the parties, I'm going to bring our jury panel in at this time, release them for lunch, give them a similar instruction to the instructions they've been provided earlier, and we will commence promptly at 1 o'clock this afternoon. State, any disagreement with the battle plan so far? Same question, Mr. Owens. All right, let's go ahead and stand by, bring
Oh
back
my
in our panel.
God. Let me fix this. You know what? I probably am just going to, I don't think I'm going to end the stream. I'm just going to keep going for an hour. We'll just, hold on. Let me see something really quickly while they're on lunch. I'm not going to end the stream. That's ridiculous. You've really inconvenienced me, Mr. Owens, and I don't appreciate it. I'm done with you. I want to see something really quick. Maybe I will, maybe I won't end the stream, depending on something that I'm looking at right now. Hold on. Here we go.
State, do you recognize our jury?
Yes, sir.
Defense, do you recognize our jury? I thank you all can be seated. Members of the jury, again, once you're seated and comfortable, if you could raise your hands to confirm that you complied with the court's instructions. All right, thank you very much. Thank you for your patience. Matters with counsel took a little bit longer than we anticipated. We're going to take an early break today. It's 11:35. We anticipate the defense putting on a case this afternoon, and we don't want to get into it and then have to break a half an hour into it. So we're going to go ahead and take that break at this time. I'm going to give you a similar instruction as I've read to you over the last couple of days. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors, do not watch local news or read local newspapers. Jurors must not have any discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices.
Okay, I'm going to leave it to you guys. The Leilani Simon trial is on their morning break. They should be returning any moment. The two witnesses from the company that owns and operates the waste management collection in Savannah are now, I believe, finished testifying. Would you guys be opposed? What would you rather do? Would you rather Hold on a minute. Would you guys rather that I switch over to the Leilani case? Because I think that after those witnesses from Waste Management, they intended to call Red Craig, or would you like me to just end the stream completely and start a new stream at 12:45? It's up to you guys. I see Chloe has answered yes. Let's switch, says Alexander. Yeah, hang on just a second, Caleb. I'll drop it for you. Give me just a second. Here you go. Nightbot is going to drop it. Okay, so let's switch. All right. Un momentito, por favor. Let me delete this broadcast the stream that I set up. All right, we're just going to continue. All right, give me just 1 second. Let me go over here. Ugh, I can't handle that music in the background. Let me go over here to YouTube and let's switch. Wait, that's too many. We'll see what's going on over there with Leilani, because I do believe that Mr. Red Craig is supposed to take the stand. Let me get the stream for you guys. Hold on, I think it's in. Let me just do this. I don't know why I don't start this way. Let me see something really quick. Let me do this instead. I like their feed better. Okay, here we go. All right, they're still currently on a recess. I prefer Court TV's audio to Law and Crime. The only thing about Court TV that I am a little slightly apprehensive and or slightly annoyed by is that they tend to start a little bit behind when, even though there's already a delay of the stream by 30 minutes between the court, what's happening in court and what goes out to YouTube or whatever, wherever else you're watching. Court TV is a little bit delayed past that. I want to say they're delayed like a couple of minutes. So we will work with it. Trulia, I did see that as well. Trulia Beach says, I did see a comment from Billy Joe herself a couple of nights ago, and she said she wasn't testifying. I had seen the same comment. I don't really know. I don't really, frankly, if I'm being, just keeping it 100, I don't really see the need for Billy to testify, to be honest with you. I don't know what she could testify to that hasn't already been shown in court. For example, I think that the state has established that Leilani Simon is a lying liar face who tells lies, who lives on Liar's Lane. I think that's well established. I think that she has changed her story multiple times. There is one thing that I do want to discuss with the respect to changing the story. Something that we learned in the testimony from Special Agent Solomon yesterday when she was on the stand. And that is that Leilani sent her a text in which she claimed that it was not her that was driving the vehicle that was seen on the various cameras at the Azalea trailer park. She is not the person who left the home that evening. That the person who actually left the home that evening was Danny. Now, back when all of this was going on, okay, back when the news story broke that Quentin Simon was missing, all the way through until Quentin's body was found at the landfill. Okay. There were lots of live streams being had. Billy Joe had come up on some panels. Leilani, while she wasn't like on the actual panel, it was Billy Joe who was on the panel. Leilani was frequently in the background or sitting next to Billy Joe speaking as well. And there was a lot of I don't want to say, there was quite a kerfuffle surrounding Danny's involvement or lack of involvement. Okay. And I could not understand why people were blaming Danny. Okay. I didn't really understand beyond the fact that he had gone to Atlanta for a couple of days. Beyond that, there to me it didn't seem like there was anything else that would substantiate those accusations. I could not understand it. I could not figure it out. Okay, but yesterday when she testified, when especially the FBI special agent, Miss Savannah Solomon testified, when she explained about that text, then I understood. Okay, because I believe that if Leilani was bold enough to text an FBI agent that cockamamie bullshit story, that she was also bold enough to tell that to some YouTube creators. And so that is, I think, where that came from. And I feel like, that is something that is important to understand. So, okay, let me add this to the stage. Looks like we're getting a fantastic view. Let me put my golf announcer voice on. All right. The cameras are up in the courtroom in Georgia versus Leilani Simon. Now we're looking currently at the state seal of Georgia, where before we had a fantastic and lovely view of the ceiling. It looks like it's in fantastic shape, freshly popcorned. It's got recessed lighting, which aesthetically I don't care for. I think it's a little dated, but who am I to judge? I'm only a Florida taxpayer. I'm not a Georgia taxpayer. So I can't really, demand a change in aesthetic. I just think it's a little dated. I think we should be resuming testimony shortly. If you're just joining us, currently we have switched from the Sarah Boone trial because Mr. Owens has pulled yet another BS card out of his back pocket and now claims that even though the jury was out for an hour, that was just not adequate time for him to discuss the suitcase and the baseball bat. Wasn't enough time for them to view it in an hour and 8 minutes. They requested an early lunch. So currently they're on lunch break in Florida versus Sarah Boone. They will resume testimony, hopefully putting Sarah Boone on the stand at 1:00 p.m. unless Mr. Owens pulls another stall tactic, which at this point I am confident he will pretty much try. Probably something ridiculous, such as, well, Your Honor, we were discussing some things and we were just about to view the suitcase and the bat, which I've asked 3 times to view, in that hour and 8 minutes that you sent the jury back to the deliberation room. And yet somehow I have not managed in that hour and 8 minutes to do it, even though um, this even though we could see from the courtroom view, because cameras at no time went down, that there was quite a bit of time between them, Sarah and Mr. Owens being back in the courtroom after discussion. There was at least 5 to 7 minutes, at which time they were just sitting there waiting for the judge to get back on the bench. And yet at no time, even though permission was granted by the judge, at no time did Mr. Owens at all say, hey, while we're waiting for the judge to get back on the bench, let's go over and view the suitcase and the bat. Because that would be way too much like common sense. And heaven knows, common sense has zero place in a trial. That is ridiculous. And I don't even know why I'm upset, because it's clearly not a huge, big ass waste of time. No. This is all perfectly normal. He's just looking out for his client. Like, I'm over it, bro. I'm so over it with him. I've had enough, man. You know? Now I need to change my banner because the banner makes no sense. So now we're just hurrying up and waiting. I've decided that rather than starting an entirely new stream, I will just sit here with you good folks who've been patient with me, who don't mind if I have technical difficulties, don't mind if sometimes while there's testimony and then they approach the bench, there's no talking, because this case, the behavior of the defense attorneys in this case has incensed me to such a point that I need to remove myself from the office and adjourn to the smoker's lounge in the Florida room on the back patio. And sometimes there's a break and there's just silence because that's what I'm doing, and have to haul my cookies back to the office. You guys don't complain. You're supportive. You give me the thumbs up. You're just fantastic, and I can't thank you enough for that. Thank you, Kathy. Kathy says, thank you for doing this for us, Jen Lou. I appreciate you. Well, thank you, Kathy. I appreciate you guys. You're amazing. You're incredibly supportive of me. I'm just so grateful for it. We've been waiting a long time for both of these trials, to be quite honest. Although I will say, as it pertains to Sarah, to Leilani's trial, I think obviously just logistically, time-wise, we haven't been waiting as long because this happened, 2 years ago. Okay. But hang on just a second. What is happening here? But anyway, 2 years is definitely less than almost 5. I think everybody can agree on that point. But because most of us followed what happened to Quentin Simon from the very beginning, from his first reported being missing all the way through, and we saw so much in the interim, 2 years feels like a lifetime to wait and find out what ultimately happened to Quentin Simon on that evening. And, I myself have, really gone back and forth about how I am going to, not as a person, like just as me, Jen Lou, but as a true crime creator. I don't like that word, but as a person who covers true crime on YouTube, that's much better. who has been streaming this trial, who did talk about Quentin, the case. But when there wasn't anything new to speak about, I stopped. So I've really questioned how I'm going to handle the medical examiner's testimony, and and whether I will live stream it or watch it live, yet refrain from live streaming it because it's a very sensitive topic, and I think what I'm going to do is likely live stream it because I want to give you guys that are following this case and that follow me a place to be when it happens. And I feel like similar to the medical examiner's testimony in the in Letitia Stauch's trial, when the medical examiner testified to what ultimately happened with Gannon and how what he ultimately suffered. I think that if I had watched that alone, I think it would have been exponentially more difficult. But because we were going through it together, it made it a little bit easier. And so I think, hang on just a second. I think that's what I'm going to do this time. I want to give, everybody, that I want to have a place for us all to be and get through this. I have zero idea what's taking so long. Let me just check one thing briefly, because like I said, for whatever reason, Court TV tends to be behind a little bit with Law and Crime, although Law and Crime is also not showing anything. So I'm not sure what's happening, but whatever it is, we're just taking a little teeny tiny break. So I just want to thank you guys all so much for being here. And I couldn't do it without you. Christina J says, Jen, I really appreciate you covering this stuff. These trials are not the same without the community you have created for us. Thank you. Thank you so, so much. I appreciate that very, very much. Thank you. Let's see what Carolina Hurtado has to say. Once again, Owens pulls a delay card out of his bum. He's so dang rude. He and Sarah make a good pair. You know what? They both make me so dang mad. They make me mad too. I agree with you. I think we're all feeling that that level of frustration. Just so you know that whatever happens between, it's almost 12 o'clock p.m. currently. All right, we're like 1 minute shy of 12 o'clock. Whatever happens in this, with this testimony in this trial, which is the Leilani Simon trial, whatever happens at 1 o'clock, I don't give a rat's fat kneecap what is going on. I'm going to switch to the Sarah Boone trial because, that's what the stream is about. We're just taking a tiny little break right now. We're having a little diversion from Boone because Mr. Owens, I'm so over him, man. I'm so over him. I cannot believe he did this. I don't know why I'm surprised. I just, for whatever reason, like I guess I shouldn't be surprised. Honestly, I shouldn't be. I really shouldn't. And maybe some of my frustration is actually with my own self because I am surprised and I'm having such a clearly, I'm having a bit of a tantrum. I'm having a bit of a moment because of it. I just feel like I prepared more for this day than her attorney did. All of her attorneys, quite frankly. And I guess I feel like, oh, really, Squirrel? That's so cute. Lego is coming out with Gannon's favorite character. like Sonic? Are they coming out with a Lego Sonic? That would be amazing. I would get that. I would get that. And you know what? I would get that. And I bet you, I wonder if Lego is going to donate some of the proceeds to some charity in Gannon's name. I hope they do that. That would be a really cool thing to do. But yeah. Well, that's true, Scott. I have been covering this case longer than Mr. Owens. That is a fair and accurate statement. However, one thing that is similar in between Mr. Owens and I is that we both chose to cover this case. So there you go. He chose to be there. He chose to come in at this late hour. He knew that there was at least a possibility when he filed that motion for continuance that the judge was going to stand firm, especially because in the actual order itself, which was ordered on June 28th, 2024, he expressly wrote in that order that a new attorney taking this case would not be grounds for a motion for continuance to be granted. So he had, Judge Cranick gave every attorney that might have even considered taking this case for Sarah a heads up. He still filed it and then proceeded to act shocked when it wasn't granted. So over it. All right, Lil Red, take it easy, babe. They had to have. Crime Crochet Coife says, and we're 100% sure that her attorneys are real attorneys, like past the bar and all the things. They're not cosplaying. Yeah. They've passed the bar. They're attorneys. I don't know what's going on. Like, I know that this is part of it, this hurry up and wait, things come up, right? But in this instance, with Sarah Boone, we haven't there can be a delay sometimes in trials because best laid plans and everything, and you've called the witnesses that you intend to call, right? And the next witness you thought was going to be after lunch, but you finished early, okay? Or something comes up in the testimony from one of the witnesses that there needs to be an in-camera hearing outside of the presence of the jury. That's what that means. So those things happen during trials, right? But not this. Not like this. Absolutely ridiculous. Now, with what's going on with Leilani Simon, it's quite possible that the testimony from this morning went faster than the attorneys anticipated. And so the next witness that they intend to call has not arrived. They're running late. Let me tell you something. I don't know how it is in Savannah, but I do know how Atlanta Metro traffic is. And it is terrible at any time of the day. It really does not matter. When I was there, one of the things that I noticed is that there is a posted speed limit, right? And there's a posted minimum speed on the highway, okay? Now, mind you, I am from Texas. I've lived there the majority of my life. I moved there when I was 10 years old, okay? I have never in all my life ever seen anybody going the posted minimum speed on a 4-lane highway in my life. However, in Georgia, that happens all the time. And not only are there drivers on a 4-lane highway, driving the posted minimum speed, which mind you is 45 miles per hour, they are in the far left lane. Far left lane. Not acceptable at all. And for a person such as myself who sometimes can be an angry driver, I don't drive. Mainly what I mean by angry driver is like I don't cut people off, I don't brake check people, but I have been known to yell in my vehicle, not at people, just like, because usually the windows are up, but I'm just screaming. So I'm sure to the casual observer, they can't tell whether I am yelling at the traffic around me or I am just a very emphatic car singer. Who knows? But that's how I drive. I've never seen anything like it, Victoria. I've never seen anything like it. Victoria says, I live in the metro Atlanta area, both under and way over the speed limit. It's nuts every day. Yes, and frequently the both under and way over the speed limit happen to be in the same dadgum lane. You know, it's a lot. It's a lot. It's a lot. So I'm not exactly sure what the delay is here. Now I kind of, every time I make a plan, like, I'm just gonna, maybe I should end the stream. No. Let me just keep going because I don't want, let's just keep going. We'll just go check out what's going on in the Leilani Simon trial. They've been on a 15-minute break, and they're at the point I switched over. They were on the 14th minute of a 15-minute break, and once again, here we are. And I know that if I go over to the stream right now and I rewind back, the minute that I rewind back to see what the testimony was prior to the break, the testimony is going to resume. That's how we are in Texas. See, in Texas, the way you drive is, except for certain spots. Okay, Pantego, Texas, which is like a little tiny suburb, sort of in between like Arlington, Texas, and Mansfield. You never speed, ever, in Pantego. If the speed limit is 45, do 44. Okay, just to be on the safe side, but definitely do not do 46. Not 1 mile over the speed limit. That is a huge speed trap. In Texas, we refer to the speed limit similar to the pirate code. Not really hard and fast. It's not really a rule, right? It's like a guideline. It's a suggestion, That's how they are in Texas, and a little bit in Florida too. Although it depends on where in Florida that you live. The more touristy, I guess that's not really a word, but that's the word I'm going to use. The more touristy where you live is, obviously driving it depends on the time of day, and it also depends on the time of year. So currently, this being October, almost November, this is when the snowbirds start coming. And that's a different kind of driver because they're here for an extended period of time. They usually come around, October, November, in that general area of time. And then they leave like at the beginning of March before spring break starts. Okay. So they're kind of used to the traffic. They are kind of, they're extended stayers. Okay. So traffic's not too bad. Then you get to spring break. All right. And spring break is way different than summer tourist season because it's spring break. So it's a bunch of college kids, people here partying. It is what it is. But, they're not from here, so they don't understand. And, you know, you have to be very careful, especially like downtown Clearwater Beach, because, you know, even though there's crosswalks everywhere and they all, if there's a crosswalk, there's like a button that you can push so that the traffic has to stop. But it's a party, you know, it's a party atmosphere down there, you know, during spring break, and not everybody uses the crosswalk. So it's, you know, you have to be really careful driving in downtown Clearwater Beach at that time. So yeah. Yeah, so that's what's going on. Pewee suggests that instead of Boone out, we should say Paulson out because Brian and her son didn't hurt no one. But Sarah and one of her brothers are entire pieces of crap. Yeah, but you're right. You're probably right. But, you know, I'm so used to saying Boone now. You know, maybe I won't say Boone out. Maybe what I'll say is Sarah's going to Sarah. That's what I'll probably do instead. You know, a couple of times when I was searching the Orange County Clerk's website, instead of her last name Boone coming up, the last name Paulson was coming up as a suggestion. And it reminded me of Sarah Paulson from American Horror Story. And I was like, did Sarah Paulson do something down here in the Floridas that I don't know about? So yeah, I have no idea what we're waiting on. And I'm so hesitant to, but there's movement. The camera appears to be shaking. I don't know what's happening. It's the camera shaking. Oh no. What's going on in Georgia? I don't know. I will tell you, and I hope I don't offend anybody. No, I'm not going to say it. I'm not going to say it. Because if you have to say, I hope I don't offend anybody, chances are you're probably going to offend somebody. So you shouldn't say it. And it has to do with drivers that have that I'm just going to say it. Fuck it. Here we go. Because I don't want to, like, that's rude to do. So I will say it's been my experience since I've lived in the Floridas that some of the craziest drivers, as far as tourists go, come from the Canadas. Okay. The Canadians are some of our craziest drivers on the Gulf Coast of Florida. I don't know about the East Coast of Florida, but on the Gulf Coast of Florida, the Canadians are easily some of our craziest drivers. And I have no idea why. I don't know why that is, because, you know, everybody refers to Canadians. They're so, you know, friendly and stuff. And they're just, I don't understand what happens when they get behind the wheel in Florida. You know, I don't know how they drive in Canada, but yeah. Oh, this is a good point that Victoria says. Thinking about Sarah, I wonder if deep inside she's afraid to be released from jail or prison because she has nothing to go home to. She killed her boyfriend, alienated her ex and son, and has no job. You know, that's a really good point, and one that we haven't really talked about. I mean, to be fair, we have not really, other than being irritated, annoyed, frustrated with Sarah, we really haven't talked about what happens if she gets a sentence that allows her to leave prison one day. And I would imagine that it's got to be on some level for her. She's got to be anxious about it on some level, right? As much as she would be excited to be released at some point, right? You know, she's 47 years old. She just turned 47 this month. She hasn't worked in a number of years, not just while she's been awaiting trial, right? When she's been, you know, held in the Orange County jail awaiting trial, but prior to that, she hadn't worked in a few years prior to even being arrested for this crime. And you know, she will have been convicted of a felony, a violent felony at that. And it makes you wonder what her hopes are for the future. Now, what I am given to understand, and let me say this, please take the next thing that I say with a huge truckload of salt. Okay, not just a grain, because it's very difficult for me to confirm this next thing that I'm going to say. It's my understanding that while the alimony in her divorce agreement is being litigated currently, that doesn't stop Brian from paying that alimony because it hasn't been decided yet. So it's my understanding that those payments are currently sitting in a trust. And so therefore, if it is determined that Sarah should still get alimony, then she will have that trust account. So, there's that. I guess that would be a good thing. So at least she'll have somewhat of, I guess, like a nest egg or something, Huey, this has been asked many, many times. What did she do for work before? The answer simply is, I don't know. And I don't know that anybody that doesn't know Sarah knows the answer to that. I've never seen it been asked of Sarah. I've never seen it been asked of Brian. Only the question has only been, did she work before? When's the last time she worked? I don't, Scott H says, wasn't she in HR? I cannot imagine that Sarah would be in human resources. I think just generally speaking, as a human, Sarah doesn't people well. I think that's just her makeup. I don't know what she did, to be honest. I really don't. So I don't know. No, I cannot imagine being her coworker, Pumpkin Sparkles
Okay,
Babies.
so we're back on the record in SBCR 22-0336-4J6. Council are both present at their respective tables. Ms. Simon is present with her counsel. Ms. Parker, I've had an opportunity to review the motion for immunity, and I am signing the order granting use and derivative immunity.
Okay.
Hand it down to the clerk, both documents down to the clerk, so they may be filed in.
Okay. I would imagine, let's just listen.
Weston, Craig Weston.
I'm going to rewind it just a few seconds.
Yes.
Oh, not volume. Dadgummit. Hold on. Sorry, you guys. All right. Let's play this again.
And hand it down to the clerk, both documents down to the clerk, so they may be filed in. And of course, that is regarding the witness, Weston, Craig Weston.
Red Craig, as we know him.
Signed and filed.
Yes. All right. So before we bring the jury out, let's talk about how we're going to proceed at this point. The state has made a motion to not broadcast or have recorded certain testimony. Mr. Dean, if you'll state the state's position.
What?
So we're objecting to any recording, audio or video, and broadcasting.
Oh
of the
my
testimony of
God.
Greg Weston and of Tim Weston, should he testify. We're objecting under OCGA 15.1.10.1, which sets forth the multifactorial test for granting or denying media requests. In particular, we are relying on the first two factors: the nature of the particular proceeding at issue, that proceeding being just his or their testimony, and the second factor, the consent or objection of the parties or witnesses. He has objected to us, and so we're relaying that to the court. Also, the sixth factor, the impact upon due process and the truth-finding function of the judicial proceeding. We think that, given his concerns about recording and broadcasting, we think that the truth-seeking function of this criminal trial will be furthered by not doing that in the case of him and Tim Weston, should he testify.
All right, thank you.
Ridiculous.
Your Honor, since we're just dealing with flat statements without any evidence to support them, my objection is the exact opposite of that. With the only two exceptions in the trial so far, one having to do with a minor child, which I think everyone agreed on, and the other one having to do with an agent who may or may not have testified that we didn't want to have their identity revealed for reasons, okay, that are enumerated, and again, not a great objection to. We don't have that here, okay? Mr. Weston is a civilian. He's not a minor. He's not under indictment. He's been granted use immunity. I'm sorry if the things that he's testifying about may be personally embarrassing to him, but I didn't call him as a witness, and the rules we've been playing under have been the same for everyone. I don't see, Mr. Dean baldly states, well, due process can be served by this. Well, I can baldly state that due process would not be served by it, and we're right back at the beginning of the analysis. So everyone in here has objected to the media coverage thus far, every opportunity we've been given. So I'm not saying this because I'm any great fan of having cameras in the courtroom, because I'm not, okay? I am saying this, though, that the rules that we've been playing by, every witness has had to come in here and testify so far, with only those two exceptions, have had to testify in front of the cameras. So I think Mr. Weston should have to as well. I'm sorry if he finds it embarrassing or he doesn't like it, but other than that, he has use immunity. So any potential legal ramifications are out the window at this point. So I think that use immunity promotes due process and fairness more than anything. Other than that, we're just talking about his own personal embarrassment, and that's not one of the factors, Judge. So we object.
Agreed.
Mr. Dean, looking at considerations 1, 2, and 6, is there anything particularly about the nature of the particular proceeding at issue? What can you tell the court more about that in your objection?
This witness is likely going to be asked to touch on private sexual matters. It's one thing he is a private citizen. He is likely going to be asked to touch on private sexual matters. He's testifying under compulsion and under a grant of immunity, and might also be asked about perhaps about criminal activity for which he will never be tried.
So then what's the big deal? Put his ass on the
and
stand, turn the
will
cameras
therefore
on, and
never
let's
be
go.
Vetted in a court. And this is the same reason that the federal government doesn't name unindicted co-conspirators in indictments, because unindicted co-conspirators are never going to get a trial and an opportunity to flesh out the truth or falsity of the allegations against them. There's sort of a parallel thing going on here with him. And as to, so I think that's enough factually to state that, and that goes to the nature of the proceedings. As to the objection issue, I mean, I'm just proffering and stating in my place as an officer of the court that he objects, and he objects strongly. He can,
And you've cleared up a question I had in my mind. So
may I say one more thing? I'm sorry.
you sure you want
If not, that's fine. You're not going to hurt my feelings. I'll sit down.
What do you want to say, Mr. Dean?
I was just going to say that this idea that the court's decisions about recording or broadcasting the trial at large and the testimony of other witnesses, and that there ought to be some, there's like a principle of consistency that ought to control here, just seems to me to be totally at odds with the multifactorial, fact-specific, witness-specific tests set forth in the
Are you
code.
saying that's what the court is doing?
No. That's what I took Mr. Hilliard to be urging the court to do, is to apply a uniform rule for all witnesses and all the subject matter of the trial. And I just don't think that's what the code section calls for.
Mr. Dean, I
Yes.
know you're about to go on, and
If
you
you
don't,
like.
you don't, you don't
If you
need to.
like.
You
Okay.
will,
Okay.
you will, and I don't need you to.
I do have something to say about that. You asked about the nature of the proceeding, so this is kind of a different thing, and he gave an answer to it. I'm going to see if I can summarize Mr. Dean's argument. We've hauled in a witness by compulsory process. We are offering this witness. We have given this witness immunity, and we've subpoenaed them into this murder trial. And now, because he feels some kind of way about being embarrassed, that we're going to change the rules for this witness, which is all what they've done. So I don't understand how you can create the problem, cement the problem, alleviate the problem with this particular witness, and then think that, I'm the one who's objecting to it, and I'm the bad guy, because I think this guy should play by the same rules that every other person they've done the exact same thing to has had to play by the entire trial. I don't see there's anything unique about the nature of this particular.
I agree.
I don't see there's anything about this particular witness that makes it relevant or necessary to turn the cameras off. And I don't say that because I want them on.
I'll tell you in a
I say
minute,
that
Ivy
because
Lease.
I don't see a reason to carve out an exception for Mr. Weston. He's not that special.
He's not.
That's the reason why I'm objecting to it.
They wanted him, put him up there. Let's go. Let's go, Red Craig.
Rules are here to guide us, and 15-110 is here to guide us with regards to videotaping and televising and recording. I do think there is a balancing test. There are several conditions that are listed, things that the court should consider and hear from all parties. All situations are a little bit different. And in taking this case in particular, and the state's objection, I'm going to grant.
Oh my God.
I'm not going to require Mr. Weston to testify with the cameras on. I think that Mr. Dean gave an argument for, one, the nature and particular proceeding at issue that helps satisfy the court.
What about
He
audio?
also stated condition 2, but condition 6 I find is very persuasive. The impact upon due process and the truth finding function of the judicial proceeding. Given what the particular scenario is with this witness and some of the factors that play in, I am going to require that cameras not roll and that it not be recorded. Of course, the fact finders who are here will still be able to hear all of the evidence. They will be able to see him. And anyone who's in the courtroom will be able to hear from him. This is still an open courtroom, although in my discretion, I am not going to allow this witness testimony to be broadcast.
That's absolute
Okay.
baloney.
And so with that, is there anything else that we need to take up before we bring in the jury? What I anticipate is Detective Lemons. Detective Lemons is going to be called next. And then after her, after Detective, then Mr. Weston is going to be called. And I would
Fine.
ask that you cut the camera footage and recording at that time.
And just to clarify, that would be audio as well as video.
Yes, ma'am.
Thank you.
Yes, sir.
This is absolutely ridiculous.
Could we describe this testimony as reporters
Yeah.
talking about what's happened in the day or no?
This is an open courtroom. We're just not recording and broadcasting that portion.
Thank you.
All right, well, that's fine.
All right, so we're allowed to quote.
This is ridiculous, so.
Direct quotes, that's fine.
Yes. All right. Please bring in the jury.
I'm upset by this, and here's why. Because I don't think what this evidence wasn't going to come in initially. But for Mr. Dean making an argument, a good argument. It started with the texts, and now we're beyond the texts and we're into the actual testimony. Now, I don't give a rat's fat kneecap. I agree, and I can't even believe I'm saying this, but I agree with the defense attorney. He's a private citizen and he's not a minor. Fine. Don't film him. All right. We don't need a visual. That's cool. But we ought to be able to hear what he says. That's how I feel. At the end of the day, though, let me just say this. To the judge's point about the fact finders of this case, which is the jury, they're going to hear and see his testimony. And at the end of the day, that's really what matters. As annoyed as I am, we're going to hear from Detective Lemons. We'll be hearing for Detective Lemons for a few minutes, for, a little while before we get back to Boone.
Hey, you may call your next witness.
Marion Lemons.
I myself need a little moment. I'll be right back. I'm here. I can listen, but look, how much more personal can it get then? Obviously, we're going to be hearing details of what the prosecutor has described as she banged her drug dealer. Whatever. I'm over it.
One more time for good measure.
Yes, ma'am.
All right, you testified, feels like a long time ago now, about the defendant's October 5th interviews at Chatham County Police Headquarters, right?
Yes.
And over the course of that day, she disclosed 2 trips away from the residence on the night of October 4th, morning of October 5th.
Yes.
And on that day, what was the story as to the first trip, the earlier of the 2?
She described going to the Flacco's Tacos to meet up with a gentleman she knew as Red.
To do what?
To pay back a drug front.
Over time, I guess by October 12th, in the interview with Special Agent Snyder and Special Agent Solomon that we watched more recently in time, did that story change?
Yes, it did.
How did it change?
It moved from meeting Red for a drug front at the Flacco's Tacos into meeting Red/Craig on Arkwright to buy cocaine and Percocets.
What do you mean by Red/Craig?
She told the interviewers that Red is Craig in that interview.
Okay, same person.
Yes.
Okay. As early as October 5th, you had thumbed through her phone, right?
Yes.
And on that day, did you did you, at some point, did you see messages in her phone between her and a contact saved as Craig?
Correct.
When do you remember first seeing those messages?
I believe I mentioned them on October 5th to her.
Okay. And did you ask her a question about Craig that day?
I did.
What was the question that you asked her?
I think I asked her specifically, who is Craig?
Did you ask her whether there was anything going, what did she say to that, if you remember?
I believe she referred to him as an older white male that was not red.
And it was on the 12th that she said, actually, Craig and Red are the same person.
Yes.
And it's an African-American gentleman, right?
Yes.
Okay. On the 5th, you had seen messages between her and a contact saved as Craig, right? Day
Yes.
one. And did you ask her whether there was anything sexual going on between the two of them?
Yes, I did.
And what did she say about that?
I believe in that specific interview, I don't fully remember what she said.
Okay. At some point in the investigation, did she deny that, though?
Yes, she did.
Okay. You later received a copy of her cell phone extraction, correct?
Yes.
And did you select and export from that cell phone extraction all of her communications with the contact saved as Craig?
Yes.
Do you see in front of you State's Exhibit 91?
Yes, I do.
Can you tell us what that is?
So this is an extraction report of all communications and anything that has to do with the user she has saved as Craig.
Your Honor, I would introduce this as State's Exhibit 91.
No objection.
Submit it.
Now, does this exhibit show when she first saved Craig as a contact?
Yes, it does.
And what was that date?
On September 16th in 2022.
Okay, so that would have been how long before Quentin's disappearance? Like a little less than 3 weeks, maybe?
Correct.
Okay. In moving forward from that, is there a series of text message exchanges between the two of them leading up to October 4th?
Yes, text messages and phone calls.
Okay. And does this document include all of them?
Yes, it does.
Before we get into, reading individual ones and describing when they were sent and received and so forth, let me just ask you, can you kind of summarize what these communications show as far as what was going on with the two of them, between the two of them during, say, late September, early October?
So pretty much from when Leilani saved Craig into her phone, it appears that they began a sexual relationship and were scheduling meetups to meet and have sexual intercourse.
And where was it that they appeared to be meeting?
At his place of residence.
And where is that?
Off of Arkwright.
Okay. On Arkwright Road?
Yes.
Off of Highway 204?
Yes.
Okay. And I think you testified earlier that you identified Craig as Craig Weston of Arkwright Road.
Yes.
Okay. Let me draw your attention to a few of these and have you talk us through them, okay?
Okay.
Can you go to line 7?
Yes.
So this thing is like, we've had some of these bubble style exports. This is a table style, right?
Correct. Yes.
It's just a different way of pushing text messages out of the Cellbrite extraction.
Yes.
Okay. Line 7. Can you walk us through this message, including like the date and time and who sent it to whom and what it says?
Okay. So again, these are only from Craig and Leilani. So this one's from Craig saying WRY, which is commonly known as Where Are You? On September 25th at 2:24 a.m.
All right. So middle of the night.
Yeah.
All right. Line 8, can you just kind of walk through these from that one through line 16?
Okay. So the previous message was at 2:24 a.m. The next one is from Leilani at 2:25 that says, I'm home on Buckhalter. At 2:25 from Craig, hello. 2:26 a.m. from Leilani, I can come I can come back out there at 2:38 a.m. from Leilani on the way. And then at 2:46 a.m., Leilani sends a video message. This is a thumbnail of the video that she sent, and it appears to be of a trailer from inside of a vehicle.
Now, you've been to Arkwright Road
I have,
and you've seen the structures out there.
yes.
Does this appear to show that she was present there at that time?
I believe it's the back part of Arkwright.
Okay. And that was at 2:46.
Correct.
So it looks like she's there at that point.
Yes.
Okay. Moving on to line 13.
So at 2:48 a.m., Craig says, "Okay, 1 minute." And then it skips to 5:55 p.m., so several hours later.
That would be like 13 hours later or something like
Yes.
that. Okay.
Craig asked, "You okay today? You man here?"
And how does she respond to that?
At 6:54 p.m., she says, "Yeah, I'm okay. He's on his BS today, and I don't feel like arguing." And then in response, at 6:58 p.m., Craig says, "Okay, well, was thinking about you."
All right. So is that set of messages that we described, does that appear to be the first visit by the defendant to Craig that we see reflected in this set of messages at least?
That's correct.
Okay. Now, I'd like to go forward to line 62 on page 5.
Okay.
And if you could just do the same thing for 62 through 76, go nice and slow with the times and everything.
Okay. So this is on September 26th at 11:59 p.m. from Leilani. On the way now, be there in about 12 to 14 minutes. At 12:04 a.m., Craig initiates a phone call and they speak for 53 seconds. At 12:05 a.m., Craig says, "Okay." At 12:06 a.m., Craig says, "Okay, I'm in back to my camper. Stay close to your left. My dog gonna try eat your car, but he won't."
And the next one?
At 12:16 a.m., Craig says, "Hello." At 12:16 a.m., Leilani says, "Okay, I'm passing Quaco now." At 12:17 a.m., Leilani initiates a phone call for 19 seconds with Craig. And then at 12:21 a.m., Craig says, "Door open." Then skipping to 1:22 a.m., the previous was at 12:21. Leilani says, "I'm home. I loved those hugs."
I'm home. I love those hugs.
Yep.
All right. So based on when she said she was passing Quaco Road on the way there, and when she says, "I'm home, I love those hugs," roughly how long does it appear that she spent at Craig's place that night?
Roughly 45 minutes.
Okay. Moving on to line 41, when is this message sent in relation to the last one we just read?
Yep. So the last one was at 1:22, where she's saying, "I'm home. I loved those hugs." The following message is from Craig at 1:26 a.m. and it says, "Okay, not more than I did. I was about to grab that kitty one time."
What does she say to that?
In response, at 1:26, she said, "LMFAO, you most definitely could have!" Exclamation point. And then at
Do you think people generally know what LMFAO means?
It's laugh my fucking ass off, in case you didn't.
No. All right. 73, what's that? What does that one say?
73 is at 1:29 a.m. from Craig. "Shit, I sure wanted to, like I see how it looked, FR."
Try that one again, sorry. Read it slowly.
Yeah.
And before you do that, what date are we on?
9:27.
Early morning hours of September 27th. Okay. Go ahead with 73.
Yep, 73 at 1:29 a.m. Shit, I sure wanted to like to see how it looked. FR.
What does FR mean?
For real.
Okay. How does the defendant respond to that in line 74?
So 74 at 1:36 a.m. is a response from Leilani sending a video message to Craig of herself masturbating.
75.
75 is at 1:38. So after the video message, Craig says, "Damn, you just made me hard as fuck. Thank you."
And 76.
76 is at 1:39 a.m. from Leilani. Well, shit, I'm glad I did.
Moving on to 117. And this will be the last set that I'll ask you to read, okay? If you could take us through 117 through 131. Stop at 131, okay?
Okay. So it's on October 1st at 12:24 a.m. is the first message from Leilani. Dealing with Danny flipping his shit. As soon as I can leave here, I'll let you know. Craig responds at 12:34 a.m. K. And then at 1:14 a.m. from Craig, if you can't come out, it's okay. At 1:15 a.m. from Leilani, I'm about to head that way, just probably can only stay for a couple hours though. Is that okay? Then at 1:22 a.m., Leilani says, heading to the car now. At 1:22 a.m., Leilani says, be there in about 20. At 1:25 a.m., Craig says, well, you want to park at rideshare.
What is rideshare?
It's pretty much just like an empty parking lot about a quarter mile from Arkwright. It's commonly known in that area as the rideshare.
Okay, go ahead.
At 1:26 a.m., Leilani says, yeah, I will. At 1:56 a.m., Leilani says, just pulled into the rideshare. At 2 a.m., they have a 2-second conversation over the phone. At 2 a.m., Craig says 2 min, which is 2 minutes. And then at 2:01, Leilani says, okay.
All right, so per those messages, it looks like by shortly after 2 a.m. they would have been together then?
Yes.
Okay. And the next message, 129?
So that one is at 3:23 a.m. The previous was at 2:01. Craig's
almost like an hour and a half has passed or so.
Yes,
Okay.
more than an hour. That was good as fuck. I'll take that anytime. FRI, no, I made you come for a long time.
That was from Craig to the defendant.
Yes.
All right, the next message.
That one's at 3:56 a.m. from Leilani. I would be down to do that again anytime.
131.
At 3:56 a.m., Leilani says, and yes, you did for a good ass min. And then the following message is at 11:59 p.m.
So how much time has passed?
I mean, is anybody clutching their pearls? Like, come
Well
on.
over 12 hours.
Okay,
If
so
he's-
it's like
if-
the next night.
Yes.
If this is what he's going to be testifying to, I don't get what the BFD is. You know, like, I just don't. You know, I don't. I'm sorry. I'm frustrated, and I'm going to have to deduct some points, Mr. Superman Attorney DA, Mr. Dean. I don't know which portion of the pageant I'll be deducting the points. I'm going to deduct it from the portion of the pageant that carries the most weight, the interview portion. Be deducting points.
It is 10-1. So
Yes,
at
these are the
11:59,
texts.
Craig says, you okay? On 10-2 at 9:02 a.m., Leilani says, yes, I'm okay.
9 minutes to
She then
Boone.
responds, about to drive over there actually. At 9:46 a.m., Craig responds, damn, you was tired or I got rid of a lot of your stress. At 9:46, Craig says LOL.
Yes, be
At
frank.
9:47,
9 minutes.
Leilani
9
says, a lot of
minutes.
stress was released. I need that sleep. At 9:54 a.m., Craig says, that's good shit.
Okay. Neat Noodle says, the Ward case studies, do you think Red is an informant and doesn't want to be seen? It's possible, but at the end of the day, whether he's seen or not, I promise you that this has already made the rounds gossip wise, and it doesn't matter at this point. It's done. It's over with. The fact that he's testifying, the fact that he is testifying with use immunity and derivative immunity, it is what it is.
Leading up to Quentin's disappearance, that the defendant was getting male attention from Craig like 3-4 times, something like that.
It would appear so, yes.
And look, I don't even care about his face being recorded, although I'm mildly curious as to what he looks like. It's more, I'd rather hear his testimony. That's it.
Detective Lemons, let's talk about the text messages you didn't mention.
Okay.
Yes, let's do that.
Let's
Okay,
start on
fine.
page 1. So the contact for Craig was added on September 16th, correct?
Yes.
That's the first time that this appears anywhere in here to the best of your knowledge or in mine, correct?
Yes.
Right. Did you see anything to this number prior to that?
No.
Okay. So on the first page, instant message 6, if you would, did Mr. Dean ask you to read that one?
No, he didn't.
Okay. What does that one say? And who's it from and who's it to?
On 9:25 at 2:23 a.m., Leilani says, I needed a 50, but no one was there.
What is a 50 commonly referred to as? Is that a drug slang?
I believe it's just a number.
I needed a 50, but no one was there?
I don't know what she was intending there. I mean, I can assume it's drug lingo, but what exactly it is, I don't know.
Okay. Well, you seem to know what WRY meant.
That's not
correct?
okay.
And
Okay.
you're currently stationed at CNT, correct?
Listen, Mr. Sassy Pants defense attorney, please don't make me have to get on to you about this, but there's a difference between knowing what common chat slang is versus drug slang. Okay. For example, most people know what LMFAO is. LMFAO. Most people know what that means. Most people know what WYD means. Okay. Most people don't understand other lingo like nickel, dime, quarter, 1 gram, 1/8 of a gram, half of a gram. No, most people don't know that. Okay. So stop.
I am.
Okay. So using your experience and your knowledge as an agent over at the counter narcotics team, when someone says they need a 50, what are they commonly referring to?
I
I'm going to allow Mr. Hilliard his line of questioning.
Yep. So my understanding is almost everyone has their own drug knowledge. Usually when I don't know something, I'll ask one of the other agents there. So right now I don't know what she's referring to.
All right. So let's move on then. Look at
Christina says, you said BFD. I haven't heard that in a long while. My mama used to get on me so bad for using BFD. Thanks for that chuckle. You're welcome. And thank you very much for the super chat. I appreciate that. 5 minutes to Boone.
beginning with this.
Oh my goodness. Let's go,
And
bro.
Number 43. What was the reply?
From Craig, no, I'll check around.
And
I think the slang would depend greatly on the type of illicit substance you're discussing as well. So there you go.
number 52 at the bottom right there. Who's that from and who's that to?
That one is from Leilani to Craig.
And what's that asking for?
You got a half of tree.
And what is that referring to?
Believe that's marijuana.
And
Why are you looking confused, Leilani? Why don't you get up there and tell us what you meant by a fitty?
and the instant message that y'all are referring to was
3 minutes to
believe Mr.
Boone.
Dean
3 minutes to
asking
Boone.
about where it looks like, I guess they met at the ride share.
Is that a question, counselor?
What day was that again?
There you go.
I think it was October 1st.
I mean, what are you doing, bruh? Come on, these are your questions. Control. What you doing, man?
And does that seem to be when there was some sort of activity between the two of them?
Oh, you learn what no cap means, Violet. Low Red says the word case studies. You think Craig or Red look like are a look-alike of Debo or Day Day? I don't know. Maybe Big Worm. I don't think you applying yourself, Smokey.
I think it's the last page, but I'm not mistaken.
Okay, there's like 2 minutes to Boone, and I'm over the fumbling. We're going over to Boone. I'm annoyed. I wanted to hear those text messages. We heard those text messages. Although, at the end of the day, I can't imagine that. What the heck? I cannot imagine that the testimony is going to be more salacious than the texts. I mean, what we're going to hear Red Craig say in his own words that he had a tango in the sheets with Leilani. I mean, okay. Ridiculous, whatever. That's right, Nadie. Big worm. That's how I feel about that whole testimony right now, currently. It's going on over in Leilani. Oh, wait, let me hide this comment. It's more effective. Let me do it in Peter's voice. Oh my God. Who the hell cares? That's how I feel. I don't think it was all that salacious. I don't understand. Like, I understand, okay, he doesn't want his face shown. All right. I'd be embarrassed too if I were Red Craig and I can't think of a euphemism. I'm tired. Whatever. If I was intimate with Leilani because of the charges that she faces. All right. Because of what she did. I would not claim that hoe either. I get it, Red Craig. I understand. All right. You don't want your face shown. Let's not show your face. That's fine. That's cool. We won't show your face. We ought to be able to hear your audio. I think that if a minor can take the stand and testify to the things that she witnessed, which in my opinion are far more difficult testimony to listen to and sit through than whatever it is you're about to testify. And because she is a minor, she wasn't to be filmed. That's fine. If she can get up there and do that, how is a 17-year-old kid braver than this guy? It's like ridiculous. I'm over it. Over it. I need to look at something really quick while we wait here. Okay, it's 11:01. Where's everybody? Hello? It's time. Where's Melissa Jade, who's supposed to be taking down bullshit Bindi says? Add this to the coffee table book, Melissa Jade. I get it, Red Craig. I wouldn't claim that hoe either. That's another one. That's going in the coffee table book. Mm-hmm. Okay, let me see what's happening here. That's not what I tried to do. Oh, Boone needs a toaster for her Pop-Tart. Oh. Well. Let me see what's going on over here. I got to check on some business real quick. Pardon me while I do that. I need to upload some music for the background, just, you know. Okay. All right. Looks like we're starting.
We are on the record. 20.
Oh my God. Shut up. See? This is why I don't like you, Mr. Owens. You don't even let this man finish his sentence. And here you go, interrupting. All right. While we're waiting, I'm going to drop some links for you guys in the chat that you might find useful. The first one I'm dropping is Nadine's link. She makes the best wax melts on the planet. I'm dropping Allie's link because she makes fantastic content, and she will probably be handling the recap of Red Craig's testimony with our in-court correspondent, Carol freaking Claus, over on her channel. I am dropping Melissa Jade's, I think it's just Melissa, hold on, let me check, link, because if you are behind and want to catch up on all things Wade Wilson that are respective of his latest situation he finds himself in with the wives and the money, Melissa Jade's is the place to check out. If you find yourself wanting to become a member of this fine establishment, here's that link. If you aren't sure and you're hesitant about joining memberships, you don't fancy yourself somebody who can make a commitment, that's cool. I'm going to drop my PayPal and Cash App link if you decide you want to give your girl a tip. There you go. Those are all the links that I have. She is dressed like a bruise. Carolina, she's wearing black and blue. And still, we've been on lunch. We've had all the breaks in the world, and this heffalump has still not fixed her bedhead. I'm hungry. All right, here we go. Mr. Owens, if you dare try to ask for more time, I'm telling you, write me out. I'm going to read you like a book like it is take as many books from the library as you want day. what's going on here?
We're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. Let me get appearances for the state.
Dave Castro on behalf of the state. William J. for the state.
Defense.
James Owens for Ms. Boone.
County Henderson from Ms. Boone.
Ms. Boone is seated at counsel's table, wearing the same black jacket and blue blouse from this morning. We will be standing when our jury enters. She is in custody, but out of any restraints. As she is testifying first, once we bring in our jury, she will walk to the jury box and be sworn in front of the jury. State, are we ready to bring in our panel?
Yes, Your Honor. I was able to get the redactions done. I put a disc on Mr. Owens' notebook there, has the case number on it and 3 black dots in Sharpie, just so that a random way of saying what it is.
Excellent. Appreciate it. Thank you for getting that done over the lunch hour. Defense, are we ready to bring in our jury?
I've got a couple of issues.
Yes.
Oh my God. I'm going to stop you right there. You see how Mr. J makes excellent, fantastic use of his time. It's the lunch hour. He should have been enjoying a leisurely lunch, right? Instead, what is he doing? Making redactions, working. Here comes Bozo with his issues.
Beck is working on.
Let the record reflect that Mr. Beck has appeared.
For the record, I'd like to make 2 points about this issue, about whether or not I can bring in evidence of prior acts, prior bad acts, prior to the overt act. And there's 2 reasons that I believe I should be allowed to do so.
Oh my God, this again?
One is, Judge, in that 2-minute video, Sarah Boone makes a statement, "That's how I feel when you choke me." And then some moments later, "That's how I feel when you cheat on me." And she's angry at him, and she's talking to him. She's talking to him in an intoxicated state, and she's expressing her anger and why she is angry. And I ought to be able to elaborate on what that is that she's angry about as it relates to when you choke me. That's my first motion.
Okay.
The second one is, Judge, on this.
Before you proceed with the second, is the second intertwined with the first?
No, I mean, it's a similar argument, but related to something else.
Okay, response.
Judge, I don't disagree that they should be able to bring that in once they've established an overt act that is imminently dangerous to an objectively reasonable person. I believe that's the law in our home.
Any other further arguments, sir?
Not on that issue.
Motion's denied. Court again is going to rely on the Supreme Court's guidance in these situations based on Holland 916 7 second 750 at point 760 through 761.
My second argument ties into what he just said about what a reasonable person would do under the circumstances facing an imminent threat, whether a reasonable person would perceive the overt act on the part of Jorge Torres that was witnessed by Sarah Boone. Would that be perceived by someone as a imminent threat? And to some degree, you have to understand the history of Jorge Torres and Sarah Boone. They were together 3.5 years. They were engaged, but there had been a history of violence. And from the evidence that's been presented, facing the circumstances in total, if you take what she said at various times, you would understand that she became concerned when he came back from Publix with that second bottle of wine, because she knew when Jorge Torres gets to a certain level of intoxication, he gets sad, he gets moody, and eventually he gets belligerent, and sometimes he can be violent. So she knew when he brought home that second bottle of wine that it was not going to be a good night. And she tried to keep him occupied and tried to keep his mind off of his troubles, because she knew that if he reaches a certain level and is dwelling on his hardships, that he will react to her in a violent way. So she had that state of mind with that understanding of her history and his history in his overt act, which she's going to testify to, coupled with the fact of her state of mind based on her past experiences with him in that intoxicated state and the fact that he is violent. So she was hypersensitive to danger and fear. And I think that ought to be allowed in as part of her collectively an overt act. So it was culminated by his state of intoxication coupled with his overt act created the well-founded fear for her to block the attack, to self-restrain or physically restrain Jorge Torres in the suitcase, to actually use the bat to prevent him from getting out of the suitcase because she knew she was going to get attacked.
And the basis of the opinion of about to be attacked is predicated on the prior incidences of violence, correct? Based on
Well, there's an overt
knowledge.
act committed by Jorge Torres, but she was heightened because she knows when he gets to that level of intoxication, and that's a scenario, and that's an issue.
So I need clarification. What is it that you're asking me to do?
For me to be able to elicit from Sarah Boone that she was concerned once that second bottle was brought, and that's why she tried to placate him over the course of the evening, and that's why she had a heightened sense that he was capable, Judge, due to his degree of intoxication, that he may act violently towards her. And the problem is, a lot of the problem is, Judge, he doesn't remember battering her the next day. That's part of the reason that she videotapes him and photographs him. She starts to document what happens so that she can show him. She loves the man. She adores the man. She wants to marry him. She wants a life with him. But she's tired of being beat on. And so that all ties into her behavior, her sense of nervousness at that point.
Let me get this straight, Mr. Owens. She was hypersensitive, right? And as soon as he returned from purchasing that bottle of wine, she became even more her senses became more heightened. She became even increasingly alert, hypersensitive, as it were, knowing his pattern of behavior, lamenting over his woes, as you put it. Is that why, after he returned from Publix, she had him call his brother and also his children? Because she was heightened and worried?
The reason she was so confident during that 2-minute video is because she knew, okay, this is my chance. He can't get to me. I can tell him exactly what he does that bothers me, that hurts me, and how I feel. And so that's all tied together with then he starts to try to get out of the suitcase, and she reacts the way she does.
Response.
We held these arguments already. The court has ruled there are no new arguments being made. The court understands exactly what Sarah Boone, the defendant, said to Dr. Werner on October 2nd. The court knows exactly what the defendant said to Dr. Harper over the period of a number of months and years, and there was no overt act. The overt act has to be something that is objectively reasonable to cause a reasonable person to believe there's an imminent fear of great bodily harm or death. What the testimony is not that that's what has occurred, that there's her new testimony is this generalized fear, but you've already read that and you've already ruled on that. And I'll just remind the court that her previous testimony is it's all fun and games. We're laughing. I zipped the suitcase shut. We're still both laughing. It's funny. And then the decedent says, I can't breathe. And then she flips a switch, gets angry because it reminds her of all the times before where she is asserting that the decedent made her feel like she couldn't breathe. And then that's when she starts beating and shuffling the suitcase so much that it flips over and hitting him with the bat. We've covered this ground. Aggravated assault, aggravated battery, 2 independent forcible felonies. She's committing false imprisonment. She is the initial aggressor after there being no overt act. She can't start it and then say, well, I'm in fear of retaliation, because that's what her testimony was, is once I started doing these things, once I wouldn't let him out of the suitcase, I was afraid he would come out and harm me or kill me. Well, Judge, if I pull a gun on you and I say, give me everything you own on you right now, and then you in turn pull a gun on me and say, bam, 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 and shoot and kill me, and I shoot, let me strike that. You pull a gun on me to defend yourself, and then I shoot and kill you. I can't assert self-defense. I can't say, well, Judge Kranick pulled a gun on me and I was in fear of death, because I was the initial aggressor. I was committing a forcible felony. That's the facts of this case here, according to her previous testimony. And the state concedes if she wants to change her testimony again, that's one thing, and then we'll cross that bridge when we get there. But if she testifies as she previously has, the court has already ruled there's no overt act, and you've read the transcripts. You know what she has said.
Judge, she hasn't testified. She hasn't testified. Dr. Harper's testified. Dr. Warner's testified.
They have not testified. They've given depositions.
Well, given depositions, but she hasn't testified about the act in question. She hasn't testified about the event in question. She had consultations and evaluations by Dr. Harper where they had discussions that Dr. Harper could relate in her testimony. Dr. Warner can say what was said during the evaluation. Again, both of those were not reported. There may be disputes. I disagree with his characterization of that assessment, but it's up to Sarah to tell the truth here today. She's under oath. She's under oath today. She's got an obligation to tell the truth. If he thinks she's made prior inconsistent statements, it's up to him to impeach her with those inconsistent statements.
To the extent that you are requesting permission to go into presumably and seemingly prior bad acts, vis-a-vis, he got the wine and I know what happens when he gets it and everything that follows from that, those are bad acts. That is character. And the Florida Supreme Court has provided guidance and circumstances, specifically in Holland, on what needs to be done. You're attempting to provide information that the defendant was apprehensive of the victim at the time of the homicide by virtue of the wine, etc., as you've proffered. That's bad character evidence that you're going to be bringing in. Historic bad character evidence. This is what happens when he drinks. This is what happens when I don't placate him. This is the situation that I find myself in, which inevitably may dovetail into prior incidents of abuse. That's all prohibited character under 404, 9404. And the carve out for that is if a overt act is established. It's not a subjective standard. It's an objective standard. The jury instruction, 3.6F, identifies it being an objective standard, and the Akendo case specifically tells us that it's an objective standard. And Akendo, the second DCA in 2023 stated, the conduct of a person acting in self-defense is measured by an objective standard, but the standard must be applied to the facts and circumstances as they appeared at the time of the altercation to the one acting in self-defense. I'm going to rely on Holland. Holland is the law of the land. It is what the Supreme Court has told us to utilize. That's what I will be relying on. The overt act has to be established.
Ms. Boone, do you understand that?
I do.
Okay. Anything else?
We cannot talk about any prior bad acts or anything of that nature until we talk about the actual event, the attack. Correct? You understand?
Do you understand that?
I do.
Okay.
Sarah doesn't give a rat's fat kneecap, y'all. Stop this. All right, let me answer and thank Chicken Shite really quick. Thank you so much, Chicken Shite. I appreciate this, babe. Anyone else curious what Owens and her did with the suitcase alone time? They are so weird on so many levels. Okay. They would technically never be like alone with the evidence. Okay. There would absolutely have to be somebody there supervising and likely a representative from the state. That's number one. Number two, I would submit that what they did during that time is try to get Sarah worked up and tell her, you better cry on that stand. You better get those tears out. That's what I think happened. I'm over this shit. Let's get this show on the road. No more stalling. Owens.
Anything else, State?
Nothing.
Defense, anything else?
Ridiculous.
All right, let's go ahead and stand and bring in our jury.
Finally. I would like to submit to the court that we ought to be able to serve the jury a Pop-Tart platter while they listen to this testimony. They should be allowed at this point, due to the baloney that the defense has pulled, they should be allowed to sit in that jury box, Pop-Tart in hand, while Sarah testifies. And no Pop-Tarts for Sarah Boone.
Jury entering.
She gonna try to escape that jury box.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury? All right, thank you. Y'all can be seated. Members of the jury, after seated and comfortable, if you could raise your hands to confirm.
Yes, she's
that you
laughing
complied with the
because
court's
she's
instructions during
delusional.
the
She's
break.
not stressed. She
Record
don't
reflect
care.
all hands have been raised. With that, state has rested. The defense is going to put on a case. Defense, Mr. Owens, you can call your first witness.
The defense would call Sarah Boone.
Finally, 11 billion hours later.
Raise your right hand, please sworn. Please do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God? I do.
All right, ma'am, you could take a seat. And if you could, state and spell your name for the record for us.
Sarah Boone, 101077.
And could you spell your name?
SARAHEOONE.
All right, thank you very much. Sir, you may inquire.
Ms. Boone.
What
would
are you
please,
doing with the
tell
microphone?
jury where you were born and raised?
Atlanta, Georgia.
You were born in Atlanta?
I was born in Atlanta.
And how long did you stay in Atlanta before you moved here to Florida?
I was 3 years old, 3 or 4.
Okay. And from that time, y'all moved, you and your family, your mother and father, moved to Orlando?
And my grandparents.
Okay. You all moved down from Atlanta down to Orlando?
Yes, and my 2 brothers.
Okay. And were you raised here essentially from that time on?
Yes.
And you resided here in Orange County, Florida that entire time?
Yes.
Okay. And where did you go to high school here locally?
I did.
Where did you go to high school?
Edgewater.
Okay. And tell the jury, how old were you when you graduated?
I was 18 years old.
Now, I know you lost your mother and father.
Overruled.
I know you lost your mother and father in your teens and in your 20s. Is that true?
I lost my grandfather when I was a sophomore in high school, and I lost my father when I was a senior. And then my mother passed away a few years after that, and then my grandmother passed away after my mother died.
All right, so you were in your 20s when all that was going on?
Yes.
Okay. And then at some point in your 20s, you met Brian Boone?
I did, yes.
All right. And how long did y'all date before you married?
A good handful of years. I helped my family with paying mortgage and bills for the house since my father had passed away and my grandfather. So
So you worked outside the home?
I did.
Okay. Can you tell the jury when you said you and Brian Boone dated for a while? Do you remember when y'all married?
I do.
Could you tell the jury when y'all were married?
The year?
Yeah.
You
remember the date?
It happened to be, yes, that after my mother passed away, that he had waited to ask me to marry him because he knew it would be,
Objection, non-responsive.
Sustained.
Just answer the question if you can, Ms. Boone. Are you a little bit nervous?
a little bit.
Okay. Well, just tell the jury if you remember the date that you and Brian Boone married.
August 21st, 2004.
Okay. And had y'all lived with each other for a short time before that?
Short time.
Yes. Okay. After you married, how long was it before y'all had any children?
Gosh, 6 years.
Okay. And y'all have one son.
Yes,
What's his name?
Lucas.
And how old is Lucas now?
Lucas will be 14 years old on the 28th.
28th of this month?
Yes.
Okay. So you and Brian were married and y'all lived in Orange County. How long were y'all married?
For 13 years.
Right, and y'all divorced?
Yes.
And as part of the divorce, were y'all to share custody of your son?
Yes.
And so y'all would split days, would that be fair to say?
Yes.
At some time after you and Brian split up, did you meet Jorge Torres?
Yes.
All right, could you tell the jury how you met Jorge Torres?
I met George when I decided to buck up, I guess, and was tired of trying to patch things up with my ex-husband. And I decided to go one day for a walk across the street and go have a beer by myself and sit and people watch just to get out of my house and a change of scenery.
All right, now is this your apartment?
No, this is the marital home,
Okay. Where is that marital home?
Winter Park.
You're no longer living in that marital home?
No,
Who lives in the marital home?
no one. It has been sold.
Okay. So you met Jorge Torres before you got the apartment?
Yes.
Okay. And you met him at a bar across the street from the marital home?
Yes, we had a mutual friend there.
Were you introduced?
Yes.
All right. How did you and George get along when y'all first met?
Very well. It was strange how quickly we hit things off and had so much in common. And I never thought that he would be interested in someone like me. And I just couldn't believe that he was actually interested in me and said a lot of nice things. And 1 hour ended up being 4 hours from when we had first met. And then we would always have something to talk about.
Why couldn't you believe that he would be interested in you?
He was very handsome. He was very funny. He was smart, and I would show up in workout clothes and disheveled hair, and I guess I kind of felt broken from being in the process of the divorce that he knew about. But then one of the things that we could relate also was the fact that he was here in Florida because he had just been divorced from his second wife. So that was another topic that he and I could compare notes on.
So eventually the divorce was settled. Did you get your own place?
Yes.
Is it fair to say that at first you lived in your parents' home, correct?
Yes, until I was married.
And then you moved directly in with Brian?
Yes.
And then y'all lived in the marital home, correct?
Yes.
And then you got this apartment.
Yes.
So that was the first time in your life that you actually had your own place.
Yes.
And what was the address?
4748 France Court, apartment number 3.
And what city is that in?
It's in Winter Park.
How far is that from here?
20 minutes.
Okay. So you got that apartment, and initially were you by yourself?
No.
All right, tell the jury.
In the almost year, about 10 months of separation from Brian, my ex-husband, that is the time when I met George. And my ex-husband was trying to buy me out or force me out of our marital home, and I needed to find somewhere to live. And
So did you and George agree to rent the apartment?
yes, I needed extra income. We could not afford it just on my own.
You were receiving some income from the marriage settlement, were you not?
Yes.
So you did have a consistent monthly income coming in from the marriage settlement,
For the most part, yes.
but you needed more to live.
Yes, to pay the bills and for rent.
So did you and George have some agreement?
We did.
All right, what was the agreement?
The agreement was that if I decided for he and I to live with one another, because it would be under my name, that he would help with the monthly bills, and on a regular basis where it wouldn't be something that I would have to argue with him about. It would just be an automatic, make sure that everything's paid first, and then from there, hopefully have some fun with it.
Okay. So I understand from that point on, would it be fair to say that y'all saw each other on and off for about the next 3.5 years?
No, I would consider us a couple. At some point, he asked me to marry him.
Okay. But y'all did have times where he left and went to live with his parents.
Yes,
Is that fair?
yes,
And there were times where there was an understanding that y'all were going to break up.
multiple times.
Okay. All right. So again, on again, off again.
Yes, this was actually before we had our apartment. That was, I guess, our dating phase.
Okay. So y'all were together for 3.5 years. Is that fair?
Yes.
And y'all had actually agreed to marry?
He had asked me, yes, a couple of times to marry him, and one time I agreed to yes.
Okay. Now, I want to get directly to the date of this event so that the jury can hear your testimony. All right. So tell us, I believe the date is February the 23rd of 2020. Explain to the jury that whole day, from the time y'all got up, the whole thing.
Approach.
Yes, Sarah, that's fantastic. Keep smirking. The jury loves that. You're moments away. The last question that you were asked, thank you, officer. The last question that you were asked was to describe what occurred on the day the person that you are just testified that you love more than anything in the world. And you're smirking. Well played, dummy. Well played. I love this for you.
Objection's overruled for now.
Now, Ms. Boone, let's just, instead of one long speech, let me break you up over the course of the day. So do you remember the date of February 23rd, 2020?
Yes,
Do you remember getting up?
yes.
All right, just tell the jury about that morning, what y'all did that morning, what you and George spent the night together at the apartment.
Yes, at that point, he was living there.
Yes. So y'all slept in the bed together upstairs, February. So you would have gotten up, y'all would have gotten up that morning, February 23rd of 2020.
Yes.
All right, tell the jury what happened when y'all got up.
He was already downstairs, and I went downstairs, and he wanted to start the day off by drinking because it was a day off from his job. And I talked him into cleaning and tidying up the house for a sense of accomplishment. So that is what we did for however long that it took. So we did tidy up the house and got everything in order, and it was kind of a reward, I guess, to be able to sit and enjoy ourselves and sit on the back porch.
All right, what do you mean by cleaning up the house? What did y'all do?
We swept and mopped. We folded some of the laundry. I know that we did the dishes, emptied the dishwasher, just general run-of-the-mill tidying up.
And did you have your son coming the next day?
Yes, that was one of the reasons why we were able to do that.
What was the arrangement you had in terms of the next day would have been your day to pick up your son from school?
Yes,
What time would you pick Lucas up from school the next day?
I believe his school ended at 3 o'clock.
Okay. So you would have been responsible to pick him up and he would be spending the night with you that night.
Yes.
So you wanted to have
Thank
the
you,
house
Tess.
nice
I appreciate that, babe.
How many bedrooms are in the home?
2.
And you and George had one bedroom? And who had the other?
Lucas.
All right. Is that exclusively his bedroom?
Yes.
All right. So how long would it have taken y'all that morning to clean?
I don't really remember what time we woke up, but maybe a good 2, maybe 3 hours.
Okay. And would it be fair to say that you and George both smoked cigarettes?
Yes.
And would it be fair to say that you and George both drink alcohol?
Yes.
So at some point, y'all finished your chores, right? And then y'all were going to enjoy the day.
Yes.
All right. What was the plan?
It was just kind of, we've got the day to ourselves. Let's just kind of relax and go with the flow.
Did y'all make a decision that y'all were going to start drinking?
Yes, we had a half of a bottle that was already in the refrigerator, and I did not want to go out afterwards. I, again, had Lucas coming the next day, so we went over to Publix to purchase another bottle of wine, so we could not have to go out later on that evening.
Now, you were here in court when the state played the video of you two and the Publix purchasing the bottle of wine?
Yes.
Is that what you're referring to here with the jury right now?
Yes.
Okay. And that was around noonish?
I believe so, yes.
Okay. Had y'all started drinking the leftover bottle before going to the Publix?
No.
Okay. So y'all bought a bottle of wine?
Yes.
All right. And how did y'all get to Publix?
My car.
How far is Publix from your apartment?
5 minutes.
How would you get there from your apartment?
What do you mean?
Did you have to go across any major highways, or is it right there?
You just come out of our apartment complex and you do a little U-turn and then you come up and it's right in that complex.
Okay. But it's easier to drive than to walk.
Yes.
I know at some times y'all would simply need cigarettes and it was in walking distance. Can you tell the jury about that?
Yes. There was a Lotto Zone convenience store with in the same, I guess, parking lot of our townhome, our complex. And it was just a straight shot from our apartment to a back gate, and you could get right into the convenience store from right there.
Okay.
Thank
Y'all
you,
went over to get
Curious
that bottle of
Christine.
wine
I
around
appreciate that,
noonish,
babe.
And how did you took your car?
Yes.
Did George have a vehicle?
We did not.
And how did you pay for the wine?
With my debit card?
And then y'all came back and started drinking?
Yes.
Okay. Tell us what you did when you got back from the Publix.
Just went on the back porch where we usually spend our time because we're able to smoke cigarettes outside as opposed to inside. And
Is cigarette smoking not allowed indoors?
it is not.
Okay. Do you have pets?
Yes, I do.
Well, did you have pets?
I did, yes.
Okay. Were they with y'all there that day?
Yes, my dogs were with me all the time when I was there.
How many dogs do you have?
I have 2.
And just what are their names?
Penny and Tess.
And what is the breed?
They are red Boston Terriers.
And are they both disabled?
Yes, Penny is blind and Tef is deaf.
So when y'all went out to smoke on the back porch and drink, I assume, as well, correct?
Yes.
Did y'all take the dogs out?
Oh, yes.
Is there a place for them to do their business out there?
Yes, I extended our back porch for them to have a little bit of area as opposed to going from a large backyard from my marital home to our little townhome. And they would come out there and do their business, and I would open the gate and then walk them in the back part of our apartment.
So you and George were just going to enjoy the day together?
Correct.
Is it fair to say y'all don't have a lot of money?
Yes.
And so y'all were going to do something there in the home. Y'all weren't going out for dinner or...
Yes, I would consider us homebodies as opposed to going out and partying and doing this and that.
Okay. And how long do you think y'all were out that afternoon outside?
A few hours.
All right. Could you tell the jury what y'all did during that time?
We have a dartboard that's out there, and we just had drinks, and we're just really enjoying each other's company and talking about, things upcoming. We both were looking for a job, and just kind of, I guess, encouraging and supporting and planning. And
Well, now you said he had a job. Was he looking for a job, a second job?
no, the job that he had was very unstable, and at that,
So he was looking for something new.
yes, at that time, yes.
Okay. And so during that 2 or 3 hours, would it be fair to say that y'all drank the bottle?
Yes.
Okay. So would it be fair to say that y'all were feeling the effects of the alcohol?
Yes,
Okay. At some point, who made the decision to come in?
I did.
Okay. Why did you want to come in?
I felt that George needed a change of scenery.
Okay. So y'all came in, and then did y'all do anything else before he left again? Were y'all doing anything? I know y'all did some arts and crafts. What did y'all do? At some point, he went to get another bottle at Publix.
Yes, I believe it was after it was right before, I believe, that we had gone inside. Because he called his daughters. I was trying to encourage him to call his family.
Okay, now where are his daughters?
His 2 daughters are located in Pennsylvania,
And what are their names?
Anna and Destiny.
And how old are they?
I believe that Anna is in her 30s, and Destiny may be in her early 20s.
All right. Does he have any more children?
Yes, he has a son.
And where does his son live?
He is in Pennsylvania also.
So part of that afternoon is y'all came in to call relatives, call family.
No, I had him call outside, just trying to, I guess, boost the mood. And the first daughter didn't answer, and I don't remember the reason I didn't speak to the second one. I believe he did. It was just for a moment.
All right, now whose phone y'all using?
My phone.
All right. And is that common for y'all to use that, for y'all to share that phone?
It was, because George said that he didn't have a phone. So it would either be lost or given to him by his mother. So I didn't know he had a cell phone, so we would use my phone.
So it was primarily your phone?
Yes.
Okay. And you took a lot of photographs that were on that phone?
Yes.
Videotapes?
Yes.
Text messages?
Yes.
Phone call?
Yes, he and I both on the phone calls.
So he would use it as well?
Yes.
And that phone, is that the one that was seized in this case?
Yes.
All right, so y'all called his daughters, and then during that phone call period, did you also call his brother?
Yes.
Okay, and which brother was that?
John.
All right, now, how many brothers and sisters does George have?
I'm going to list them if that's okay.
Okay.
It's John, Pharrell, Isaac, Mo, and his sister.
Okay. And do they all live here in Florida?
Yes.
Are they close by?
As far as I know, yes.
What about his parents?
Yes.
They live here as well?
Yes.
Okay. But his ex-wives and his children live up in Philadelphia?
Yes.
Okay. So you called the girls, then you called, or George called his brother.
Yes.
Was that conversation that long?
No, it was not.
Okay. And then after that phone call, were y'all inside by this time?
Yes, at this point, I believe that it was a good time to get a change of scenery. So I thought George would be better off inside, and frankly, I didn't want to be outside any longer either.
Okay. So just to get an idea, about this time is when he went to get the second bottle, or did y'all stay inside for a while before he left?
No, from what I recall, I thought the day was over and it was going to be, get ready for the evening, for the day. What do you want for dinner? Do you have an extra load of laundry that you need to throw in, kind of thing? And that was my understanding. And he said,
This was about 5-ish or something?
I don't remember the time.
Okay. At some point during that time period, did George go to Publix again?
Yes, I thought he was going to be walking to the convenience store, but apparently, when he returned, he had gone across the street with my car and my debit card to buy another bottle of wine.
What was your understanding of where he was going?
To the convenience store, walking.
For what?
Cigarettes.
Okay. And you learned obviously that he came back and you learned that he'd used your vehicle
Yes,
and he'd used your debit card
yes,
and he'd brought back a bottle of wine from Publix.
correct.
And you saw the Publix video of that.
Yes,
So he comes back with the other bottle of wine, and did he want you to drink with him?
it was expected, yes.
Yes. And you agreed to consume the second bottle with him.
Yes.
So over the course of that evening, drinking the wine, what did y'all do for time-wise? Watch a movie, music, just kind of tell the jury what you remember. I know it's obviously been a while, but.
It was kind of a regular thing where I would always try to come up with entertaining activities for George, and I bought a puzzle. We started off at one point doing a smaller puzzle, and then we did that very quickly. So then I purchased a larger puzzle, and I believe it was 1,000 pieces. So I thought, to get his mind off of things and to focus on something, it would be smart for us to do the puzzle. So for however long that took, we finished the puzzle. So that was one.
Did you every piece was finished, or was?
Every piece was finished. It was strange that we couldn't find one piece, and we thought it was funny that it was like in like the perfect place on there. But yes, every one but one piece.
All right. After the puzzle, what did y'all do?
I decided to continue to maintain and focus him, and I have a bunch of paints that I used of my son's that his grandmother bought him. It's a very big art wooden box, and it's got pastels, pencils, paint, any kind of whatever. And he and I were very much into art, and with this resource, it got him very interested in being more creative.
How long have you been into art?
Ever since I can remember. As a child,
You like to draw?
I like to do anything artistic.
And I know, we saw some of the pictures of your apartment, but it looks like there was pictures and artwork up. Is that all your work and George's work?
The majority of it, yes, are belongings from my home. And then also some of George's, yes, on the wall.
Was he pretty good at art as well?
Yes,
All right. So you both enjoyed doing that.
very much.
Yes, this is fantastic testimony, Sarah. Please keep explaining to the jury. Did I even unmute? Yeah, I did. Okay, please keep explaining to the jury how you dictated, controlled, directed, however you want to put it, the day's activities into the evening's activities. Yes, please continue to tell that to the jury. This is fantastic. I love this for you.
So y'all got out Lucas's art set. What did y'all do with that?
We were just, I guess, doodling, whatever. I would always tell him that everything that you make is a masterpiece. So just let loose and just let it go. And we would just paint and, paint and drink, yes, and listen to music sometimes, and yes.
Now with the dogs, did y'all get the dogs involved?
Oh, yes, my dogs follow me everywhere, yes.
Was there some dancing going on with the dogs?
Yes, after we had completed the puzzle and I guess we're painted out, I thought that it might be a good point for us to maybe listen to some music. And the music that George listens to is it's very fractious to me, and it was definitely not going to lighten the mood. So we ended up finding some channel on the radio, and he was feeling it. And then we ended up, my one dog gets very active and was dancing with us, and we were just having a good time listening to music.
And I guess it's getting pretty late in the evening.
Yes.
Anything else I've missed?
I don't believe so.
All right. So tell us where y'all ended up before you started the game of hide and seek.
We were there. I couldn't think of anything else possibly that I had to continue entertainment. But I remember sitting at the end of the couch and him sitting in one of my son's chairs that was in the living room, and just kind of doing this. Like, what are we going to do now? Like, I very much would like to go to sleep.
Had y'all finished off the that bottle that he had bought?
I don't remember, to be honest with you.
Bless you.
Would it be fair to say that as the day wore on, the more y'all consumed?
Yes.
And would it be fair to say that as the day wore on, the more you consumed, the more effects you felt from the alcohol?
Of course, yes.
Both of you.
Yes.
Okay. So you would agree, would you not, that at the time y'all were trying to figure out something to do and you put your head on the couch, that y'all, would it be fair to say that y'all were intoxicated?
Yes.
Tell the jury what happened.
At one point, I guess he knew that I couldn't come up with anything else, tapped me on my knee and said, "You're it." So from there, I ran up the stairs and hid into our shower, just waiting for him to find me so we could hopefully go to sleep soon at some point. And
Your shower, is it a tub or just a walk-in?
it's a tub, but it's in the master bedroom, and you have to go all the way upstairs. You have to go in the bedroom, and then you have to go into the bathroom part, and then there's the shower part.
So did you lay down in the tub?
At one point, yes, I was.
So you were hiding?
I was trying.
Okay. And did you believe that he was going to come try to find you?
Yes.
Did you wait?
Yes, for quite some time.
All right. Then what did you decide to do?
That I decided that I need to go to sleep. I'm picking my son up the next day, and we need to start wrapping up the evening. And I went downstairs to find where he was.
And what?
Thank you, Just Demi. I
think the
appreciate
jury
that,
has
babe.
seen pictures of your, would you call it an apartment or
It's considered a townhome.
a townhome? So you walk down the stairs, right?
Mhm.
And at the bottom of the stairs is a bookshelf here?
Yes, at the very end of it, yes.
Okay. So you walk down the stairs and you turn and look in the living room. What did you see?
I don't even think I made it all the way down the stairwell because I was just looking for him as soon as I could, to hopefully go upstairs as soon as we could. And I looked over and I saw him settling himself in the suitcase.
All right, tell us about the suitcase. How long, was it an older suitcase?
Yes,
Whose suitcase was it?
this is George's suitcase.
All right, and did he use it for traveling back and forth to Philly?
Yes, I had recently taken him on a trip to go see his children in Pennsylvania, who he hasn't seen in years. And we took that with us. And because of how dilapidated it was, how broken it was, in the end, after that trip, we decided that we would donate it.
All right, and I understand y'all kept the suitcase upstairs.
Yes.
How long did y'all keep it upstairs?
Hang on. Back the milk truck up. This is a new version. I don't think I recall hearing Sarah say that they had decided to donate this dilapidated suitcase. Wow, you guys you're so generous, Sarah, that you would donate a dilapidated, broken suitcase. You're so magnanimous. I hope they canonize you, which if you don't know what that means, it means it's making you a saint. You ought to have a whole statue erected in your honor, ma'am, for your service and charitable works.
Since we had moved in,
Is there a closet up there you kept it in?
Yes, it was in the master closet, the master bedroom closet, all the way in the back because of the size of it, and there was nowhere to put it, so it's all the way in the back.
So when did y'all decide to move it down from upstairs to downstairs? Was it that day or sometime earlier?
No, it was
Right about the time I
maybe a
kicked
week or
it down
so
the stairs.
prior.
And so what, y'all were gonna donate that to Goodwill or?
Yes, we were going to do, I guess, a spring cleaning. Anyone who has children understands that they grow quickly, and there was a lot of clothes that I needed to go through of my sons, and then also from George and I moving in and just kind of putting everything in there, at one point where we just needed to actually go through it and organize it and get things more in order.
So is that the reason it was downstairs? You were gonna donate it and a bunch of things that you were gonna put inside of it?
Correct, yes.
Okay. So it'd been down there a week, so it was already down there?
Yes, George brought it down.
Okay. So you said that you got down there, you're looking for him, you see him settling into the suitcase.
Yes.
What did you do?
In my head, I said, oh man, we're obviously not going to be going to sleep anytime soon. And I walked over and he was trying to get himself flat, so I couldn't tell that he was in there. And then
Now, let me stop you there. The suitcase, is it the suitcase over here in the
yes,
box? You've seen it, you saw it.
yes,
It's a pretty big suitcase.
yes.
How big is George?
George was my height. And
How tall are you?
I'm 5'3".
Okay. And how much did George weigh?
I thought it was 100 pounds.
Okay. And how much did you weigh?
I was 98 pounds.
All right. Do you agree you put on some weight?
Since I've been incarcerated, yes.
Well, at the time, though, y'all were pretty skinny.
Yes.
So from the pictures, it looks like y'all were both pretty thin.
Yes.
All right. So because of his thinness, is that how? And he's a small man.
Yes.
Okay. So he was able to get in the suitcase on his own.
Yes.
Did he willingly get in the suitcase?
He was already in there.
Okay. When you got to him, did he see you?
Yes.
All right. Tell us what happened.
I mean, I zipped him up. We thought it was funny. And we're joking about how he was, I guess, small enough to fit inside of the suitcase.
All right. So what happened then?
From there, it was just,
Hang on, you guys know I have to pause for fair use and commentary. Our national treasurer in the chat, MK Leon, did the math based on George's height and the dimensions testified to of the suitcase at the trial. And if I recall correctly, MK said that if the suitcase were standing upright, that George was 5'2", and it would only have reached about what mid thigh, I believe, is what our resident national treasure MK said, which I believe him. So there you have it. It's not a huge suitcase. Stop it. Let's continue.
we were laughing about it. And it was just strange that he was small enough to fit in there. And then I kind of moved it around a little bit with him in the suitcase still. It was still funny that he was still in the suitcase. Just, I think he and I were just kind of, couldn't believe that he could fit in the suitcase.
Did you eventually close the top?
Yes, in order for, well, the top was already closed. As he was settling himself in there, that's how I knew he was in there, was because the top was kind of flopping a little bit.
Okay. So he had got in there to hide and he pulled the top
Yes,
on top of it, but you could tell he was in there.
yes,
You saw him right away.
yes,
All right. So at some point, did you zip him up?
yes.
And what was he saying or doing when you were zipping him up?
We just thought it was funny.
Were you both laughing?
Yes,
And so you zipped him up. Were y'all still laughing once you zipped him up?
yes.
Tell the jury what happened then.
From there, I moved the suitcase around a couple of times, just kind of on the wheels and moved it around. And at that point, it was funny. We were joking and laughing about it.
All right, now eventually, did you go sit down on the couch and get your phone?
Yes.
Have I missed something?
Well, the suitcase had, for me moving it around was flopped over. So while it was like that, I thought at that point I had a moment to, I guess, take the time to talk to him while I guess he was not able to get out for a moment.
So you flipped it. You got it on the top, right?
Yeah.
It gets in, but at some point you flip it over so the zipper is on the bottom.
Well, it was just kind of how I was moving it around that it ended up kind of flopping. So
It was upside down.
yes,
So after you did that, what did you do?
that's when I went over and decided to videotape to just see the I guess the jest in it for him to understand that right now I feel safe and right now I have the ability to actually speak to you in a manner that normally I would not have the ability to do.
And you were intoxicated,
Yes.
and you would agree that you said some things you should not have,
Yes.
but you realized he could not get out and get at you. Is that fair?
At that moment, yes.
So it goes on for about 10 minutes.
So basically, let's just sum this little bit of testimony up. Sarah had a captive audience. Thanks. We got it.
Yes.
You heard it here today, did you not?
Yes.
You heard his voice as he was speaking from the suitcase.
Yes.
That was his voice on the video and audio.
Yes.
And you heard your voice on the video and audio.
Yes.
That was your voice.
Yes.
All those things said by the man were said by George in that 2-minute video.
Correct.
All the words said by the female were said by you in that 2-minute video.
Correct.
Were you intending on showing him the video the next day?
Yes.
At the time or the next day, is it fair to say you don't even remember a videotape?
I do not.
So from what you can tell from watching it, did that refresh your memory about that event?
It did.
Why did you say all that?
I mean, this is going just about as great as you would expect it. She still wants to smirk. She still thinks that this is funny. She doesn't, I don't understand. You guys, I don't understand this. And I don't even, like, I'm a little annoyed with myself that I am even having this reaction. I just, look. Who, now you got me sounding like an owl. Who are you smirking at, Sarah? What are you doing? I mean, listen, don't stop. Far be it from me to help you, but for Pete's sake, she's recalling it. She is recalling this is my opinion. This is only my opinion. It appears that as she is recalling when George was trapped in that suitcase because of her and telling her he couldn't breathe, she's recalling that moment and smirking. That moment that later, and I don't know how much later, I don't know how long it took. Even the medical examiner could not testify to that. But those actions
Mr. Owens, you may proceed.
resulted in George's death, and she's smirking. Now, listen, I know people have inappropriate reactions to situations sometimes. When I'm in a high level stress situation, my coping mechanism is to make a joke, okay? But not in never something like, I just, she's supposed to be terrified. Remember, this is where we're going to come to the overt act, all right, that triggered her PTSD response, that is the battered spouse syndrome. And she's smirking. Piece of work.
All right, I'm talking about just the 2-minute video part that was recorded. Could you just tell the jury what you were feeling, what your feelings were at the time, and then just explain that to the jury? You mentioned, you talked about it before. You said he was in that confined space and it was my chance, but do you want to elaborate on that, or?
Sure. I want you all to know that the majority of the time, am always afraid and always scared.
All right, well, I understand that. Okay, I understand that. But would it be fair to say that you had some anger at that point?
I did.
Would it be fair to say that you wanted to tell him off to some degree?
I just wanted, yes, for him to have a better understanding, which was the whole point of the videos and documentation prior.
And you could tell that he was uncomfortable.
I'm guessing.
And did you want him to feel some uncomfort?
I did.
Okay. Now, at some point, you turned off the video.
Yes.
And then we saw a second video, which was approximately 11 minutes later. And you've seen that video. It was played to the jury. It was 22 seconds long.
Yes.
And I don't think you speak in that video. You hear George say Sarah one time.
Yes.
Is that fair to say?
Yes.
So between the 2-minute video and the 22-second video is an 11-minute period. Would you tell the jury what happened?
We continued to, I guess, speak to one another, and his tone changed, and I knew the tone, and we ended up, I guess, arguing back and forth with one another, and it was the things that he was saying very much frightened me, and cursing at me and threatening me. And
did he want you to let him out of the suitcase?
I'm sure so.
Okay. Go ahead, tell the jury.
And it got very heated very quickly, and he continued to push on the suitcase. And my fear was that he was going to break out of the suitcase, knowing that it was a broken suitcase. And his hand started to come through. His hand started to come through this way. And so I shook the suitcase, trying to get his hand to go back in, shaking it, and telling him that, please stop doing this. Please stop doing this to me. Please stop doing this to me.
So his hand actually got out of the suitcase.
Yes.
And you went to the suitcase.
Yes.
And shook it.
Yes.
Did that force his hand to go back in?
No.
So you're shaking it. Were you shaking it to try to get the suitcase, his hand back in?
Yes.
How long did you shake it?
I don't know.
But his hand was still out.
Yes.
Was he trying to get out?
Forcefully, yes.
Was he angry at you?
Yes.
Were you in fear?
Always.
If he would have gotten out of the suitcase, what would he have done to you?
Like he used to tell me, he probably would have made me unrecognizable, or I would have lost my life.
Did you lose the grip on the suitcase?
Yes.
Where was the bat in relation to the suitcase?
It was leaning up against the dining room table right there.
How far was the bat from the suitcase?
3 feet, 2 feet.
Was his hand still out of the suitcase?
Yes.
And was he getting out of the suitcase?
He very much was trying, yes.
And so what did you do?
For the split second reaction that I had, I happened to see that and I grabbed the baseball bat and was trying to poke his hand to go back in to please don't break through, please. So I hit his hand.
Did you hit the outside part of his hand?
Yes.
We've seen the photographs of his left hand. Did you cause the bruising there?
I'm guessing yes.
Now, you've seen the bat. It's a youth bat.
Yes, I bought it for my son.
Is this the bat you used?
Yes.
And you said you poked him with it?
Yes, I kind of pushed, like I held it with the skinny part here and then
So the grip here,
prodded at it, yes.
you grabbed it with both hands here,
Yes,
and then the barrel of the bat, the big part of the bat is here.
correct.
And you thrusted it into the different areas of the suitcase?
I started with his hand and his hand, he was still trying to get out. He was still trying to do that. So I started to push on the suitcase around it, hoping to have his hand retract and go back inside.
You made those injuries.
I did,
We've seen the photographs.
yes,
We see the bruising. Is that from that bat?
yes.
Eventually, did his hand go back inside from you doing?
Yes, finally, he had subsided and retracted his hand.
So in your mind, did you prevent him from attacking you?
Absolutely. Split second decision.
Now, once he retracted his hand, do you remember zipping it up some, or what did you do in relation? Because he was upside down, was he not, at that point?
Yes,
At some point, you flipped him back up.
I did.
Tell how that happened.
He wasn't cursing. He wasn't threatening. His hand was inside foremost. There was no more of him trying to break through the suitcase. So I felt safe enough to turn it back over. It wasn't happening anymore.
You went back to the video and the couch,
I did, yes.
and we saw the second video,
Yes,
the 22-second, and he's right side up again,
yes,
and you hear him say, "Sarah."
yes.
Had you left enough room for him to get out? Zipper to zipper.
Yes, that's how his hand was trying.
That suitcase has two zippers, doesn't it? And they meet at various places along the line?
Correct.
How much room, when you flipped it over, how much room was between zipper to zipper?
I don't know specifically. I mean, it was enough to where his hand was coming out.
After you had hit him with the bat, was he not trying to get out anymore?
No,
Did you believe that he could breathe in there?
yes,
Did you ever believe he could die in there?
no, at all.
Were you trying to kill him?
Never.
Did you want to kill him?
I did not.
Did you walk upstairs?
I did, yes.
Why didn't you let him out before you walked upstairs? Were you afraid?
Terrified is more of the word.
As long as he was in the suitcase, he couldn't harm you.
Correct.
When he's Did you want him to calm down?
Yes, I wanted him to stop being angry because I know what it is for him to be angry.
You went upstairs. Where were the dogs?
The dogs ran upstairs with me.
And where did they go?
On the bed.
Did you have the phone with you?
Yes,
I know at some point you called your husband Brian, did you not?
I did.
Do you recall how long that conversation was?
Not very long.
Can you recall what was said?
I don't remember exactly. No, I don't.
Miss Boone, Sarah Boone, you said that when he was in the suitcase, he was threatening you. Can you tell the jury what he was saying?
I don't know. Am I allowed to curse?
Yes.
But he was going to fucking end me. And that's what made me ask him please to stop doing what he's doing to me. That he was going to, I'm guessing, try his best that night to probably take my life.
But what the threat you heard was
He's going to
say the
fucking
word.
end me.
Excuse me?
Fucking end me.
End you?
Yes.
One more.
Yes, sir.
Judge, can we approach the bench?
Yes.
Wow. This is terrible. Terrible, terrible testimony. She's also behavior panel. Shout out to y'all. Blink rate increasing many times during her testimony prior to actually answering the question, listening to the question being asked. She pulls her lip, both her top and her bottom lip in, which is sort of a way to prevent the truth from escaping, as it were. All of these questions, the way that he's questioning her, you guys, is 111 billion% leading. There should have been objections all over the place. However, I think personally, in my opinion,
All right, members of the jury, it is 2:14. I have a matter that I have to discuss with counsel at this point in time outside of your presence. So I'm going to ask you to retire to the deliberation room. We'll bring you back in as
it is my personal opinion that the reason that, I mean, we don't need, do you guys want to hear the judge instruct the jury not to talk to anybody, not to do any of their own personal research, and not to discuss the testimony or any of the evidence they've just heard until it's time for them to deliberate? Do we need to hear that again? They're basically just letting the ship sink itself, like MK said. Thank you, MK. No need for a Miss America answer. It's just going so badly that they're basically letting the ship sink itself. The end. But what she has testified to thus far is she controlled every single aspect of that day. Every single one. From the moment they woke up until he was in the suitcase, after he was in the suitcase, and throughout the rest of the night, she controlled every single aspect of that day. Not only that, apparently the story has changed. Because initially, the overt act was the hand coming out of the suitcase. Now it has morphed, and I told y'all that she would adjust it. It has morphed into not only was his hand coming out of the suitcase, but he said, "I will fucking end you." That's the overt act. So let's hear some gibberish from Owens.
Promptly as possible. Discussions among.
Yes, Carolina, that is why I believe the state didn't object, because they didn't want to.
Y'all may be seated. Thank you.
It was going so poorly that they just let it continue.
State, you can proceed with any argument at this point in time.
Judge, I believe that's pretty close to what we already knew from the deposition testimony, from the doctors relaying what she said for the proffer. What we have here is testimony from the defendant. Her timeline is she comes downstairs after having gone up to the shower and hiding, laying down after being declared to be it. She comes back downstairs, and before she gets back to the bottom of the stairwell, she can see that the victim is in the suitcase trying to get flat because the lid is flopping and he's not hidden just yet. And so she comes over, and I believe she testified she was moving it around before actually zipping the lid shut, but moving it around, everybody's laughing. It's all fun and games still. And then she zips it, and it's still fun and games, and everybody's laughing. And then at this point, she testifies that this is now her opportunity to get on her pulpit to express her true feelings about everything. And that's when she sits down on the couch and opens up her phone device and begins recording what later turns out to be IMG _1062.movie at 11:12:45 for 2 minutes and 3 seconds. During this period of time, the decedent is expressing meekly that he can't breathe. The only time he ever curses at her is, "Sarah, I can't fucking breathe. Babe, I can't fucking breathe." He is demonstrating under the law that he is in fear of losing his life. She has committed an aggravated assault. She has committed false imprisonment. She was the initial aggressor. There was no overt act to justify these actions that she took against her boyfriend. She then goes on to say that during this period of time between the end of the movie at 11:14:48 seconds and before the next one starts at 11:23, that it's now at this time, while he's still constrained and clearly unable to get out under his own power despite having his hand out, she begins beating him with a bat, poking his hands, poking the suitcase with a deadly weapon. A bat is used for baseball, but it can also be used to harm another person. And according to the medical examiner's testimony, there was great harm caused to him, deep ecchymosis bruises. She can't start to do this out of fear, like the analogy I gave earlier. If I pull a gun to rob you, Judge, and you pull a gun, I can't shoot you in self-defense. She started this. She started this. There was no overt act, and therefore, we're asking for you to prevent, under the case law, any prior instances of violence, any reputation evidence, and any battered spouse syndrome evidence, because that's simply just what the case ended up being. Thank you.
Response.
Judge, this was a game by two intoxicated people. When people are drunk and intoxicated, they do silly and stupid things. The evidence is uncontroverted that Jorge Torres willingly, by his own choice, elected to hide in the suitcase. By their interaction between the two of them, giggling and laughing at each other, he consented to her zipping up the suitcase. And the playful nature of what was going on during those few minutes prior to the video. When the video is turned on, there's a 2-minute period where they're talking. He's saying, I need to get out. I can't breathe. She's not taking him seriously. As you've seen from the videos, I thought it was the boy crying wolf. She did not appreciate the fact that he could be actually having trouble breathing. And this was a chance for him to be heard by her about how she felt about some things involving their relationship. A short time later, the video was turned off, and then that period has been testified to by my client. And that period is uncontroverted. That's a second period of time. We've got that time for the video. We got the 11 minutes, we got the 22 seconds. And there's no video, there's no audio, there's no eyewitness, there's nothing but Sarah Boone's testimony. And she's testified here today that they had words, there were threats. He got his hand out of the suitcase. She knew by the threats and him getting his hand out of the suitcase that he was about to get out of the suitcase and he was going to hurt her. A reasonable person under that scenario would believe she was about to be harmed. She was an imminent threat of harm. She blocked that attack by grabbing the bat, hitting his hand. When that didn't work, she started poking him with the bat in the suitcase. Eventually, she poked him several times. He put his hand inside the suitcase. She put the bat up. When she realized he was not going to do that any further, she flipped him over right side up. She still had a fear, knowing that if he got out, she would be harmed. He would beat her up. She went upstairs. That is an overt act based on the discussions, coupled with the fact that he threatened her, using the word, I'm going to fucking end it for you, or some words to that effect. I don't remember her exact words, just before she went upstairs while he was still in the suitcase. If she would have let him out, and this is now this is an event involving an omission, failure to act, failure to unzip him at that point, before she went upstairs. The failure to act, the failure to unzip, which would have let him out, which would have created a situation that she believed was imminent bodily harm to herself. And I guess I'll get a couple of examples. Let's say that a police officer is called to a scene and the only thing he hears is there is a suspect and the suspect may be armed. So of course the officer pulls out his revolver and he's walking around. Well, then eventually he finds the suspect and the suspect reaches for his waist. The officer doesn't see the gun, but the officer sees the movement to the waist. The officer fires and shoots the suspect. The officer is justified because there's an immediate threat of harm. The officer has to react instinctively. There's no time to think. Similar to the actions that Sarah Boone had to take. Another example, you're in a bar with your buddies and you've had something to drink and another group has had something to drink and one of your buddies gets into an argument with one of the buddies on the other party. And one of your friends, seeing that it's being escalated and the guy that's arguing with your buddy is aggressive, more aggressive than your buddy is. Your buddy's trying to settle the thing, but this other individual, maybe he's had too much to drink and he's more aggressive. So you go around behind this individual, and before he's able to strike your buddy, you grab him, you lock him up. That's physical restraint to block an attack. Or you grab him by the neck and you choke him. Physical restraint to block an attack. That's what she was doing with the suitcase.
3 pointing back.
If she let him out of the suitcase, she was going to be harmed based on him trying to get out with his hand, based on the threats he made while he had his hand out, and based on the threats he made while he had his hand inside just before she went upstairs.
Thank you. Court's going to re-review all the case law that it's obtained in its research in this matter and come back with an oral ruling momentarily. Thank you.
Are you just going to leave Sarah sitting on the stand? Oh my gosh. Wow. I feel like Kai, if you want to know the truth. Oh my gosh. I forgot about this thing. I gotta remember to hold on, let me do it now while I'm thinking about it because I'll forget if I don't. I feel like Kai, honestly, right now, like I can't call it. Honestly, I cannot. This is something that I mean, the case law is clear, and the argument really comes down to what a reasonable person would believe. I'm really failing to be able to find words. All right. The legal argument comes down to what a reasonable person would interpret as an overt act. And frankly, in my opinion, based on Sarah's testimony, I can erase everything else, okay? Because that's what the judge is going to have to do. So everybody clear your mind of everything that you know about this case. Clean slate, we know nothing. Hey, Allie, we're waiting for the judge to decide whether or not Sarah will be allowed to use the battered spouse defense. She's just finished testifying. Now, everybody wipe your mind clear. We're all blank slates over here. All right. Now, solely based on Sarah's testimony, okay, we have to figure out the overt act. So according to Sarah's testimony, the overt act is his hand coming out of the suitcase, followed by the statement, "I'm going to fucking end you." Okay? Now, if that is the overt act that caused Sarah to have this PTSD response, why didn't she zip the zipper of the suitcase all the way up? Instead, what did she do? During that 11 minutes, according to her testimony, that's when all of the threats, that's when the threat was made, the verbal threat. That's when, but she failed to record that. Okay. Instead, after it's all said and done, she picks up the phone to record again. And all you hear George say is, Sarah. So you're telling me that George, who started out in the video we've seen, the initial video, the 2-minute and 3-second video, begging, meekly saying, his voice isn't even raised. He's not even, he's not even being loud. Let me out. Not let me out. I can't breathe. Sarah, babe, I can't breathe. I'm serious. I'm not fucking playing. I can't breathe. Okay. Then the camera shuts off. The video ends. There's 11 minutes. And then and only then is when he starts making a threat. He makes a threat. The hand is starting to come out of the suitcase. Right? And Sarah gets the bat. She hits him, pokes. Her words are poke. Doesn't look like pokes. It looks like hitting across the knuckles, because if I know they didn't show them, but a little bit they did. And it's actually, if you really look at his knuckles, it's actually a linear bruise. It's across all of the knuckles. So, in the hands. Doesn't look like a poke. Looks like she swung. Okay, these are her words. This is what she testified to. All right. She records another 3-second video or whatever it is, 22-second video. And then what happens? We don't know, because that's where the testimony stopped. But we know what didn't happen. What didn't happen is she did not further zip the suitcase up because she knew he couldn't get out. According to her own testimony, he had been trying and he couldn't get out on his own. She didn't zip it up further. She didn't do, what did she do? She didn't call, she called her ex-husband, but doesn't remember what the gist of that conversation was. No idea. Doesn't call 911. Terrified. She's terrified, you guys. Terrified. And in between all of this testimony, okay, which the judge is not going to take into consideration because he deals with case law. There's nothing about, he can only base his decision on case law and her testimony, the words that actually came out of her mouth, okay? But what did we see and what did the jury see? Anytime there was an objection and they had to approach the bench to have the discussion, what was Sarah doing? She was smirking. So you're telling me that in the 4 years and 8 months that she's been awaiting trial in the Orange County jail, she's had the level of therapy that would...
All right, we're back
Hold
on
on a
the record,
minute.
State of Florida versus Sarah Boone, case number 20.
Excuse me, Judge Kranick, I need to finish my point. You're telling, so what? She's received such therapy, such good quality, effective therapy in the 4 years and 8 months that now on the stand, recalling the events of those days, her fear didn't trigger her at all to have a PTSD response, didn't trigger any emotion at all. That makes zero sense. All right, let's see what the judge is going to rule.
2020 CF 2603, appearances for the state.
Chief Judge Shore on behalf of the state. William J. The state.
Defense.
James Owens from Miss Boone.
Tony Henderson for Sarah Boone.
Kevin Beck on behalf of Sarah.
Ms. Boone is currently seated at counsel's table, wearing the same clothing from this morning. The court has had the opportunity to review the case law, review the arguments provided by both the state and the defense. The court finds that a overt act has been established. The case law is clear that a scintilla of the providing of an overt act is sufficient to provide the self-defense jury instruction. An overt act is not something that's specifically defined in Florida case law. It's something that's from the totality of the circumstances, seemingly under the authorities that the court has reviewed. As such, the court is going to find that under Holland, a overt act has been established and will allow the defense to proceed with evidence of reputation and specific instances of conduct and battered spouse evidence, so long as the necessary predicates are established for those items. Any questions or clarifications with regard to the court's order state? Defense.
I think it would help if we went through my exhibits involving the blow-up photographs and these other photographs, because I think some of it was contingent on the court's ruling. So I don't know if you want to try to deal with all of them one at a time in front of the jury, or whether we want to just talk about them ahead of time so that we know.
Are there any objections to those items?
It depends on the items. I was shown a lot of different things, including like a rap sheet.
Hold on, I want to look at.
The victim and the defendant stuff.
I've taken that.
We need to, I'm happy to take care of some of this stuff in advance.
I'd rather do it now
Yes.
so that it's not up, down, in and out with the jury.
Yeah, for real.
All right, go ahead, Mr. Owens. What do we got?
Well, I had the clerk go ahead and mark everything.
Owens, do you always have to give Miss America answers? You're worse than me. Tracy says, why wasn't it in narrative form, or do I not know what? I don't understand the question. I'm sorry. I don't understand the question, babe. Can you explain better to me? I know you're limited on characters. If it has to come out in a couple of different, chats or whatever, or messages, can you do that? Because I want to answer you, but I don't understand the question. I'm sorry.
Some of it is a composite. Is this it? First is,
I agree. I think a lot of this,
defense identification.
I think this ruling
Pictures involved.
is really more about the, I didn't see Tellis testifying. Yes, please rephrase. I didn't watch the Robert Tellis trial, so I don't know. I don't know what that means. Because I didn't see it. So that reference is not ringing any bells. It's not ringing any bells. It's ringing no bells. Yes, the judge has determined that there was a scintilla of an overt act testified to, and therefore he's going to allow character testimony, previous bad acts, as well as her ability to use the battered spouse syndrome defense. Oh, I see. So Tracy says, I thought her getting on the stand was her testifying more like Robert Tellis did in near form, meaning he got up and explained his story with little interruptions. She was testifying. So I wouldn't necessarily say it was total narrative, although there was quite a bit of narrative.
Relevancy objection is overruled.
She's also not off of the stand, just so you know, and shouldn't be speaking to this attorney here. I'm sorry, little Irish. Just Irish. Sometimes it's in my brain and I got to get it out.
But also So the state.
Yes, the state will get to
shows
cross.
that,
She's
one
not
way
done
the
testifying.
state
Your Honor.
defend-
Excuse me, Judge
Okay, no
Cranick.
objection.
Technically, she's still on the stand and shouldn't be talking with this other lawyer.
Assuming all the normal practice.
Judge, this is where he took a bath. It's 5 photographs where he took a bath to TV, to Sarah's TV.
My understanding, is this O?
I don't believe it's required in Florida
This is
for
still
the.
O, correct?
Okay, hold on. Let me
Yes.
turn this down.
My understanding from the state is there's no objections.
I
so
feel
long
like
as the
I'm
foundation's established.
considering. I'm over
Thank you.
talking the judge, and I think that's rude. I believe in Florida.
No objections so long as foundation is established.
Okay. This is where it gets complicated. Florida has its own set of standards. Florida has its own laws governing this. Okay. And the deal was with all of this potential battered spouse syndrome was that Sarah would have to testify. That's it. That's all. The judge would listen to her testimony. That's why she testified in front of the jury. This was all of this that we just heard out of her mouth was in front of the jury. It's on record. It is testimony. They absolutely can use it in their deliberations. Okay. It's a little different in Florida. So what happens then is after Sarah testified to what the defense believed was the overt act, which is the hand coming out of the suitcase, the words that were spoken, that's the overt act. That is when he stopped. That is when he asked for a sidebar. That is when they excused the jury and made their arguments. Sarah is still testifying. I'm going to have to look it up, you guys. I don't understand. I understand that you guys are asking that they agreed to a narrative, but I'm going to have to look up. Oh, wait, hold on. Let me see. I do. I'm going to have to look this up, this narrative situation. Okay. Cause I understand now what you guys were, are asking me. And, I will look into it for you guys and have an answer for you. Wendy says the hand coming out of the suitcase was Sarah's testimony with no corroboration. Right. But it had to be that way. It's not required for Sarah to prove with corroboration of the overt act because the overt act is subjective and it relies on her interpretation of the event, her perception of the events in that moment. It's very this is a very complicated situation, and there's a lot of moving parts to it. What I believe is that the reason that Judge Cranick ruled this way is to prevent potential appellate issues. I can't even talk. That is what I think. I believe that the way that the case law in Holland reads is that the overt act has to come from the defendant. And I don't think that it matters how many times because the judge isn't here. I don't know how to explain this the right way. This is a complicated defense. The way that I understood the ruling from the court prior to the testimony coming in, okay, prior to Sarah's testimony, is that she would testify and then he would make his determination based on her testimony, not her other statements. That's a credibility and weight issue. And that, as the fact finders in this case, goes to the jury. That is for the jury to decide. The judge only has to decide if she has established the overt act. And according to the case law that he cited, it only has to be a scintilla of proof. And that's it. And that's the argument.
I think that's Bravo. Is it the defendant on the porch with the 2 dogs?
Yes.
That was pre-marked before trial as Bravo.
I believe personally,
It was
I don't
as
think
defense
that
M.
I don't think that the overt act was only the threat, because he was inside of a suitcase from which he could not escape. I think that it had to be the totality of the circumstances, which would be the threat in combination with the fingers, the hand, however it was coming out of the suitcase. That's the overt act, not one or the other, both. Because it's very difficult to if you can't get out of, if you're confined in a space, right? How much of a threat are you? You know, that's why we have doors on jail cells. Okay, so that the people can be confined to their cell. When you can't get out of someplace, you're no longer a threat, like a physical threat. I don't think he can at this point. I can't highlight that, Lisa, obviously for YouTube reasons, but I don't think that he can claim, especially with the animals, because she's certainly, although, let me preface this, now that that's come in, now that the judge has allowed the battered spouse syndrome evidence to come in, it is possible, it's very possible that the reason Sarah said what she said, testified the way she did in that moment to the questions that she was asked by Mr. Owens, okay, it'll cut because the battered spouse syndrome hadn't been ruled on. Maybe that's why. I don't know. I'm not an attorney, you guys. I'm just watching this and interpreting what I see like you guys do. You know, I do know some things, but I think the jury is going to see through this BS, you guys. I'm really not worried about it. Yes, let's have Kai. Hold on, let me add Kai.
Okay. If we can bring Ms. Boone back up to the witness stand. Once she is seated, we can bring back in our panel.
Let's have a little palate cleanser. I can't believe that Sarah was allowed to have a discussion with her defense team. That's an issue.
Let's go ahead and stand and bring back in our panel.
I am wondering, since both attorneys for the state were up at the defense or up at the bench, I wonder if they will review today's live stream footage and comment on that tomorrow. That's going to, I do think that's going to be an issue. But while we wait for the jury to come in.
And Kai, when you're on Jen Lou's channel, what do you do with the like button?
Smash, smash, smash. Yeah.
Yeah. Smash that like button, y'all. Give it up for your girl who's been streaming for 6 hours, no break. Oh, what happened? Are we okay? Everything okay in the chat? Let me see what's going on here. Also, thank you very much, Chicken Shite. I appreciate that, babe. Very generous. Thank you for your support. I think a lot of us disagree with the judge's ruling, but I also think that we need to be, you know, he is the judge. I think he did it to, I think we got to have a little faith in Judge Cranick.
State, you recognize our jury.
Yes, sir.
Defense, you recognize our jury.
Yes.
All right, thank you. All can be seated. Members of the jury, again, you could, once seated, raise your hands to confirm that you complied with the court's instructions during our last break. Record reflect all hands have been raised. Mr. Owens, you may continue with your inquiry, sir.
Thank you, Judge. Ms. Boone, so I think we left off. You had called your ex-husband.
Yes.
All right. After you called your ex-husband, what happened after that?
I ended up falling asleep.
Okay.
So let me just explain something really quickly. Kayla says, I don't understand your last statement and YouTube being a problem. So Lisa made a comment in the chat about animal abuse and SA testimony because Owens has claimed that. And so, but I can address it. I just can't highlight the comment on the, like I'm highlighting your comment right now. I can't do that because it's one of those things YouTube does not like those words. So saying it is one thing, highlighting it in a comment and pinning it to the screen is another. So the way I have, Lisa knew what I was talking about. So that's what I was trying to address. Sorry about that, you guys.
Do you remember waking up the next morning?
Yes.
Did you sleep in?
Not intentionally.
Oh, here we go.
Okay. But you didn't get up at 8 o'clock, did you?
No.
Hang on. This is very important. We've had our first not intentionally of the day. Put that on your bingo card.
Did you wake up closer to noon?
I believe so, yes.
Did you check the time?
No.
Now, did you hear your phone ringing?
Yes, my phone was ringing.
And did you answer it right away?
No.
Do you know approximately how many times it rang before you answered it?
I believe the call was about 3 times.
Did you know who was calling?
I figured it was my ex-husband.
And why would he be calling?
To make sure that I was still on schedule to pick up our son.
At 3 that afternoon?
Correct.
Because I'm irresponsible AF.
And he goes to school there close by?
Yes.
All right. When you woke up, did you stay in bed for a while?
For a little while, yes.
Or tell the jury what happened when you got up.
I knew it was my ex-husband calling repeatedly. I didn't answer right away because one of our problems is that he doesn't understand that I'm doing things around the apartment and looking for jobs and so on and so forth. So I inevitably just let it ring, and I laid in the bed, and I figured that George was downstairs either drinking or looking for jobs, or may have just left. And so eventually I decided to get out of the bed and start moving to go downstairs. I was motivated enough to go downstairs. And when I went downstairs, it was very quiet. So I had the understanding, I believed that he had left. And
did you check to see if where would he be looking for a job at?
Usually on the couch. He would have my son's laptop, and he and I, which we would share.
Y'all only have the son's laptop?
Correct.
And the TV was not working at this time?
The TV was not there.
So you thought he would be in the living room on the laptop?
Yes.
He was not there?
No.
Where else did you look for him?
I looked on the back porch. I went through the front door to see if my car was there, thinking maybe he had taken my car. I checked the bathroom, and when I was checking the bathroom, I saw the suitcase, and I remembered about the night prior, and I unzipped the suitcase
Let me
and
stop you there. You said you were in the bathroom when you saw the suitcase or coming out of the bathroom?
know where our bathroom is. I would have to go to the bathroom here, and then when I turned around, I noticed the suitcase, and I remembered.
How did you feel when you saw the suitcase?
I don't think I've ever experienced anything like that before.
Describe it for the jury.
I guess it was, I was aghast, and I just can't describe the feeling.
Bless you.
It was terror to
Bless you.
a certain degree.
I'm sorry, say that again now.
It was terror to a certain degree. I just can't describe it in words, the feeling of remembering. And then he was still in there.
So what did you do?
I immediately unzipped the suitcase, and I was screaming, George, 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 and I was shaking him. And I pulled him out, and I stretched him out flat, and then I began instantly trying to do CPR, and then was trying to look for a pulse or a breath or just anything, and was just screaming his name over and over and over again, and come on, George, and I continued CPR, and I continued CPR, and he was gurgling. And
what color was it?
What color was he?
Yes.
He was purple.
At some point, did you call your ex-husband?
Yes, when he started to gurgle, and I knew that my ex-husband is notorious for bringing my son over in very inopportune times when George is possibly drunk or doing things not appropriate for my son to see. And I just didn't know what to do. It was just a quick knee-jerk reaction. Ryan was kind of my go-to person because of my family being deceased, and I don't have anyone else that I can call. And I just wanted to ensure that he would not bring my son over in the process of all of this at some point.
So you called him.
I called him.
Did you ask him what to do? Or did you just tell him to come over?
I just told him to come over.
Did you tell him that you felt like George was dead?
Yes, I did.
And how far? You said it's 5 minutes from house to house?
Yes.
Did you call him back?
Yes, because he was taking so long. It felt seconds were hours. Yes. I'm still doing CPR at the same time in the process of it. I'm
Yeah.
doing CPR, I don't know how many times.
Did he get there?
Yes,
Did he walk in?
yes,
Did he walk out?
yes.
What did he tell you to do?
Call 911.
What did you do?
I called 911.
Is that the recording we've heard here in this trial?
Yes.
Did you love George?
To this day.
Why did you love him?
George was very passionate. George was a very real person. George was nice to me on the good days. George complimented me. George and I were two bodies with one soul, he and I would always say. I don't believe that I've ever had a connection with anyone like I have with George.
Did you have that connection with your ex-husband?
I did not.
Was it even close?
No.
George has some good traits, doesn't he?
Very much.
Did George have some bad traits?
He did.
Did you drink too much?
I did.
Did George drink too much?
Yes.
Tell the jury about George's drinking.
If George was able to, he would drink from sun up to sundown. And me having my son and trying to work and maintain the home and just have a life, a normal life as best as I could, somehow that upset George. And because I had a certain dollar amount from my divorce settlement, at one point it was from wine we could afford vodka. So a lot of the times he would take my card, my debit card, and go buy the large, we call them handles, of vodka, which is the big bottle. And sometimes he would finish that all off on his own throughout an entire period of a day into an evening. That's honestly where I thought that he was going to be that morning when I came downstairs, because he's notorious for just automatically already being outside from drinking all the time.
All right. And you said you have an alcohol problem. George has an alcohol problem.
Yes.
How did George's drinking adversely affect you?
It would debilitate my ability to help him the way that I was always trying to help him, because it would be one good day, a day of survival, and then it would be another day where I'm having to peel him off of me and call 911.
Why would he get that way? Tell us his pattern as it relates to drinking and then
Approach.
I know you guys are frustrated. I know you guys are infuriated. I am as well. George is not on trial. However, because the battered spouse syndrome defense has been allowed, she is allowed to give character testimony. And that is exactly what she's doing. I don't like it. You guys don't like it. It's not right. It's not, I don't like to use the word fair, because fair, when you're an adult, isn't really a thing anymore to me. Life is just simply not fair, but I do feel that this is wrong. I believe that nothing that Sarah has described from that day, from the time they got up until the 911 call, in my opinion, constitutes the use of deadly force, justifiable deadly force. In my opinion, this was absolutely not self-defense. If George was angry about being in the suitcase, I feel like that would be justifiable. I would be angry if I was having a hard time breathing and I was gasping for air, and the person who zipped me into the suitcase after I agreed to some weird game of hide and go seek. Who knows? First of all, what is happening with this game of hide and go seek? Okay. Becky wants to know, will the state now be able to bring in how Boone abused
Objections
George?
overruled
Yes,
for now.
absolutely. They are absolutely allowed to impeach her testimony. It will all come in.
You're already together 3.5 years.
Yes,
Is there times when he would get to a state of intoxication where he would get violent against you?
quite often.
Judge, can I approach the witness?
Yes.
They will
As long
bring.
as you show it to the state first, please.
The state will be allowed to bring in rebuttal witnesses, and they will be allowed to impeach Sarah Boone's testimony in whatever way they need to. That might be too broad, but within reason.
Defense exhibit for identification P. It's 2 photographs. Could you look at those photographs and see if you recognize those?
I do.
Those 2 pictures of your body,
Yes,
did they show injuries to your body?
yes,
Were those injuries caused by Jorge Torres?
yes,
Are those photographs a fair and accurate depiction of the injuries you sustained at the hands of Jorge Torres?
on this occurrence, yes.
You remember this occurrence?
I don't, it was so often.
You don't remember a specific date,
I don't,
but you're sure that that's you?
yes.
Is that the injuries that what's the injury to the rib cage?
I don't remember specifically. These may be the pictures. So, when we used to go over to his brother's house, one of his brothers and his,
Non-responsive.
Sustained.
Do you know what happened did George cause these injuries?
yes,
All right. Were y'all both drinking at that time?
I don't remember on this instance.
Judge, I'd like to move this exhibit into evidence.
Okay.
What was pre-marked as P will be received into evidence without objection as Defense Exhibit 2.
I'm not sure I know how to operate this.
Mr. Owens, may I get into just a number, please? Thank you.
Mr. J, would you be so kind? Thank you.
And I need to ask permission.
Yes, sir. You may do so.
This is nice, Judge.
Looks like I think there's a wheel on the top where you can use to. There you go.
Ms. Boone, is that you?
Yes,
Are those injuries to your arm?
yes,
Were they caused by Jorge Torres?
yes,
And during the same incident, is this you?
yes,
Is that an injury or bruise to your rib cage area
yes,
and your arm?
yes.
show you identification, defense identification Q. See if you recognize that photograph.
Yes,
Is that your thigh?
yes,
Okay. Do you remember this incident?
yes.
Can you tell the jury what happened?
I wanted to take my dogs for a walk and get off of the back porch.
Were y'all drinking?
Yes. And he was upset that I would rather go walk my dogs than sit there and continue to drink. So he slapped my thigh as hard as he possibly could and said that you're not going anywhere. And it was a good smack on my thigh.
Is that a fair and accurate depiction of the wound that you suffered as a result of George Torres slapping you on the thigh?
Yes.
Judge, I'd like to offer Q in evidence.
Objection. What was pre-marked as Q will be received into evidence without objection as defense 3. You may, sir.
And for the jury's sake, is this the photograph you just mentioned?
Yes.
Let's show you identification, defense identification S. See if you recognize that photograph.
I do.
Is that your hand?
Yes.
Is that your blood on your hand?
Yes, it is.
Is that you standing, looks like in a room with flip-flops?
This is in the kitchen at Brian's house.
Okay, what happened there?
So George was very drunk, and I wanted to leave, and he's notorious for taking my car keys and putting them around his neck and my phone in his crotch area and telling me to come get them. And I really wanted to leave because of how drunk, and I knew the escalation of his anger. I didn't want to be there when it was at its peak. So I tried to take my keys from around him because he kept taunting me to take my keys, come get your keys. And so I attempted to go and get my keys. And so he ended up getting a butcher knife. And I had an opportunity to call Brian to come and help me, to please come pick me up, to come get me. And of course, he brings my son with him. And so I'm in the parking lot asking Brian to please help me get my car keys away from him. And there's neighbors, and it's a scene at this point. And George comes to the doorway of my townhome wielding the butcher knife, saying that, do I curse? That no one's going to take her fucking keys. No one's going to fucking come into this house. And he's waving the butcher knife. And I walked up to him, and I just wanted to leave. And my little son, who was, I believe, 7 or 8 at the time, just is screaming, give mommy her keys, give mommy her keys, let her leave. Brian was even trying to negotiate with him, saying, please, you know she'll come back, just let her leave. So I went up to try and take the keys from him, and he was pulling on them, and I ended up pulling harder. And he pulled them back again to try to pull me in the house, and I pulled them even harder, and it ripped my finger. And at one point, I had lost the fingernail, and the tip of my pinky was severely gashed.
Judge, I'd like to offer this to the evidence.
Okay. What was it pre-marked as, counselor?
Just like S, but not importantly.
What was pre-marked as defense S will be received into evidence without objection as defense 4.
Ms. Boone, for the jury's sake, is this the picture you were referring to? Is that the nail? Was it on? Still on?
I believe so, yes.
I'm showing you a composite identification L, 2 photographs. Can you look at those photographs and tell the jury what they are?
I wanted to eat, and while he was drinking, went and made myself, as quickly as I possibly could, a microwave bowl of, I believe it was broccoli and cheddar soup. And I didn't get it out enough time, and he came up behind me and he slapped it out of my hand. And it was a 2nd-degree burn. I went to the hospital for it.
Are those fair and accurate depictions of the injury, the burn to your thigh?
Yes.
Would like to offer identification L into evidence.
No objection.
What was pre-marked as L will be received into evidence without objection as defense 5.
Permission.
Yes, sir.
You had to go to the hospital as a result of these injuries to your thigh?
Yes. It
Okay.
was
Is
extremely
this-
painful.
Is that a depiction of the burn?
Yes.
Is that your thigh
Oh my God, yes.
and your knee?
Yes.
All right, I'm showing you composite exhibit for identification K, 4 photographs. Did you look at those, all 4, before commenting? This is a longer story, isn't it? Go ahead and tell.
So George stabbed me in my leg. I almost bled to death.
All right, well, let's go back and explain what led up to that.
I thought it would be nice to cook a nice steak dinner. We don't have 2 nickels to rub together, so I thought it would be special to make a steak dinner and baked potato and go above the normal whatever's left over in the refrigerator. And so I spent a lot of time doing that, and George is drinking the entire time and on the back porch.
You were drinking as well, were you not?
I was drinking. He was on the back porch while I was in the house and I was cooking. And it was one of those where maybe if I start making dinner now, it will be over at a particular time and we can go to bed at a reasonable time. And I even put it in the bedroom and had a movie set up for us to watch. So it would just kind of be dinner in bed. And then he came upstairs and saw that I had made the steak dinner, and I don't know how to describe how drunk he was, but it definitely was not George. And had him come lay on the bed, sit on the bed, and, you know, put the, I got the dogs out, and I presented him with the steak dinner and sat down and was getting ready to start playing the movie. And he starts being very rude and cursing the steak and finding fault with it. And then, you know, I'm having to encourage him to eat. You know, if you want me to cut it up for you, I will cut it up for you. Did you want some more sour cream for your potato? What can I do to make you happier? And then he started to pull on me and kept saying that, excuse me, that I just want to fuck you on the steak and fuck you on the potatoes. And I took offense to that, and I kept trying to encourage him to eat. I started to eat.
Was this just him really drunk and saying nonsense?
I don't know why he was so angry that day. I don't know if it's because I got steak. I don't know. Most of the time I don't know the reason why. I couldn't take it anymore. Obviously, I was not going to be able to eat. So I started to crawl off of the bed to leave, just the bedroom. And he told me again that I'm not going anywhere. And he stabbed me in my leg, and it crunched. You could hear a noise that it made, and blood just started to come out of my leg, just like a fountain. So I got off of the bed. He's starting to freak out, and grabbed me a towel. I got a wet towel, and I'm sitting here holding the towel, and it's increasingly becoming even more and more saturated by the minute. It's just minutes. So I'm going through towels and towels, and I said, George, I think I need to go to the hospital. This is not stopping to bleed. This is serious. And he got on his knees and begged me, please don't call the police. Please don't call the police. Please don't call the police. And inevitably, he went and got my car keys and put them around his neck again, and my cell phone. So I was not able to call anyone, and I wasn't able to leave in my car. So I figured I would just go downstairs, and I'm just going to go downstairs. And I had propped my foot up on the glass table that we had, and blood is just everywhere. Blood is everywhere. I can't keep up with the amount of blood, and I'm starting to feel very weak and really weird. And he comes downstairs, and he's still begging me, please don't call 911. Please don't call 911. I kept telling him, there's something, this is serious. This is something. Because he knew that he would probably get arrested or something bad would happen to him. So I couldn't take him anymore. He was just all over me, and just, I'm bleeding. I'm bleeding very badly, and he's having me try to console him. And I kept telling him, please, I need to call 911, please. And I said, okay, just give me a moment. And I crawled upstairs to my son's bathroom, which is the furthest bathroom away from everything. And I remember holding onto the sink, and I looked into the mirror, and my lips were blue. And I knew I needed help. I needed help. And he came upstairs looking frantic for me, calling my name. And then I turned to him and I said, please, I'm going to die. I've lost a lot of blood. There's something wrong. My lips are blue. Please, we don't have to call an ambulance. If you could just take me, I'll drive whatever I can do, please, to go to the hospital for this. And he said that before anything happens, I had to concoct a story in order for him to not be arrested or be in trouble when we did inevitably get to the hospital. So I'm sitting there with this blood-soaked towel with blue lips, trying to come up with a story of what I can tell them when I go down there so he's not in trouble, and telling him that it's okay. And I came up with the story of that we were sword fighting silly after drinking with our steak knives, and he accidentally punctured my leg. And from there...
How did you get to the hospital?
Originally, he told me to drive, and...
Espera. Wait. Another story of a time they were playing and somebody got hurt? Is that what she just testified to? Is that what I just heard? This is a pattern.
And because of the amount of alcohol that he drank, and I couldn't. So he got into the driver's seat and drove me, and the entire time he's barking at me to make sure that I get the story straight. We're sword fighting, okay? We were drunk,
Did you go
being
to the
silly.
emergency room?
Yes.
Also, I feel it incumbent to tell you that now that she has said, she's testified that George essentially coached her on what to say so that he would not get arrested. Guess what's coming in? The video of her coaching him. Well played, Demi.
All right, and did you get treated there?
Yes. I was bloody, and
All right, let me show you the photograph. Can I show you these? All right, is this a fair and accurate depiction of the injury to your leg?
yes, I had to go to 2 different hospitals for it.
And you lied to medical personnel about how this happened?
Yes, they brought in sheriffs and everything.
Was it consistent with, they brought in sheriffs? Did you have to answer to the law enforcement officers?
Yes,
Did you stick with the story that you and Georgia agreed?
I did.
Judge, I'd like to offer this composite exhibit.
What was pre-marked as K will be received into evidence without objection as Defendant 6. You may publish, sir.
Thank you. And is this you at the hospital?
Yes.
Is this the stab wound to your leg?
Yes. My foot.
Is this a close-up of the stab wound?
Yes.
And was that, did you hurt your foot?
No, due to the injury, I had other problems with the surgery.
Okay. But you eventually recovered?
Eventually, yes.
Do you have a scar to that effect?
I do.
Judge, can you step down and show me?
Mr. J? You may. There's a lock, sir. Out.
All right, I don't know how best to do this, Judge, because we've got this ball. Is this the injury here? Looks like there's an addition.
I'm done, y'all.
All right, I'm showing you identification. T, you recognize that photograph?
I do. Yes.
All right. Looks like you've got an injury to your lip and to your face. Do you recall this event?
I was trying to sleep, and
Have y'all been drinking?
I'm not sure. I know that he had been drinking. This was one of the instances where I would go upstairs to try to go to sleep. And
But
he,
y'all drank together a lot, did you not?
sometimes, yes.
But there were times where he wanted to stay up and continue to drink and you wanted to go to bed.
Many times, yes.
You were done, he was not.
Correct.
Was that one of these times?
Yes.
So tell us what happened.
I'm sleeping in the bed, sound asleep, and he comes into the room and grabs me by my hair a lot of the times. And from here, he scratched me from trying to grab me, and then grabbed my hair and pulled me off of the bed, and then raked my face across the carpet. These are carpet burns.
To your lips?
Yes.
What about to the, looks like the eyebrow area?
That's from where from grabbing me, scratched me, and got a hold of me by my hair.
Why was he mad at you?
Because I wasn't downstairs with him
He wanted you to be drinking with him?
all the time.
All right, I'd like to introduce identification to you now.
What was pre-marked as T will be received into evidence without objection as Defense Exhibit 7.
Oh, permission, Paul.
You may, sir.
All right, you see the injury between the eyes and the injury to the lip?
Yes.
As you described?
Yes, and then the blood going down my eye, yes.
Showing you what has been marked as exhibit for identification, or defense exhibit. You for identification?
Yes.
Can you describe that photograph?
I can. This was the first time that I ever called 911. George and I had gone to a bar across the street within walking distance, and at some point, I asked a guy, or he asked me, somehow or another, it was over a cigarette. And he left, and I didn't know where he went, and the bartender said, oh, he left. He took your car and he left. So,
Why would he do that?
well, I found out when I got home, it was because I spoke to another man. And so I paid the tab and I walked home, and he's sitting on the back porch with the handle of vodka. And I was walking on eggshells and terrified and kind of treaded lightly when I came in, and he acted all natural and fine. So I didn't know the reason why that he had just gotten up and left with my car. So then he calls me a whore, and then he calls me a slut, and then he calls me a cunt, and gets up and pushes me. And he pushed me with both of his hands so hard that we have this little area where our washer and dryer is, and there are metal doors that are on it. And he pushed me into the metal door. And then I fell back, and he got his knees on top of me on my arms here, so I was pinned down, and was starting to strangle me and hit my head up against the metal closet over and over and over and over and over it again, and calling me a fucking whore and you're such a slut and fuck you and everything. And my tongue was flopping out of my mouth, and I thought I was going to bite my tongue off. And because of the amount of noise, I guess, my head was making on the metal door, he slid me down and got back on me, and then started to strangle me again. And it was on, we have carpet, but it's like concrete. And I was able to get my arms out from underneath and grab his throat and get him off of me. So I got him off of me, and I pushed him off, and he came up and he goes, "You fucking bitch." And he stomped my face. And the next thing I know, I woke up. I obviously blacked out. I'm obviously, I guess, yes. And he was passed out on the floor. And I woke up frantic, looking for my phone, and I immediately called 911.
Okay. Police arrived on that incident?
Yes, they did.
Is this a fair and accurate depiction of the injury you sustained as a result of him kicking you?
Stomping, yes.
A stomp?
Stomp.
With his
All I
heel?
saw was his heel.
We know this story. We know this incident. It's coming in
What
now.
was pre-marked as you will be received without objection is defense 8.
You guys, listen, Sarah, okay. So we're all listening to this, and we're all in disbelief, okay? I don't think that I think the jury, can you please work the dadgum overhead projector? Put the photo right side up so we can understand what we're looking at here, please, sir. Ugh.
That's a couple of days later.
Hey, Shakto, good to see you.
Kicking of the eye?
She's not going to get off, you guys. Wait, you got to be patient. The state knows what it's doing. I have full faith in Mr. J.
Showing you identification V, defense. Could you recognize that? You have to speak up.
Yes.
Can you identify that picture?
Yes.
Is that your leg?
Yes.
And is that just like the injury to your knee?
Yes.
Is that a fair and accurate depiction of the injury you sustained to your knee?
Yes.
Do you remember how that happened?
Yes.
Did you tell the jury?
I was trying to get off of the back porch, and he grabbed me and pushed me, and it was a rock or a really sharp piece of mulch.
A sharp piece of mulch. I'm done. That's it. I
guess
quit.
just happened to hit my knee just right on whatever it was.
Were y'all drinking?
We were always drinking.
Why did he push you?
Because I wanted to get off of the back porch.
He wanted to stay out there?
Yes.
He wanted you to be with him? What's the deal with him wanting to be with you all the time?
Security, I guess. I don't know. I don't know.
Did you do your best to please him?
And then some, yes.
All right, I'd like to introduce an evidence identification.
What was pre-marked as V will be received into evidence without objection as defense 9.
Now, Ms. Boone, were you treated for this, or did you self-treat? Show the jury now.
No, that was just, I got the first aid kit that I had for my son and I just cleaned it up.
What?
I said I got the first aid kit that I had for my son and I just cleaned it up and put a Band-Aid on it.
All right, I'm showing you identification W. Defense identification. You recognize that photograph?
Yes.
What is that a photograph of?
This is a photograph of my arm.
And is that a fair and accurate depiction of your arm with some type of injury?
Yes.
Do you remember this event?
Multiple times, yes.
Well, I'm talking about this isolated event where this photograph was taken, the injury you sustained.
Yep.
Who injured your arm?
George Torres.
Do you remember this event?
Yes.
Did you tell the jury about it?
This was one of the instances where I would try to pull away from him, and I don't know how my arm started to do this, but from him pulling from this way, how hard he would pull, with me trying to struggle to get away from him, it would leave these bloody under the skin splotches.
So he wouldn't hit you sometimes, he would just grab you and pull you.
Yes, for me trying to pull away from him, that's the point of it doing this, from me pulling away from him.
Now, this is one of the many times y'all were both intoxicated.
I mean, I can't say for sure that, yes, but whenever it would happen, yes, it would be drinking.
Identification W in evidence.
What was pre-marked as W will be received into evidence without objection as defense exhibit 10. You may, sir.
All right, it doesn't look like a wound or anything. Objection to commentary.
Sustained.
Yeah, hush up, Owens. You're not testifying.
You said it's just from the grip, him losing his grip?
Yes, it would be from me pulling away from him and whatever under the skin it was that it was disturbed from the amount of pressure of him holding and then pulling from me would create those on my arms.
I'm going to show you defense exhibit X for identification.
Yes.
And what is that a picture of?
This is a picture of my ear, side of my head.
Is that a fair and accurate depiction
Yes.
of the injury you sustained by George Torres?
Yes.
Do you remember this event?
Yes.
Were you drinking?
I at the time was not drinking.
On this event, you had not consumed any alcohol.
I mean, I may have earlier. This was another, I was in the bed trying to sleep.
Where was George?
Downstairs drinking.
All right, and so you were wanting to go to bed, and he wanted you to stay down there with him?
Yes, I was in the bed.
All right, tell the jury what happened on this event.
I believe this was the instant where I was in the bed and I used to barricade the door with our dresser.
Why didn't you just lock it?
All of the locks were broken in my home.
Why?
They were from George taking them in, including my son's. At one point, I could seek refuge in my son's room, but he broke that one as well.
Well, tell me, explain how that happens. Tell the jury. We can't read your mind.
George wants me, which he has told me numerous times that I am to be with him at all times and doesn't like to be apart from me or away from me. So whenever it was even just to go to the bathroom, sometimes he would go with me. And you have to understand, I have a 2-story, 900 square foot townhome, so there's not many places to go. So it just happened to be that it would be upstairs or downstairs, or I'd be in a particular room or not. So inevitably.
Did you want some time away?
Yes, I did. Even if it were just him upstairs or me downstairs or vice versa. So I rarely got to sleep. This was one of the instances because I had barricaded the door with our, 200-pound dresser that we had. And then I had my nightstand barricaded up against the bed, to where it was even more difficult from the prior times of him breaking in. And he would, I don't know how he would ever do it, but he would get himself in through the crack of the door that he would be able to wedge the dresser in the nightstand. And he pulled me out of the bed and told me I was going to die. And I believe it's this incident, and then punched me and
Punched you in the side of the head?
yes, in
Was
my
it-
temple and everything.
Was it an open fist or a closed fist, or do you know?
It was fully closed.
Like identification X introduced in the evidence?
Was pre-marked as X will be received without objection as Defense Exhibit 11.
Part I'm showing you this exhibit. That's you? Did you get any treatment?
All right, I just want to say something really quickly for commentary and fair use purposes. I don't doubt that Sarah suffered injuries at the hands of George. I don't doubt that George suffered injuries and ultimately his death at the hands of Sarah Boone. Okay. However, you can't kick in a door without leaving some damage. Okay. So I would expect if George Torres was able to push a door open with a 200-pound heavy, I'm not even going to say 200-pound, just a heavy dresser full of clothes and a nightstand in between the dresser, the bed, in between the dresser and the bed, there would be some damage to the door. So what we shall be doing, probably not today because this is going to be ongoing. I think she's going to be on the stand on direct for the rest of the day, is we will be looking back at the photographs that were taken of their home, specifically that bedroom door. Now, I recall from the body cam footage that it did not appear to me that their bedroom door had any damage to it.
Treatment for that? Medical treatment?
I know the police came, but I don't remember. I remember it hurt for a good solid 2 weeks after that.
Was this one of the incidents where the police were called?
Yes.
Oh, fantastic. Then there'll be body cam footage. We'll be looking, I'm sure the state will admit that into evidence.
Now, do you recognize this photograph, which is identification Y?
Yes.
Was that the date of the incident? The date of this event?
No, it happened prior. I mean, but this picture that was taken of the,
This picture was taken, would have been taken February 24th of 2020?
yes,
And do you recognize that as your close-up facial?
yes,
Is that a fair and accurate depiction of how your face looked on February 23rd of 2020?
yes.
What's the significance of this picture?
Again, because I was sleeping, George was upset with me and came in with a metal curtain rod and bent it and snapped it in half and then crunched me in the forehead with it. And it started to beat the furniture that was in in a bedroom. This is probably a good month before or after it had happened, before I really do believe that I should have gotten stitches, but I was not allowed to go to the hospital.
Judge, I'd like identification why introduced into evidence.
It was a gash.
What was pre-marked as Y will be received into evidence without objection as defense 12.
Is that the same curtain rod that you mentioned in the 2-hour interrogation video?
Which they didn't take, yes.
This was photographs that were taken, I guess it would have been the crime scene? Was it the crime scene investigator that came out and took photographs?
I don't remember who it was, but yes, someone did on the day of the incident.
Was it different from the extraction, the phone extraction expert? Was it somebody different?
I think.
But is it this wound right here?
Yes. And remember, that's a month later.
And then on that same date, same time, they took this photograph as well, which is identification R.
Yes.
All right, and what does that do?
I believe it's from holding the baseball bat, and
Is that an injury to your hand?
it's a bruise.
Was that taken, February 23rd, 2020, when the investigators came out on February 24th?
Oh my God, I have to stop. Owens, this is your case, bruh. Who's running this show, you or Sarah? You don't even know when this happened? Let me just be quiet.
I'd like to introduce identification R.
What was pre-marked as defense R will be received into evidence without objection as defense 13.
So I believe that what's going to end up happening is this. Her expert witness is going to get up there and testify about battered spouse syndrome and why the battered spouse will take back their abuser. Okay. They're going to explain the thought process behind that and everything. Okay. But what I think is really going to be the most impactful for the jury to see and to hear is the video of Sarah coaching George on what to say so that she doesn't get prosecuted. I think that's going to be, there's a lot of ways to impeach this testimony. So let's keep going.
Yes, sir.
I promised I would be quiet and I've already lied.
But February 24th of 2020, is that what you were wearing? Is that you?
Yes.
And there's some discoloration up here of your palm. You see that?
I do.
Is that from you jabbing him with a baseball bat?
Sustained.
Do you know how you suffered that injury?
I believe it's from holding the baseball bat.
When you poked him with it?
Yes, trying to get his hand back in.
I object. To me, which I barely can see that bruise in the photograph, whatever. Usually that type of injury is a result of you hitting your hand against something. So I highly doubt that it is from you just simply holding the bat and poking him. No, I don't believe that. I said I would be quiet. I need to stop.
I'm showing you defense identification N. looks like 5 photographs. Can you look at those? See if you recognize them. All right, well, let's continue now.
Yes.
And are those fair and accurate depictions?
Yes.
As a composite of the events that occurred in relation to George Torres and your TV?
Yes. Yes.
All right, are those stills of a videotape that you took?
Yes.
And is that videotape, was it on your phone?
Yes.
So when law enforcement sees the phone, they would have had access to this video?
I believe so, yes.
And tell me about it.
Lucas liked to watch cartoons and play video games on the big screen, this is the big screen, and I would have to call Brian to come over sometimes to help me figure out the Fire Stick and whatever platform or whatever it was that Lucas was trying to view his shows and video games on. And I don't remember how George found out that Brian had come over. I believe because it was actually fixed and he knew that I didn't know how to do it. Found out that Brian had come over to fix it, and
was he jealous of Brian?
I don't know if he was jealous of Brian. I think that he had a fear that I somehow would go back to Brian. So I think by Brian helping me with things for Lucas, he just didn't want him to be interacting with me at all.
So Lucas wasn't over here this day, was he? No. Brian wasn't over here this day.
He may have been, I can't remember when he actually fixed the television for Lucas.
But y'all were drinking this day.
I know he was for a fact, yes.
Chances are you were.
Probably so, yes.
Okay.
I would agree.
So how did it end up badly?
He accused me of sucking Brian's dick and told me that he was going to break my face with the bat, that he was going to make me unrecognizable to my son with the bat, and then told me that he's going to destroy my fucking television, and then I was going to remove it from the apartment. And if I didn't, I was going to be, again, unrecognizable to my son.
So did he grab the bat?
Absolutely. He already had that in his hand, and he told me that I had to videotape it.
Did you videotape it voluntarily?
No.
All right, but there is a video, but I'm going to go ahead and ask Judge if I could introduce this identification of these 5 photographs into evidence.
Okay. Is it O or N?
I have O being a composite with 5 photos, that's not having a single photo.
We're moving in O. Okay. All right. What was pre-marked as O will be received into evidence without objection as defense 14.
All right, so these are some stills from the video. This was George that particular day holding the bat.
You guys telling me that I'm going to take the television out once he destroys it.
He wanted you to take the television out?
That or I was going to help him, but either way, I was taking it apart and removing it.
And what is this picture of?
In the process of him destroying my television.
While you're videotaping?
Correct.
Is that the result?
No. After that, he ripped it off of the TV stand.
Did you later pass out?
Like he usually does.
What's he drinking then?
I don't know. Vodka and something, I'm sure.
I'm showing you identification N. Did you recognize that?
It's my living room in the stairwell.
All right, were those, was that a photograph taken by a crime scene?
Correct.
Is that a fair and accurate depiction of your living room and stairwell?
Yes.
And I'm going to try to introduce this as identification 9 as an exhibit.
No, it's pre-marked as M, correct?
It's got N.
N, I apologize. What was pre-marked as N will be received into evidence without objection as defendant's 15.
Can you tell us a little bit about this room?
This is my living room. This wall that we have over here with the hearts, that's where we would display all of our artwork. We were in the process of taking it down to add more, so he could continue to be entertained. The bookshelf over here is my son's bookshelf with all of his toys and little guns and musical instruments. He's got a little karaoke machine down here, his guitar. The stand right here with the red bucket on it, that was the television stand. And then my back porch area and the dog bed here.
And then it looks like in front of the bookshelf at the foot of the stairs is that a doggy?
It's a baby gate, but my dogs would wander upstairs sometimes and go to the bathroom sometimes when we couldn't get them out. So I would, at nighttime, or whenever we weren't home, make sure that they didn't go upstairs. And plus Penny was blind.
There's an allegation that you pushed George down the stairs
Apparently,
or got him in the suitcase upstairs and pushed him down the stairs?
supposedly,
Did that occur?
absolutely not.
Is that bookshelf disturbed in any way?
No, nor the plant next to it.
I'm showing you composite 2 photographs, identification M. Did you look at those 2 and see if you recognize them?
Yes, this is me sitting on the back porch with my dogs. And as you can see that we are both drinking.
All right, who's taking the picture?
I'm guessing George's, or maybe it's one that Lucas wasn't on here, so it had to be George.
How can you tell y'all are drinking?
Because there's a cup here and then he has a beer.
And there's 2 dogs. There's one sitting next to you. Who's that?
That's Penny, she's the blind dog. I used to have to pick her up to put her somewhere so she would stay there because she was unfamiliar with the area, especially since we moved from my marital home to the townhome. So most of the time Penny would be close or next to me.
Who's next to the film?
This is little guard dog Tess. She was the deaf dog. And this is the fence here.
Well, I'll show them.
Okay. But this is Tess, and then this is deaf, blind. Penny and Tess.
All right, and then the second one.
This is Tess on the back porch taking a nap. She was never far from me.
All right, when George was sober, how did he treat the dogs?
Nice. I don't know if he was a pet person, but I mean, he was nice. If I needed him to feed them, he would feed them.
Were there times when George was drinking where he would threaten to harm the dogs?
all the time.
Are we gonna have to tell the jury?
One of the worst threats was Penny being blind. He would actually leave the gate open in the back. He wouldn't threaten me to do it. He would actually do it on nights that I had to go up to sleep or I fled the night before or something. And would tell me that he hoped that I would come back and find her bloated body dead in the pond across the way from our townhome. And Tess was notorious if I wasn't there to go look for me, and would say that he would hope that I would have to scrape up her dead body from the street that was out in front of our apartment complex.
Why was George upset with you? Why was he threatening to harm the dog?
Anything that he could get to try to have some type of hold over me.
Control?
And he knew I loved my dogs very much, especially that they were handicapped.
Were they afraid of him?
Yes. Penny would hear his voice and instantly go underneath the dining room table that we had. Tess was always fractious and very, very quick with his movements, but she was never far away. They never showed their teeth. They never growled. Tess would occasionally bark, but it was very rare. And he used to kick them and just.
For what reason would he kick them?
Penny would try to find me because she's blind.
Speculating in the mind of the dog.
Sustained.
I'd like to move identification in and evidence.
Any objection? Was pre-marked as M will be received into evidence without objection as defense 16.
All right. Can you describe this for the jury?
This is again is our back porch, and this is the fence that I made for the dogs to have a little bit extra space. Penny is next to me. She's the blind dog, and then Tess is down here guarding the gate.
Are these fake rabbits? Is that?
Yes. I used to call my son when he was a baby. He was my bunny rabbit.
Overruled.
He was my bunny rabbit, so I used to collect bunny rabbits, and so I have rabbits here and there throughout my house and in my little garden area.
All right, this is the alcohol you are consuming?
Yes.
And this is a close-up of which one?
This is Tess. She's the deaf dog.
How old were these dogs at that time, 2020?
Gosh, maybe 9, maybe 10.
We approach.
Yes.
I have to agree with Scott's comment in the chat that just because Sarah is a terrible person doesn't mean that doesn't make George an angel, right? I think we all agree that they were in an incredibly toxic, violent relationship. What's really what's really in question here is, was Sarah justified? Was this self-defense? I don't think so. There's a lot of her testimony that I don't find to be believable. It doesn't make sense to me. And it's not that so much this specific testimony that she's giving here. It's actually more the testimony that she gave about that night and the 11 minutes in between those videos.
All right, members of the jury, it's 4:03. By show of hands, would you like to take an afternoon break at this point in time? Okay, court sees no hands.
Wow.
We may have to work also a little bit past 5 o'clock, maybe going to between 5:45 and 6 this evening. I know juror third from the right, you may have to make a phone call as to that. Does anyone have any concerns about working a little bit later today till 6 o'clock? If you have those concerns, please raise your hand at this time. All right, court sees no hands. Ma'am, are you in a position to step out to see if you can get assistance with childcare, or is that not an option for today?
I'm actually all set for today. She's already taken them off.
You are? Okay. All right. Excellent. Very good. Thank you very much. I appreciate you all. With that, Mr. Owens, you may continue.
Judge,
Yes, sir.
I think one of the jurors raised their hand.
Oh, I'm sorry. Yes, juror fifth from the right.
Are we gonna get a break before the 5:45 mark? Because if not, then yes, I would like a break.
Then I tell you what, let's go ahead and take it at this time. We'll give you all.
Okay. We're behind, so we'll catch up. It's no biggie. All right. For me personally, and I really do think that the jury is going to listen and weigh all of the evidence, all of the testimony. Okay. But just speaking to Sarah's testimony right now, today, for me, if I were on the jury, the most important testimony for me would be what happened that night. And there's a lot about the testimony that Sarah gave respective to that 11 minutes between the two photographs that don't make sense to me. For example, it appears from the testimony we're listening to currently that Sarah frequently documented incidents of violence. And what doesn't make sense to me is her choice to record when there was no violence, if George, she had total control. I mean, George was in the suitcase. He wasn't able to get out. And it doesn't make sense to me that she didn't pick up her phone and record that incident where he was threatening her or whatever, because she says it went on for 11 minutes, that there was, I think that the other issue, as Kathy has pointed out very astutely, is take all of this and add the words, "for all you've done to me." In my opinion, that video, what that really shows is that this was punitive and intentional. And it does not make sense to me that she picked up that bat and hit him with the bat and then expected him to be able to get out of the suitcase. None of the, and I understand that a lot of Sarah's thought processes don't make sense to me, but she fled before. I'm not even talking about getting the cops involved. Okay. But she's fled before. She lives in Florida. All right. We don't have, bars do close around here, but it is, where she lives, is near the Orlando area. There are Ubers. She could have fled, but she didn't. Instead, she expected him to get out of the suitcase after she put him in it, or zipped him up in it, I should say. After she zipped him up in the suitcase, assaulted him with a bat. And what was she doing upstairs? Waiting for him to get out and it be over with? That thought process doesn't make sense to me. The only reason that you would go upstairs, intentionally or not intentionally, fall asleep, is because the threat was over with. There was no threat. You weren't up there. You didn't barricade yourself in the room. You actually expected him to come up to that room And what you thought that that once he got out of the suitcase after you'd assaulted him with the bat, that he would have cooled down? He would be less angry? I don't think so. I noticed that Owens asked her if the now I got distracted by chat. I'm going to address that in just a second. Not in a bad way. I'll highlight it in a second, but I got to finish this thought maybe. None of this makes sense to me. Her story does not make sense. And Owens did ask her if she pushed the suitcase down the stairs, and she denies pushing the suitcase down the stairs. What I noticed that he did not do is follow that question up with, well, then what was that noise? What is it that they're talking about? What do you think happened? And I mean, I don't think he can answer what she thinks happened. But again, he points out as evidence that the suitcase didn't go down the stairs, that the bookshelf is all back in order. Well, there were hours and hours and hours between 10:30, 11 o'clock, which is when the neighbors say they heard this thud, this big loud noise that shook the wall, and the time that those crime scene photos were taken. I mean, I don't get it. Okay. Now, hang on just a second. I missed this. Neat Noodle gifted a membership. Thank you very much, Neat Noodle. I appreciate that, babe. Thank you. Debbie, thank you for becoming a member. Thank you both very much for supporting me and the channel. I appreciate that very, very much. Okay, now let me scroll up a little bit. I should have highlighted. I knew this was going to happen. Here it is right here. Okay. So Melissa says, on X, it's being reported Sarah has a girlfriend and she's in the gallery, and that's why she's smiling. Does your girlfriend want to see you go to prison for the rest of your natural life? Or at the minimum, the next 22 years with credit for time served? So we'll round up and say she's got credit for 5 years. She's going to do, 17 more, because you think it's appropriate to be making eyes at each other in the courtroom during this kind of testimony. You think that's a good idea? Like, I don't care that she is in a new relationship. That doesn't matter anything to me at all. I don't care one way or the other. It's just, I feel like at the end of the day, this is supposed to be, testimony of terror. And she's smiling and smirking and, making eyes, and it just seems inappropriate. And that's what the jury is going to see as well. They're not going to see, they're not going to think that or know that the reason she's looking at somebody specific and smirking and smiling and making eyes, all they're going to see is what she's doing on the stand, which is exactly what we saw. And it's going to leave an impression. I think that I don't think that's what she said, Bouchette. I don't think that she was waiting for them to come up. I don't think she was waiting for him to come upstairs to have coitus, as it were. I don't recall her saying that. And, that is something that I would remember. I really would. I would remember that. So this is a good point that Sunflower Girl makes. Sunflower Girl says it's easy for people to say she should have left regardless. She as it looks, was absolutely abused. Sounds to me you're not taking her abuse into consideration. What she did was wrong indeed, in my opinion. I don't know. I think that the fact is they were both abusive to each other, both of them. That's what I think. And I am taking it into consideration. I am taking her abuse into consideration. And I do think that this is an element of abuse that people don't understand, that the victim takes the perpetrator back. But what I would submit is, do we really know in this situation exactly who the victim of battered spouse is and who the perpetrator of battered spouse of who is the perpetrator? I would submit that at different points in the relationship, they were both. At different points, George was the perpetrator, but he was also the victim. At different points, Sarah was the victim, but she was also the perpetrator. Because I don't think that human beings are capable. I do think that there are instances where there's a very clear victim perpetrator and they don't switch roles, right? Until something happens like this, right? Where, because I do believe that there are times when spouses have had that they've been in fear for long enough, and one day they say this is the last day, and they end their abuser's life. I do believe that those times happen. But I believe also that these circumstances exist where the parties involved are both the victim and the perpetrator. And that I think there's a lot of, I think that things in life are rarely black and white. I think there's a lot of gray. And I don't take any of the, and I know you're not saying that this chat is not, taking into consideration or making light of the situation, because at the end of the day, somebody lost their life. George is dead. So it's not a light situation. I just think that there are moments that some of the testimony is kind of ridiculous, and Mr. Owen's behavior is frankly quite ridiculous the majority of the time. I just,
All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State.
Nick Ketcher on behalf of the state. William J. for the state.
Defense.
James Owens for the school. Tommy Henderson for Sarah Boone.
All right. Ms. Boone, let's go ahead and bring you back up to the witness stand, please.
Judge, we're going to try to go with 6 today.
Yes, sir. That's the plan.
yeah, since you wanted to dilly-dally all morning, Owens, like those times.
You said about 20.
All right, we're ready to bring back in our jury.
Yes?
All right, let's do it.
Oh, Judge.
Hold on.
Oh, she's up there. I'm sorry. I thought we lost.
Exactly, Violet. Nobody deserves it. Nobody.
Jury entering.
Oh, thank you so much, Sunflower Girl. I appreciate that. I do try. We need a little levity sometimes. It's important. Laughter is good for the soul.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
I do.
All right, y'all can be seated. Thank you.
I'm particularly interested in, and I will be listening to when the defense expert witnesses take the stand and when the state's expert witnesses take the stand. And I will be listening with an open mind. Uh-oh.
Approach for a moment.
We're already approaching. Oh, dear. And we're approaching after something the bailiff. Uh-oh. I feel like Gertie in E.T. when E.T. was making all the planets in Elliot's room. You know, he was making him spin around and showing where
All right,
he
members of
lived.
the jury, again, if you could just raise your hands to confirm that you complied with the court's instructions during the last break. Record reflect all hands have been raised. All right, with that, Mr. Owens, you may continue your inquiry, sir.
Just based on the court statements, identification A, I'd like to, this is one of the photographs that we introduced. Is this injury to your ear?
Yes.
And then this is your living room. This is identification C, the blow up.
Yes.
Chapdell, please go watch E.T. I promise you, you will not regret it.
Identification D. TV. Identification E. Is that your arm?
Yes.
Oh my gosh.
Identification F. Is that your knife wound?
No, Violet, we don't. We don't know how much her marriage settlement was. No, tell me, Chacto. I love Fast Times at Ridgemont High. It's one of my I like Spicoli. He's my favorite. And Kayleen. MK's off work and Boone's still on the stand. That's thanks to Owens' dilly-dallying.
Identification H.
No, I'd like to hear it from you, Chacto, please.
Identification I. See your face shot?
Yes.
With the lip, the eyebrow.
Damone does have some good one-liners too.
Identification B. And this is the back patio of the dog.
Why do you have to slam them on that podium, bro? Come on. Some of us are wearing earbuds. Be considerate. There's other people.
Okay, I'm gonna bounce a little bit.
Aloha, Mr. Hand. What are you people on dope?
Let me go back to the night earlier in the evening when I think y'all may have been out on the back patio and you had suggested to George to call the children, but then did he call his brother or his brother called George? Do you remember?
George called his brother.
Okay. And you made a statement about telling something. Explain that to the jury.
I told him to tell his brother about you choking me the other day. This is a separate choking incident. We had been drinking, and I wanted George to tell him, but
Hey, Adrian, good to
tell
see
him,
you.
so I said it in the background, so he would be aware.
What did you tell him?
Tell him why you choked me, or that you choked me.
Now, you heard the testimony of the two neighbors, the boys that live next to you,
Yes.
and you heard that they were actually questioned. I think the audio, they were audio interviewed. You heard from Detective Copsel. I think it was a couple of days later on the 25th of February or 27th of February.
Yes.
And you heard their testimony earlier this week.
Yes.
Where they hear a kind of a thumping sound starting at the top of the steps, ending at the bottom.
Yes.
Have they got the night wrong?
Yes.
So explain to the jury that.
So it was the night before. Again, I was sleeping, and in the middle of the night with the door barricaded, he came in and ripped me out of the bed. And first got me with one hand, and then got both hands and pulled me completely off of the bed. And then, like a caveman, had my hair like this and was going down the stairwell, taking me with him to come downstairs so I could sit and drink with him.
Do you believe that's the noise that the two neighbor boys heard?
I absolutely do.
Objection. First of all, Owens, you're blocking the camera. Can you scooch? Rude. Second of all, Sarah's own admission in that interrogation video, what did she say? Things were going great. It had been a long time since George and I had been in a fight or an argument. He was doing really well, the classes, all the things, right? Isn't that what she said? Okay.
And it was just the night before.
Correct.
Now, some of the time when this abuse occurred, you called the police.
Yes.
And other times the police were not called.
Correct.
I want to refer to you the first time, I believe, you mentioned the 911 call. I believe that was July 25th of 2018.
Yes.
And that was the incident in which George had kicked you in the eye.
Stomped me. Yes.
Stomped you in the eye. And you had grabbed his neck.
Yes, I was able to get my arms out from him pinning me down with his knees and grab his neck.
So law enforcement came and investigated.
Yes.
And both of you were arrested.
Correct.
Do you recall asking the officer when you were arrested, why am I being arrested?
Many times, yes.
Do you recall asking the officer, why am I being arrested?
Yes.
And do you recall making any other statements to law enforcement as to why you did what you did to George?
That was the first time ever that I actually officially fought back.
Did you tell the officer that you were fighting back?
Yes, because I was complete shock that I was getting arrested because of it.
Owens, you better put on the body cam footage before the state does.
Now, on the 2-minute video, the suitcase video, you mentioned to him, I think you said something, I can't breathe. He said, I can't breathe. And you said, that's how I feel when you're choking me. Were you referring to an isolated incident of the night before, 2 nights before, or whatever, or were you referring to in general?
In general, the more than 2 or 3, 4 times that he had done it.
Okay. And then the part about cheating, he didn't physically cheat on you.
No, he did not.
Okay. And just, I don't want to go into a lot of detail, but what are you referring to?
George was, I believe, addicted to pornography, and a lot of that would be found on my phone from him supposedly wanting to call up job interviews. And as a solution, I sat him down and I explained to him, to me, that's you visualizing yourself with someone else, or at least having a pleasurable moment with someone else or watching other people. And to me, I told him that I considered that cheating on me.
Okay. And so he would download that on your phone?
Yes.
Why did you stay with him? You got to tell the jury.
As anyone who has ever been in love, or when you love someone, or primarily someone or something, you go above and beyond, and you tolerate and you endure and you persevere, and you try to make that person as spectacular as you possibly can, no matter the sacrifice that you may have to go through, to serve someone else in a positive light so they can be better people for themselves, and to just make them a happier person. And love is very strong, and love is very deep. And love, I believe, is not fully understood in a lot of ways for how different people react to it. And I very much, deeply, and passionately love George. I love him to this day.
Did you not want to be alone?
Beginning through my divorce, it was very nice to have him around, and he was a man to me, and I felt protected, and he was very nice, and as lame as it sounds, he used to compliment me, and it made my day. So yes.
During that period of time when you first started seeing George, would it be fair to say that you had low self-esteem?
Yes.
Now, we talked about this previous arrest where you told the officer you were fighting back and you got arrested. Now, I want to talk about your conversations with law enforcement. But first, I want to ask you, why did you go to the police station that day when you were interrogated there and saw the 2-hour video? Tell the jury.
The day of the incident, the detective Copsell gave me her business card with her personal cell phone number on it, and said if I happened to remember anything or anything that I would like to add to the day, for me to not hesitate to give her a call. So throughout the rest of the evening, something was off. I didn't feel comfortable with what she told me and how she told it to me.
How long were you at the scene?
Gosh, all day, from the moment that they were there to the moment that the coroner's van drove off.
All right, when it ended, did you stay in your home?
No, I raced inside and collected some pajamas and a toothbrush, and I went over to where my son was at my ex-husband's house.
Did you wake the dogs?
I didn't even feed them. It was so fast.
All right, and then once you got over to your ex-husband's, what happened? As it relates to Detective Copsel.
Something just wasn't sitting right with me, and I had a suspicion that she just wasn't being honest with me, so I took it upon myself.
Sustained.
So you called her. Tell us about that.
I called her and I told her that I felt that she was being dishonest with me. She originally had told me that due to her being pregnant, it would just be a lot easier for her to have me come down to the station to pick up my phone. The original plan was for she and Detective Loman to return the phone to my apartment. But she said that it would be a lot easier for me to just come down and pick it up because I remember when I was pregnant. That's what she said. You remember when you were pregnant. So I said, I feel that you're tricking me and I feel that you're being very sneaky about something and I don't believe that you're being honest with me. And I said, regardless, I'm still going to come.
Sustained.
So you agreed to come, but you understood it was to get your phone?
Correct.
All right, you came that afternoon to the station?
I did.
And the original agreement was they were to come to you?
Correct.
All right. When you got to the station, what happened?
I thought I was just going to be picking up my phone. My car was there. I had everything in my car. It was just a regular, I'm just going to go in, maybe sign something and pick up my phone. And there's people that are over here at the windows. And I thought that I was supposed to go over there to get my phone. And Detective Lowen came down and said that my phone was upstairs. So if I would just follow him upstairs, that's where my phone was. And then I was taken into I guess it was an interrogation room, and they told me to sit down, and that then I guess the interview or interrogation began, and I just simply kept getting my phone.
Sarah, tell the jury why.
Yes. You may proceed.
Ms. Boone? Ms. Boone? Tell the jury why you lied to the police.
I lied to the police. Basically everyone, because I was extremely fearful of being arrested. I made the first attempt of me calling 911 by telling them what happened, and I thought that they were going to help me, but instead I was arrested for calling 911.
So you made the decision to lie.
I did.
Did you stay with that lie?
I did.
Are you telling the truth today?
I am.
Now, let me take you back to the to this incident. Is it fair to say that when Jorge Torres is sober, he commits no violence against you?
No.
Is that fair to say?
Yes.
Is it fair to say that every time that he's intoxicated or every time that you're hit by him or harmed by him, it's when he's intoxicated?
Yes.
As a result, when he's drinking, does it change your outlook?
Yes.
Could you explain that to the jury?
I'm always fearful, paranoia.
Why?
Because I try to protect and defend myself for fear something happens at the last ultimate second.
But you're always that way, fearful. Is it because of these prior incidences?
Absolutely.
Do you try to placate him?
All the time.
What do you mean?
With the puzzles and the painting and feeding the ducks across the way at the pond, listening to music, trying to go for a walk on the trail, anything that I possibly can. I told you I was running out of things to entertain him with.
Why do you think, George, what bothers him?
Sustained.
Does he tell you?
Sustained.
As a result of how he behaves towards you in that intoxicated state, how were you feeling the night of this event?
Objection has to be answered.
Overruled.
Extremely nervous, anxiety galore, just, I can never relax.
When he's drinking?
Yes.
And the state of intoxication that he was at the time of this event, is that the state that scares you the most?
It's the tone, yes. There's a lot of alarms and red flags that go on throughout the day or night or whenever it is that we are drinking.
Objection, non-responsive.
Sustained.
Tell us about that. How that does that heighten your sense of safety,
At all times.
but especially when he's drinking?
Oh, yes, all the time.
And then his mood?
Yes, it depends on what mood he's in that day.
Well, do you have like a sixth sense of how he's doing?
Yes, I knew George very well.
Objection, non-responsive. Yes or no?
Sustained.
Can you tell us what you mean by that? Sixth sense, or knew him very well?
I guess you can say that I was trained by fear with him. Just, it wasn't fun anymore when we would drink and we would hang out on the back porch. It wasn't fun anymore because I knew inevitably that something was going to happen to me one way or another.
Ms. Boone, you know, those bruises that we saw of him, they look pretty deep. Tell the jury what you were thinking.
From the bat, you're
Yes.
saying? I didn't want to die that night. I can't describe it to you. It's terrifying love to a certain degree, where my plan was to show him the next day, and just I wanted him to be better and treat me nicer and be the person that he was when I originally met him. And I knew that was in him still. I knew that it could be found, and I just couldn't figure out what it was that I was doing wrong in order for it to not be back to where that was. And I was tired of living in fear and just sick all the time of figuring out how I can entertain him so I don't die, and continue a relationship with my son and try to live a normal life. That wasn't a normal life for me. And just, I bottom line is I didn't want to die. I would have died, or I would have been disfigured or maimed, or if it weren't me with the bat, it would have been him if he were to have gotten out.
Thank you. That's all.
Any cross-examination?
Here we go.
George knows somebody named Crystal? Did you ever mention Crystal in your text messages about being one of his bitches?
I don't know. I don't remember.
How about Christine? Did George know a Christine?
I don't know.
How about a Pamela Erickson?
These may have been people that he was communicating with on whatever the platform was.
On your phone?
I believe so, yes.
And did you find these communications?
I believe I found one or two of them from some of them.
And did you send a long letter to his family to relay to him about George and his girls that he was cheating on you with?
I believe so.
Okay, so you do know those names, right?
I don't remember them. It's been however long.
Okay. Now, on February 24th, 2020, you called 911 at about 1 p.m., correct?
Yes.
And at that point, you were still feeling a little intoxicated, were you not?
It was more shock, but yes.
So you agree that you previously stated, I was still, I believe, intoxicated to a degree?
To a degree, yes.
So 1 p.m., it's about 14 hours after 11 p.m. the night before, correct?
I'm guessing so.
Well, 12 hours prior would be 1 a.m., and then 12 a.m. is 13 hours, 11 p.m. is 14 hours, correct?
Okay.
And you were present here for the medical examiner, Dr. Zadovich, to testify, correct?
Yes.
And you heard her talk about all the effects of ethanol that has on the human body, correct?
Yes.
And she also mentioned something that it, on average, dissipates at about 0.015 an hour. Do you recall that?
I believe so.
So would it be fair to say that if you're still feeling the effects of the alcohol at 1 p.m., so that's 14 hours, 0.015, you were at approximately about a 0.21 at 11 p.m. the night before. Do you feel like you were 2.5 times the legal limit at that time?
I don't know how you came to that number.
Judge, I'm going to object.
Approach.
Mr. J did the math. I'm sorry, you guys. There's something about Mr. J's level of snark that I thoroughly, thoroughly enjoy. And to be quite honest, I think it has something to do with the fact that I feel like if I had ever gone to law school and become a lawyer and were working as a DA, I don't even think it matters what, whether I was working as a DA on, to prosecute, or whether I was working as a defense attorney. Because I definitely think that if I would have been an attorney, I would have been in the criminal attorney world. I do feel like the way that Mr. J is during some of the questioning, I do think that those are kind of the way that I would ask questions. I think that I would.
You may proceed.
So you testified earlier that you all had about half of one of these bottles left from the night before, correct?
Yes.
So would you agree that this?
All right, you guys feel that we need, we need this palate cleanser, not, okay, yes. Okay, it's time for the palate cleanser that is Mr. J. Okay, let's continue.
This is one of the 3 bottles that was purchased between February 22nd and the 2 that were purchased on February 23rd of 2020.
I'm guessing maybe it's like the bottle, yes.
All right, and it's 1.5 liters. Would you agree? And when you say half, are we talking about to the top of the label was left from the day before?
Oh, goodness, no.
All right, a little less, halfway through the label?
It's right about.
Okay, about halfway through the label. So in addition to halfway through the label, which you began consuming after going to public at about 12:15, correct? So you all would have began consuming around 12:30, is it fair to say, when you got back?
I can't call exactly.
Okay. And after finishing what you all had left over from Saturday, the 2 of you consumed 2 1.5 liter bottles, correct?
I'm not sure about the second bottle that he purchased, if it was empty or not at the time.
Well, you did mention that the police would find 2 empty bottles in the top of your trash, correct?
Yes.
And we did all see that in the photographs, correct?
See that
Two.
they empty in the garbage, yes.
All right, and you say you were about 100 pounds at the time? And we all know Mr. Torres was 103 pounds at the time of his death, correct?
That's what he said.
All right, so that's 3 liters of wine between 200 pounds split between 2 people over the course of a day, correct?
Yes.
And you testified today that you were intoxicated at the time that this occurred, the videos between 11 and 11:30 at night, correct?
Yes, at some level, yes.
Now, what does that mean to you? Previously, have you indicated that that means the room is spinning? Do you ever recall saying that?
I do.
So what was your level of intoxication at this point in time when the first video was filmed at 11:12 p.m.?
Do you mean from lack of sleep or alcohol?
From the alcohol.
What was my level?
What were you feeling? Did you have trouble with your balance?
I was more tired than anything.
Did you have trouble with your balance?
I don't believe so.
So you were able to flip a suitcase over with a 100-pound man in it, right?
I mean, yes, it happened,
Okay. How about your speech? Do you feel like your speech was slurred?
clearly.
How about your inhibitions? Do you feel like you were doing things that you wouldn't do when you were sober?
I wasn't thinking about that.
Well, on reflection, do you feel like this is something you would have done when you were sober?
I didn't know me and George.
I'm just asking you, looking back on this, when he's in the suitcase and you're telling him how you feel, and then you wait 11 minutes and you film another 22 seconds, and then you go upstairs, upon reflection, is that something you would have done and left him in there had you not been drinking?
I don't know. I can't say.
Okay.
If I was scared, then it would be something.
All right, now, today you testified about the time frame between the 2 videos, correct?
Yes.
So you came down from the shower where you were hiding, correct?
Yes.
And as you're coming down the stairs, before you even get to the bottom of the stairs, you can kind of see over your shoulder or towards your right that he's trying to hide in the suitcase, correct?
Yes.
And the lid is down, but it's not closed, and you can tell he's hiding in there. It's not a great hiding spot just yet, right?
Correct.
And so you come over to him and you're laughing, right? And you move the suitcase around some before zipping it shut, right?
No.
No? You immediately zip it shut?
Yes,
Okay. And you're both still laughing about it, correct?
correct.
All right. And then it's during this course of time, how quickly is it after you zip it shut that you begin filming the first video?
I don't know without watching it. I don't know.
Okay. I mean, the video is not going to catch you zipping him up because you're like 10 feet away, right? How quickly after you zip him up is it before the video starts is my question.
I don't know.
Okay. And then during that 9 minutes and 14 seconds is when he begins to get angry, correct?
What, 9 minutes?
Between the two videos, there's 9 minutes and 14 seconds between the end of 1061 and the beginning of 1062 and 1063. So you got the 2 minute, 3 second video that starts at 11:12:45, correct?
I guess.
Permission to use state 17?
You may.
All right, so we're looking at entry 31107. That indicates, according to the phone extraction, 2/23/2020, 11:12:45 p.m. Image _ 1062 movie begins being captured. And we've seen that that is about 2 minutes and 3 seconds. Entry 31113 indicates that image _ 1063.move I was disconnected. Okay. 31113, a second movie is captured at 11:23:03 p.m. Your testimony was that after that first video was captured by your phone and you, Mr. Torres began getting angry and trying to push his way out, correct?
Say it one more time, please.
Between these two movies, of which there's about 9 minutes and 14 seconds, Mr. Torres begins to get angry and try and push his way out and get out of the suitcase, correct?
He had been angry on and off throughout the entire day.
Okay. You didn't tell us that earlier. You said it was a wonderful, fun day all day, correct?
That's because I lived.
Okay. But you did not tell us earlier today that he had been angry throughout the day.
When would I say that?
You described your entire day of doing puzzles, and arts and crafts, and outside by the dartboard, and you said it was a wonderful day and everything was fun until he was in the suitcase. Did you not testify to that earlier today?
I did.
Let me refresh the witness.
My specific question.
Mr.
between these
Mr.
two
J, let me
movies
help
is
you.
This is when he begins to get angry and trying to push his way out and to get out of the suitcase, correct?
Angry again, yes.
And he was expressing his anger in what manner? How did he say this?
At which point throughout the day?
Ma'am, you know very well that I'm talking about between these movies. Please answer my question. Between these two movies, how did he express his anger with you?
Told me that I was going to fucking die.
Okay. Now this is happening after he's already told you several times he cannot breathe in the suitcase, correct?
Correct.
And he's been in there for whatever brief amount of time it took you to zip him up, and the laughter stops, and then you go over and begin to film, correct? And you're filming. Your purpose of filming is to kind of teach him a lesson. This is your chance to say something to him when he can't say anything back to you, correct?
No.
Then correct me.
That's literally what you testified to.
No lesson to be learned. It was just I wanted him to try to understand how I felt, so maybe he could progress in being a better person the next day.
That's a lesson.
So you wanted him to understand how you felt in the past, and that's not teaching a lesson?
I just wanted him to understand.
That's a lesson.
All right, and so immediately prior to zipping him up and putting him into the movie, you had been upstairs, correct?
I'm sorry?
Immediately before coming down and zipping him up and then filming the first of the two movies, you had been upstairs in the shower, correct?
Yes.
Uh-oh.
I'm going to publish what has been labeled as image_1061, which according to the timeline was captured at 11:03 p.m., 31 seconds with her device.
Please pan out, camera operator. The whole class would like to see. Thank you.
All right. Does this appear to be the suitcase that's in question in the two movies that are filmed at 11:12 and 11:23 p.m.?
Oh my God, MK, I can't with you. I'm going to have to be done with you for the day, sir. Please don't take it personal, but I'm supposed to be being serious and professional at this time, and I can hardly do that with your one-liners in the chat.
This is image 1061 taken at 11:03 p.m., 31 seconds. Does this appear to be the blue suitcase that's in the two videos that were captured at 11:12 and 11:23 p.m.?
Correct.
Did you take this image at 11:03 p.m.?
I don't remember if I did or not.
And again, we had, and by we, I mean you and Mr. Torres, two 1.5 liters bottles of wine and plus whatever was left over from the day before, correct?
Correct.
So you don't remember taking this photograph?
I don't.
Do you remember whether or not Mr. Torres was in here?
I don't remember taking the photo.
Okay. So what is your memory of what happens between 11:03 p.m. and 31 seconds when that image is captured, and then when the movie starts at 11:12:45? What do you remember?
I don't.
Do you remember anything from that night?
I do.
You told the police on February 25th, 2020, when they first showed you the video, that you didn't remember taking that. You remember that?
I do.
And your testimony is you do remember taking that video,
I do.
but you don't remember taking that photograph 9 minutes prior.
Correct.
Is there something, did you have more to drink in those 9 minutes?
I did not.
Where's Polly D? Busted big
Torres?
time.
In that suitcase the entire time between 11:03 when that image was taken and then when the second video was taken at 11:23 p.m.?
I believe so, yes.
So for 20 minutes? Yes?
However long the time frame is.
Did he begin telling you that he couldn't breathe before the video, or do you not remember?
I don't remember.
New memory. Who dis?
Now, you testified moments ago that your two neighbors must have misremembered which night the loud noise was, correct?
Yes.
And now you're telling us that you don't remember taking the photograph at 11:03 p.m., correct?
Correct.
Did the police come out to your townhouse on Sunday, February 23rd, 2020?
Yes.
I'm talking about Sunday. This is the Sunday fun day when we're going to Publix twice. Were the police out of your residence?
No.
It was the day after, Monday the 24th, correct?
Yes.
And that Monday morning, you called 911, well, Monday afternoon at about 1 p.m., correct?
Yes.
And between that time frame, you were the only person in your apartment plus Mr. Torres in the suitcase, correct?
Yes.
So if anything had been disturbed in your apartment, you had all the time that you wanted to undisturb them before calling 911, correct?
If I wanted to.
Okay.
Like I said, bingo.
And you still, your testimony is there was no loud boom that shook the walls of your townhouse at about 11 p.m. the night of February 23rd, 2020, correct?
Correct.
To the best of your memory, correct?
Correct.
Which is shaky at best, correct? See, that's why I like him with his Sunday fun day.
Now, that second video is 22 seconds where you just hear him say Sarah and you don't say anything. Are you familiar with that video, correct?
Yes.
She keeps
After
twitching
that,
her
then you go
mouth.
upstairs,
Hold on, I
correct?
don't want to interrupt him.
How quickly is it that you go upstairs?
Hang on a second. Y'all notice that she keeps twitching her mouth? She's over here trying to be like Samantha Stevens from Bewitched. What are you doing, Sarah Boone? All right, let me rewind this because this was a good conversation. Okay, here we go.
Say Sarah and you don't say anything. Are you familiar with that video, correct?
Yes.
It's after that that you go upstairs, correct?
Yes.
How quickly is it that you go upstairs after that?
It was pretty quick.
Can you grab the dogs?
No, the dogs were upstairs already.
Okay. Did you call 911 and let the police know that you had zipped somebody shut in a suitcase and they had not been able to get out for 20 minutes?
I did not.
Did you go to Brian's house and tell him, I had to zip Mr. Torres up in a suitcase shut? We need to do something about that before he passes.
I believe that's what the phone call was.
Okay. Well, what do you remember now about the phone call with Brian?
I know that I called him. I don't know specifically what it was about.
Oh my God. Hold on, you guys.
Now, your testimony, it seems like
We're not going to be able to let that go. I'm not going to be able to let that go like that didn't just get said. Let's rewind. All right, you ready? Okay, let's go. I want to hear this again.
Can you grab the dogs?
No, the dogs were upstairs already.
Okay. Did you call 911 and let the police know that you had zipped somebody shut in a suitcase and they had not been able to get out for 20 minutes?
I did not.
Did you go to Brian's house and tell him, I had to zip Mr. Torres up in a suitcase shut? We need to do something about that before he passes.
I believe that's what the phone call was.
Okay.
I believe that's what the phone call was. OMG. So his question was, did you go to Brian's house and say, I've zipped George in the suitcase. We need to do something before he, hold on, let me make sure. Let's listen to this again.
I had to zip Mr. Torres up in a suitcase shut. we need to do something about that before he passes.
I believe that's what the phone call was.
Okay. Well, what do you remember now about the phone call with
Huh.
Brian?
Okay.
I know that I called him. I don't know specifically what it was about.
Now, your testimony, it seems like you spend day after day finding things to entertain Mr. Torres to do, correct?
Yes,
Almost like having a child. You have your own child, correct?
I do.
What you described sounded like having a small child. Would you agree?
That's your interpretation.
Well, you take him from doing arts and crafts to doing puzzles, so on and so forth, correct?
When he's been drinking, yes.
And Mr. Torres was notorious for doing some of these things, correct?
What do you mean?
Well, you described Mr. Torres as being notoriously known for doing things. You described your ex-husband, Brian Boone, notorious for doing things like nagging and calling all the time. You remember your testimony calling people notorious for doing things?
Yes.
What would you say people would say you're notorious for?
Zipping people in suitcases.
And you would not answer Brian Boone, your ex-husband's phone calls, just so that you could let him know that you're busy and you have things going on, correct?
I knew that at whatever time it was that he was calling me, that he could wait for the few moments of me getting up to where Lucas gets out of school at 3 o'clock.
Okay. But you wouldn't return his call. You would let him call several times, correct?
That day, yes.
Okay. How about other days? Would he have to call to remind you to get Lucas on other days?
He wasn't reminding me, he was just making sure that Lucas was covered for a pickup or drop off.
All right. You didn't mention to the sheriff's office,
Just really quickly, I'd like to state for the record that at no time ever in the history of me being a mom, which would go back all the way to 1995, has anybody, my husband, anybody from my family, strangers on the street, ever had to call just to make sure that I was going to pick up the children that day from school or any other place they might have been. Just want to let the record reflect.
either
Making sure that Lucas was covered for a pickup or drop off.
All right. You didn't mention to the sheriff's office either February 24th or February 25th about going to Publix with Mr. Torres at noon or 12:17, did you?
I don't recall.
So the best evidence of that would be the recording of those interviews?
Correct.
Did you not remember going to Publix with Mr. Torres that day?
At what point?
At any point?
No, I didn't.
You had indicated to the police that it was about 4 p.m. that you all had started drinking after doing chores. Do you recall that?
I do.
And your testimony today was that it was really more after you guys went to Publix at about 12:17 p.m., correct?
Yes.
And you did not tell the truth to the police, correct?
I'm sorry, I didn't hear the question.
You did not tell the truth to the police about that, correct?
I did not.
And when they were asking you about Mr. Torres's injuries, you told them that you had nothing to do with it, correct?
Yes.
And that was not the truth.
Correct.
What did y'all have for breakfast on the 23rd?
I don't remember.
Did y'all have lunch?
I believe we had leftovers from, I think, something that we had in the fridge.
And do you recall what those were?
Not at this point, no.
And then I believe you mentioned having a sandwich of some sort for dinner.
No, I believe it was for, I'm guessing he and I ate at the same time.
Objection, non-responsive. What the frack?
And at one point, Mr. Torres called his brother Juan, correct? And do you admit that you were yelling in the background, telling Mr. Torres to tell his brother that he had been choking you?
I don't know if I was yelling. I know that he could hear me through the phone.
So how long had that been going on that day? When did you start getting on Mr. Torres about choking you in the past?
He and I had conversations about it because he didn't remember doing it to me. And the next day and the day of.
Is it fair to say that there are just points in time where you don't remember what you do either, correct?
Are you talking about almost 5 years ago?
I'm talking about from drinking. Is it fair to say that you don't often remember things that you did while you were drinking?
I would not say often.
Okay. In the course of your relationship with Mr. Torres, are there things you don't remember happening that happened the night before between you and him?
I can't say that at this point.
But you said that you don't remember taking that photograph at 11:03 p.m. on February 23rd, correct?
Yes.
Was there anything else that you were telling Mr. Torres that he needed to tell his brother?
Not that I can recall.
Was there anything you were telling him that he needed to tell his daughters?
Not that I can recall.
The smile has dissipated, the smirk has dissipated, and it has now been replaced by the twitch of her mouth
Now, you
with her
indicated that
nose.
Mr. Torres would use your phone to look at pornography.
Correct.
Were there ever any points in times when it was you that was used looking at pornography?
If I was, it was to go back and look to see.
Yes, Notorious Nance, they can bring in
Did you ever
evidence during
threaten
cross.
to get Mr. Torres arrested if he did not do what you wanted him to do?
Oh, and here it comes now.
I wouldn't say threatened.
Okay. Well, were there ever points in times where you would like him to call you or return a call? And if he didn't do that, you would threaten to get him arrested?
It depends on if he had my keys or something that I needed from him.
And it was your townhouse, correct?
Mine, yes. Flush hours.
Well, when did you get him off the lease?
I'm not sure what year it was, but I don't think he was actually removed from the lease.
Okay.
I think he was made a different type of tenant.
And did you change the locks so that he couldn't get back in at the points in times when you kicked him out?
I did sometimes.
And then would you leave the key in the hiding spot that he was aware of?
There were multiple hiding places.
Did you use one of
Any
them?
of the 911 calls, did you ever mention that Mr. Torres was aware of where you kept your keys and that's how he got back into the house?
I didn't know I needed to. He would never break into my home.
Right, because you left the key.
All right, and it's your testimony that you did not push him down the stairs, correct?
Yes.
And in fact, it was him that dragged you down the stairs the night before, correct?
Yes.
Now, by dragged, did you leave your feet?
Yes.
And did you get scrapes on your knees or anywhere from the carpet?
I'm not sure.
Did you get any injuries, like bruises or abrasions or scrapes?
I was missing A lot of my hair, yes, that was on the stairwell.
And you agree that you were photographed on February 24th when the police came out, correct?
The day of the incident?
Well, the afternoon after the incident. We're not sure when he passed.
Yes.
Some of those photographs showed ashtrays inside your house. I thought you said you guys couldn't smoke inside your house,
We couldn't.
but you did, right?
Sometimes, yes.
And you agree you would go to the hospital and tell them things that were not true, correct?
Yes.
There were times where you would go to the hospital and leave without getting treatment, correct?
Yes.
And is it fair to say that you often had alcohol in your system when you were going to the hospital, correct?
Sometimes.
All right, so just to summarize the day to make sure we understand it. You all wake up sometime in the morning, but it's an unknown time, correct? On February 23rd.
Or early afternoon. Yes, I had a problem with the detectives and them having me guesstimate times.
Okay. Are you the kind of person like most of us that uses your phone when you wake up?
No.
So the first activity on your phone may have nothing to do with when you woke up. Is that fair for you?
Yes, other than looking at the time possibly.
Okay. So at some point you wake up, it doesn't sound like you have breakfast, correct?
Correct.
You do some chores, correct?
Yes.
So that is true. That part of it is true. You did do chores before going to Publix at 12:17?
Yes.
All right. After chores, you go to Publix and you get that 1.5 liter Magnum bottle of Woodbridge Chardonnay, correct?
I'm not sure what Magnum is.
1.5 liters. Instead of the 750s, it's the double size. It's like 2 bottles of wine.
Okay, yes.
So you got a 1.5 liter, right?
Yes, it is the larger bottle.
And you got home and you at 100 pounds and Mr. Torres at 103 pounds began drinking this wine, correct?
I'm guessing so. I'm not going to guess times.
Well, don't guess. I mean, you got home from Publix. When was your first drink?
I'm not sure. I mean, we could have continued to do whatever was left over from what we didn't do before we went to Publix.
Okay. So you may have started drinking even later, correct?
And
12:30 when you get back from Publix?
I don't know.
Okay. Was it 1:30 or 2:30 when you began drinking?
I don't know.
Was it before any of the phone calls to the brothers and his daughters?
Yes.
And so you drink what's left in the bottle of wine from the day before that's halfway labeled, correct?
At some point.
And then you drink 1.5 liters of wine and he goes out and gets another one on his own without your permission or suggestion about 5:30, correct?
Correct.
And then you all consume that one as well and it ends up in the trash can at the end of the night, correct?
Apparently.
Okay. At what point in the night does your memory tape stop? You've described that it wasn't on at 11:03 p.m. when that photograph was taken. What's the last thing you actually do remember prior to these videos being made?
I don't recall it at this point. I don't remember.
All right, and so it ends in hide and seek after arts and puzzles, correct? He says, tag, you're it, but you run and go upstairs and hide, right?
Yes.
So does that mean he's it and he's supposed to come find you?
No.
Okay. So you both hide?
No.
Okay. How does this work?
I don't know how to tell you.
Okay.
I was it and I went and hid.
I mean, my understanding of the rules of hide and seek is one person will be it, cover his or her eyes and count to like 20 and then go find the person that's hiding. Is that your familiarity with the rules too, or do you guys have house rules?
I understand how the
Okay.
game of hide and seek
So
works.
explain to me, what was your expectation? You go up to the shower. Were you expecting him to come find you?
I was.
Okay. And after a while, he did not come find you.
Yes.
And that's when you return downstairs.
Correct.
And because of the way your townhouse is set up, you can kind of see over where the suitcase is and that he's trying to hide in there, but it's not successfully hidden just yet.
I mean, yes, you have to come down a good ways in order to be able to
Right.
do that.
But you saw, you testified that was before you got to the bottom.
Yes.
All right.
Mr. J's
Then you
getting a
come over
handwritten
there
note from your
and
girl
thinking that
saying
it's
thank
funny,
you.
You zip them shut, correct?
Yes, we both thought it was funny.
Okay. And the defendant standing down?
Entered into the well?
Yes.
Yes. Deputy, we release her into the well, please.
All right. Ms. Boone, can you demonstrate for the jury where Mr. Torres' head was and how his body was positioned in the suitcase, if you don't mind?
His back was this way and his head was here.
All right, and then is it fair to say his feet are kind of down here, which would be the front left corner from their perspective in the jury box?
Yes.
And then his knees are kind of tucked up towards his face.
If I remember correctly, yes, that's the position.
Okay. All right. Can you help me understand how it was that you zipped it shut? Can you show us where you say you left an opening that his hand got out of?
Would it be easier to put it down here?
I didn't want to make you go down there. If you're happy doing that, I'll let you.
Hold up. Does she need to be wearing gloves?
Yes.
Agreed. If she's going to be manipulating it.
What do you want her to do?
Just demonstrate how she zipped it shut.
Okay, well, where's the paper clip? And do you remember which one it was in?
This side.
Just the paper clip was on when this event occurred. When we pulled the suitcase out earlier, the paper clip was not attached. So now the prosecutors attached the paper clip. We don't know if that's the way it was attached.
It's not even a paper clip.
We
Okay.
don't know if that's the proper way that it was attached, but he's asking her now to pull
Is there an objection?
Yes?
Approach.
Bull, seriously? Objecting about the paperclip? Is that what's happening here? Oh my gosh. I'll tell you what. Let's not have this argument. Get the photograph, put it up there with the overhead projector, and affix the paperclip in the manner in which it is displayed in the photograph. Okay? When in actuality, he could have probably affixed the paperclip that actually makes it easier. Whatever. This is ridiculous. Absolutely ridiculous. Let me see if we're live. Let's. Hold on.
This side.
Owens, move, bro. You're obstructing the view of the audience, and now you're adjusting your pants. I'm done with you, Owens. There you go. Thank you. Get out the way. Oh, I see what's happening with the outfit of the day. Sarah's wearing a blue dress.
Was on when this event occurred. When we pulled the suitcase out earlier, the paper.
Oh God, I rewound too far.
So now the.
We see how, Madam Clerk, are you ready? Can we see how it was that the two zipper parts were positioned when you say that Mr. Torres was able to get his hand out? If you want me to do it, I'm fine to take your direction.
From what I remember, this is how the suitcase. This is how the suitcase was. This was up here. This was not this hard either.
Oh, you suddenly remember now?
This was like here.
Okay.
Right here.
What do you need gloves?
Oh, right there, ma'am?
Sit down, Owens. This ain't your time.
I assume this one was much closer. It's not over there? Where did you?
You asked me where I zipped it.
When you say that was zipped shut, show us.
Are you talking about how I zipped it or?
Yes.
You're done zipping it shut and he's inside of it. Where are the zipper components?
Oh my gosh, please lean down and bang your head on that podium, Mr. Owens, for the audience. We demand it at this point.
Just tell me what it's at.
I mean, it was the corner. I mean, the corner was kind of open. I mean, it's not. Yes, this one was already pretty much, yes. From what I can remember. That's how he was coming with his hand out. It was like this from the corner part.
Okay.
What are you doing?
Thank you. You can return to your seat. Did you ever change the position of those zippers once you put it in that position?
I did not.
Fantastic. Thank you.
And so once he was zipped into there, there's some amount of time, but you don't remember specifically before you start taking the 2-minute video, correct?
Okay. I think why they were helping is because the purpose of this demonstration was not to show how hard it was to zip or unzip the suitcase. I think that everybody understands how suitcases and zippers in general work, and that if you're laying on your side, basically in the fetal position, it would be very difficult for you to get your hands out in the first place. What they're trying to ascertain is how much room did she actually give George to get his hands out? That's number one. And did she at any time zip it up more or zip it up less, which she said that she didn't. Okay, that was the point.
Yes.
And then that's when you say what you say, and that's when he says what he says. We've all heard it, correct? And then between there and that second video of the 22 seconds length, it's at this point where he's beginning to get angry. And then that's when you take the baseball bat that's in evidence, and your testimony is you start poking him with the end of it.
Did you say this was the second video?
Between the two videos, that's when you started hitting with the bat because he was getting angry and trying to escape, correct?
It's your story.
Right, I was not hitting him. I was, yes.
Poking him.
Did you
Poking
ever
him.
hit him with the bat while he was outside of the suitcase?
No.
So each time that he is hit with the bat, it's through this suitcase.
She's not a big girl.
The marks on him because you didn't hit him with the bat outside of the suitcase, correct?
Yes, but may I demonstrate?
Oh,
No, that's okay.
fantastic.
The suitcase will speak for itself. And then you take the second video and you go upstairs and go to bed, correct?
I apparently went upstairs and I used the phone to make a phone call.
Okay.
And then I fell asleep.
Passed out, fell
And at the
asleep.
point in time when you left and went upstairs, he was still inside the suitcase, correct?
Correct.
Was he still asking for you and calling your name?
Not that I can recall.
Did you say shh to him again?
I don't remember.
Did you tell him that this was his problem and it's on you again?
I don't remember.
Did you do anything to help him escape from the predicament that you zipped him up in?
No.
No other questions.
That's it?
A redirect examination.
Huh.
Ms. Boone, he just asked you the question that you poked him and you didn't poke it. You poked, every time you poked him hard with the bat, he was inside the briefcase,
The suitcase, yes.
the suitcase. But you remember when he put his hand out, did you not hit him in the hand outside the suitcase?
Yes.
Okay. So that was the only time the bat touched Mr. Torres's body outside the suitcase.
Yes.
How did
when you
he
hit him with
get
a hand.
bruises on his
But
head?
all the other injuries were with you poking him pretty hard. I mean, you bruised your hand, correct? Doing that.
Mm,
That's all.
Ma'am, you can return to council's table.
Judge, can we approach you?
Just a
Oh
moment.
my God.
Let me get her situated at table, and then we can approach.
What?
All right, come on up, y'all.
What do you guys think? Don't lie to that girl and tell her she did a good job. She didn't. Don't tell her. I will say this. I do have some nice, not nice, probably. I will, it's hard for my soul. She didn't lose her temper. No, he's not, May. I mean, I thought he got her to admit that the only thing essentially that she remembers from that night are puzzles, arts and crafts, music, a good day, and the 11 minutes that took place between both of the videos. Everything else is an absolute blur. I thought she would lose it too, Chloe Jade. I did. And she didn't. Un momentito. Did you do just what I think you just did? Watch her. Mm-mm-mm. I believe the state is going to have some issues tomorrow, first thing, with some of this. I don't know I don't know who she wrote the note to, because it would appear, I'll know better when the camera pans out and they come and sit down. But frequently, the assistants, which I know, she's definitely not up there. Hold on.
All right, members of the jury, thank you so much. It is 5:42. At this point in time, the court's going to go into recess for the evening. I thank you again for your continued service and your attention in this matter. We're going to start tomorrow again at 9 a.m. here in 12 Alpha at the Orange County Courthouse. I'll read you another instruction. I know you've heard it. I'm sure you're sick of it, but I got to keep reading it. So thank you. Jurors, you must not conduct any investigation on your own. This includes reading.
I mean, it's conceivable that she passed it to her attorney. I don't know, to the ladies that sit directly behind her. But I have a feeling that the state is going to review some of this footage from tomorrow, and there are going to be some issues. Specifically, Sarah speaking, when they took that recess and Sarah was off the stand and the judge was deciding whether or not she could use the battered spouse defense, she was still under oath and wasn't supposed to discuss her testimony. But let's see.
Agreement now. We just wanted to get it on the record.
Understood. All right,
Hold
so
on
ma'am,
a
I just got
minute.
a couple follow-up related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, I'm going to excuse you for the balance of the evening, and thank you so much.
However, jurors, once you've, hold on, let me push pause. However, jurors, you won't see this now, but maybe after your jury service, should you feel the need or want to discuss your jury service after you've deliberated and delivered your verdict, call me. I think that
Thank you.
rebuttal will be something different, especially after the
With regard to these medical records, the court previously today had required.
Hold on. I think that once we hear what Sarah's expert witnesses testify to, I think a lot of that is I think the rebuttal is gonna hinge a lot on that. And I mean, Sarah didn't do terribly on the stand, but Mr. J getting her to admit she remembers nothing, but we're supposed to believe that she remembers those 11 minutes with perfect clarity. I think it was enough, and she did change her story a couple times. So let's continue.
By 5 p.m. to address those. Unfortunately, they have not yet been addressed. It is imperative that the state knows what it is we're culling down or redacting. And I understand that you may want to be seeking those into evidence maybe tomorrow. And the state needs to be advised as to what it is that you're seeking to utilize. So where are we in figuring that out?
Can I have 1 minute with the client?
Yes, sir.
Okay. So Tracy says that Sarah testified that she went upstairs with the phone and fell asleep, but the phone was downstairs in the morning. I am exhausted. I believe you. I do think there was a discrepancy there. I will go back tomorrow morning and search the transcript for that part so that I can play it for you guys, both timestamps, what she testified on direct and then what she testified to on cross, and we'll see. I will tell you this. I saw a couple of comments in the chat earlier today.
We've had discussions with Ms. Boone.
Regarding George and the benzos, because there was a syringe containing diazepam found in the suitcase with him. I read over his talk screen last night, his toxicology results last night on the last live, and George tested negative for benzodiazepam, so of any kind. So it's unlikely that Sarah, he didn't give him that diazepam. He didn't take it, and she didn't give it to him. There were no diazepams in his system.
And she claims that every time that he went to the hospital and the medical records would show that it was in relation to some type of domestic violence involving her, we've expressed to her that we do not wish to pursue it and introduce those records of George Torres, of his medical records of the different times he went as it relates to their difficulties. Do you understand that?
Okay. Ma'am, earlier we had discussed, anything else to add to that, Mr. Owens?
Just that I've explained to her that the lawyers make those decisions.
Okay.
And I believe she's in agreement now. We just wanted to get it on the record.
Understood. All right. So, ma'am, I just got a couple follow-up questions.
Me too.
Similar to other conversations we've had over the last couple of days. I don't want to know about the specifics of any conversations you've had with you and your attorneys, just whether or not you've had them. You recall earlier today, I'd asked you questions about certain rights that you had the ability to decide. Do you recall that conversation that we had, ma'am? It was before you testified. Okay. Do you recall that I advised you that the lawyers get to make most of the strategy determinations at trial? Do you recall that?
I do.
And do you recall that you said you understood that?
Yes,
And do you also recall that I advised you of certain rights that you have? Do you recall that?
I do.
And one of those rights was the right to testify or remain silent. Do Did you recall that? And did you understand that? So this decision is a trial decision as to whether or not there's certain evidence that your lawyers are going to seek to utilize in your defense. Do you understand that?
Yes.
Do you understand that they are exercising that trial strategy at this time not to pursue those medical records? Okay. Do you have any questions about that?
I don't.
Are you on board with that strategy?
I am.
Are you still on board with the strategy utilized in your defense?
All of it, yes.
Are you satisfied with your lawyer's representation of you in this matter?
Yes.
All right. Thank you. State, anything else we need to address before we
My
retire
understanding,
for the evening?
sorry,
That's okay.
my understanding is the last civilian witness they intend on calling is arriving at MCO at 9:03 in the morning tomorrow.
It was either 9:03 or 9:05, yes.
And plan will be to depose her in the evening at 5:30.
Okay.
Then, just scheduling purposes, we're trying to figure out when we would need our rebuttal expert, Dr. Werner, to appear.
I know Mr. Owens had said they were endeavoring to finish by Friday, but I don't know if Dr. Harper's availability issues for tomorrow is going to change that anticipated
Yes, those are airplane times.
time frame.
I'll try to reach out to her by text. That's usually how we communicate. But
Well, assuming she testifies on Thursday, are you still in a position to rest on Friday, or would that kick us to the next week, sir?
well, no, I want to finish this week if at all possible. If I'm hoping that Dr. Harper could be here tomorrow when Dr. Brandon is here, but let's just say she's tied up in Baytown.
Let's do worst case scenario.
Okay. She's here Thursday morning. I think we would try to finish our case right then and give the state a chance to rebut. I would say Thursday. I would have.
Okay, my understanding is our expert can't be here in the afternoon on Thursday. I'm gonna have to check her availability for Friday.
If you would be so kind, and we can address that tomorrow morning.
Thank you.
Okay, anything else, state?
Not-
Anything else from the defense? All right, the court will be in recess till, yes, sir.
I'm sorry, just to give everybody some scheduling, this might help everyone with schedule. There are going to be 2 officers here in the morning who are going to be ready to testify. There will also be some other witnesses, officers, like the detective who testified that I need to call back because of some impeachment issues of one of the witnesses. And then we'll get into everybody else's witnesses stuff. There's about 3 or 4 that I have in the morning time that we'll be proceeding on. Then we'll go from there.
Okay, all right, appreciate the lay of the land. All right, we will see you all. That's what, one more, Mr. Owens. Yes, sir.
That's flying in from New Jersey, I think, is Wednesday at 9 a.m.
Check your underwear.
She's scheduled to fly out Thursday at 9 a.m. So if there's any way we could depose her, maybe in the morning or at lunch, and then have her testify Wednesday afternoon.
That's an unreasonable demand on time, given everything I've been doing to make sure that we can get this pushed through. I need to do things like get ready for expert cross-examinations and other things need to get accomplished at lunchtime. Happy to do it in the evening. My understanding that she was supposed to be coming in today so that we could do it tonight, and that didn't happen.
Oh, dear.
But I don't think I should be forced to accommodate a lunchtime deposition.
Anything further?
I'm just telling you what the plans were.
Deposition will be at, 5:30 tomorrow, or at any other, if we got to have it later, depending on how we go. We'll address it at that time. All right, thank you both very much. We will see you tomorrow morning at 9 a.m. Court's in recess.
All right, that's that. Excuse me. Sorry, you guys. I think all in all, her defense, her testimony today, I think she was led a lot during her direct, which usually is not allowed. Typically, you would object to that. However, some of the answers were so poor that I feel like all in all, I would put the odds now at 70-30. 70 for a conviction, 30 for an acquittal right now, as it stands. I think that those images of Sarah's injuries probably had an impact and an effect on the jury because they did me. But I also think that there is more to this rebuttal case. And I think that we should, I will reserve final judgment, obviously, until all of the evidence comes in. Mr. Henderson has alluded to calling back, I think he's referring to Detective Kepsel, as she's the only one who testified that would be recalled because there's some impeachment. I think the impeachment that he is attempting might be around the conversation with the apartment maintenance manager. There's no way to, it can't be around the phone call between Kepsel and Boone with regard to her coming to the station, because if they had concrete evidence of the phone conversation and that Sarah was told that she could have her phone back, I think that that would have been submitted already. That would have been in evidence. So Carolina says, yeah, I'm not wrong. The civilian witness is the lady who did that TV interview. Mr. Owens makes Sarah be at ease. That's why he went into the well at the demonstration, in my opinion. So he definitely needs to be able to see what's going on there, right? Because it's his client and he would need to raise objections. But what he shouldn't have done was interfered. It was not his witness. And he should have just stood there as an observer and not intervene. That's just my opinion. So, okay, Jojo. The whole deal with the medical records is this. Mr. Owens never wanted to use George's medical records, and here's why. Because all of those times that George got treatment were the result of an altercation between Sarah and himself. I know that it was a fight with his brother that caused George to end up having to have facial reconstructive surgery. However, if I understand the situation correctly, the reason that happened is because George had been physical with Sarah and his brother was angry and retaliated, is the way that I understand. So I think that but Sarah and him, let me think about that a minute. If the way that he said it was that those medical records are all a result of altercations and incidents that he had with Sarah Boone. Not that she caused him to need facial reconstructive surgery, or that she put his fist through a plate glass window, but she was in the mix there somehow, some way. Okay. And so it doesn't actually look good on Sarah. And I think what they were doing was attempting to appease Sarah by trying to get them in because she deemed them important. And which is why they failed to meet their deadline, frankly. And I think that Mr. J was just tough enough with her, right? He took it just to that line where it was a little snarky, but not confrontational, not argumentative. Because we know what that looks like from other trials and other attorneys. He took it right to that line. And I think he did a good job with her. But I think that I'm very interested in the coming testimony that's going to come from Sarah's expert witnesses. Those to me are very important. And yes, this is quite possible. Sunday Doodle says, Bendy, could he have gone a bit light so he didn't alienate any juror with domestic violence experience or knowledge? Absolutely. See, it's a fine line, okay? You want to press the witness on cross-exam, especially because in this case, so much of this case, right, really hinges on what Sarah experienced that night, right? So, you want to, he got her to admit that she really didn't remember anything, that her memory is like Swiss cheese, is full of holes, right? And so I think he did the right thing. I think he handled Sarah correctly. Okay. I do believe that I can't imagine a scenario where he wouldn't. I do think the jury needs to see that video from Sarah's phone. This is one thing I don't understand. There's two videos I want to see from Sarah's phone. One is the video where she's coaching George to get the charges against her dropped. And two, I'd like to see the video surrounding the TV incident, the television. And the reason I say that is because if you have a video where the victim is being violent and destructive, particularly with a baseball bat, right? The same bat that Sarah used against him later, I would want to see the video of that, right? What I suspect the issue is, and I think it's a fine line, and this is why I'm not sure if the state will end up using it, but I suspect Sarah's the one that took that video, and I'm I have a sneaking suspicion there's audio on that video of Sarah, and she might be saying things that are the same tenor as she was saying in the suitcase video. I don't think that she was back there just being silent. I mean, when have you ever known Sarah to remain silent? So I'm really, really, I really want to see what's on that video. I'm really interested in why this is a video that was that the defense and the state both have. The defense got it through discovery. So if there, I don't, there's the only reason I can think that they wouldn't want to present that video is because it doesn't show Sarah being afraid of George. It probably shows Sarah in the back, drunker than Cooter Brown, in the background, hollering and talking smack. That's what I think. We'll see. I do think that those pictures are impactful. Okay. But I also think that video is equally as impactful, the suitcase video. And while the jury might understand why she's angry with George, at the end of the day, she should have let him out of that video and out of that suitcase. And that video doesn't show fear, it shows anger, which is something very different than what she described, right? She said she did what she did with the bat out of fear, right? Out of terror. She doesn't sound like she's in fear, and she doesn't sound like she's in terror in that video. And I think that that is the big difference. Oh, thank you, Midnight Dragonfly, for becoming a member. Thank you very much for supporting the channel and me. I appreciate that very much. Thank you. I think that while those pictures paint a picture, obviously they're evidence. They tell a story. I think those suitcase videos tell a story as well. I do. You know, I wondered if the whole deal with the TV was that Brian bought it. And perhaps Sarah took the video because they were drunk and Brian wouldn't acquiesce to some favor or something that Sarah asked for. And George busted up the TV with Sarah's encouragement. That's what I wondered. I thought it might be a petty moment. Honestly, that's what I thought. And I think that while Sarah didn't lose her cool on the stand, she did not come across with emotion. She came across in very flat. She has a very flat affect. And I don't remember whose TV it was, honestly. But I'm sure, I mean, if George wanted to break his own TV, then what's the big deal? See, that's what makes me wonder why they didn't play that video. We're missing a huge part of it. And I can't help, I wonder what the jury is thinking after hearing the suitcase belonged to George, had George's documents in it, had George's clothes in it, or items of George's clothes, right? And George, and a syringe, not an empty syringe. Who does that? If they're using that suitcase to collect items to give away, they were intending, it wasn't just like they were using the suitcase to hold the clothes or the items, right? They were intending to give it all away. They were going to take the suitcase and put it in the donation boxes. There's big metal boxes or, you know, things out, like, they're not boxes. I don't know what they're called, but you know what I'm talking about. You've seen them where you can donate clothes. They were intending to put it there. That's where they were not intending to keep the suitcase. So who would do that? First of all, it's a school. You're going to give, you're going to donate a suitcase with a syringe full of diazepam. You're going to put that in a donation box at school, even though it's outside of the school. You know, like, it doesn't make sense. And I'm wondering if the jury is putting that together. And I hope that they show the older body cam footages from the prior incidents between George and Sarah, because again, Sarah doesn't come across as sad that she was hurt or scared. She comes across as angry, which, to be fair, I'm a person who is far more comfortable showing anger than I am showing sadness. But I don't know. I don't know yet. Anyway. All right, you guys, I've been on for 9.5 hours. I'm sure you're tired of hearing my voice. And you need a break from me. So I'm going to let you guys go. But before I do, I want to thank everybody for being here. I want to welcome everyone who became a member. And I want to do something I haven't done in a while, just because I think that we need it. I haven't played the outro in a while, and we do need a little levity at the end of this day. So here you go. I want to, again, thank you guys all for being here. Thank you to the mods. Thank you to the chat. Welcome to the new members. We will be back here bright and early at 8:30 tomorrow morning to go over all the latest, and then hear tomorrow's testimony. And also, would you do me a favor, please, and give your girl a thumbs up on the stream. I would appreciate it. It keeps me in the algorithm. It gets my video suggested to people who don't know anything about the ward. And it's always nice to make new friends, right? So give me a thumbs up, would you? I'd appreciate it. All right, you guys, I will see you later. Have a great rest of your day, and I will see you all tomorrow. Bye.
Cause it's Friday, you ain't got no job, and you ain't got shit to do. Well, fuck you.
No malicious intent or effort was towards it.
No malicious. Finish her.
Minutes later.
We all do a little mad sometimes.